Someone make it make sense.
Probably a couple.
Hello, my squirrel friends. Hope you all are having a wonderful day and night and morning and weekend and whatever it is, wherever you are, squirrels of the world. So, we are here with another Ezra, episode 3. Y'all, let me play my intro video here. I'm super excited. It has been so incredible to put these videos together with this trial, because all I can think about is, oh my God, if only the world knew what they were missing. This trial is so interesting. And this episode is so interesting. We are going to delve way deep into the crime scene. It is full of fucking surprises, guys. Full of surprises. And one thing I'm super excited about is there's 2 different kind of extended housekeeping sessions, as it were, like we see in most trials, where they meet before the court starts, and then, maybe after lunch, and then maybe the end of the day, and they discuss things on the record with outside the presence of the jury, right? And we are going to get to hear some really good lawyering. I can't even tell you how, oh man, it scratches every itch of the brain. Like some of the arguing, I say arguing, right, in the legal sense, going back and forth, where it's like, yep, no, that makes sense. That they're right. And then you hear the other side, you're like, oh, but, wow, that also makes sense. It is some good stuff. And it's all, they're all so, I'll tell you what, man, here's what it is. Here's what you guys, I think, will see is really good lawyering on both sides. And, I know it's one thing to have an opinion about the style of attorneys when they're questioning a witness. That's totally fair. That's totally normal. But that's just one element, right, of an attorney's job. I'll tell you what, especially the female attorney for Ezra on the defense, right? And, they're court appointed. Dude, she is a fucking force arguing. I can't wait for you guys to see this. It's really something else. And she knows her case law backwards, forwards, inside out without looking it up. And you know what? She was a practicing attorney on several of the cases that she cites. It's wild, y'all. I think she might actually be kind of like a legend, but I just didn't know that because I don't live in Wisconsin. Shout out to Super Planner Girl. Shout out to Iowa, Backyard Cam. Happy to see you guys. So we're going to get to see some really good lawyering. It is really, and it's all of it's above board. There's nothing yet, right? Yet. There's nothing unethical. There's nothing that's going to give you that icky feeling. It's like really intellectual. And they're arguing about some really important things about, like, a lot of this stuff is pretty novel in terms of, like, Alex's journals are a big part of this trial, right? And there's a whole host of things that it's like, 404, 403 and 404 evidence, right? Like we know about from other trials, including Murdaugh, and, just a lot of stuff. So this episode is really dynamic because we're going to get to know the crime scene even more. We're going to hear from some of the friends that were friends with both Alex and Ezra that were really close to them, and what their impressions were of what was going on. It's going to be probably difficult at times, but it's important. And we're going to get to hear some really good arguing from the attorneys with a couple different housekeeping sessions. And this is only the second day of trial. And they're already getting into, every time, catches me by surprise, they're already getting into really the main issues, man. I'll tell you what, like a lot of trials, day 2, it's still just kind of like, getting exhibits in, or like, whatever. I mean, if it's Karen Reed, it's just like literally nothing. But here it's like day 2, and it's like, I'm not skipping anything, right? I mean, especially because, again, this has not been on YouTube. I'm not skipping anything. I'm not skipping a single sentence of testimony or arguing or anything. Only silence. That's it. Just silence if nothing's happening. But luckily on the Court TV archives, they cut a lot of that out ahead of time for you. So it's really, and what I find is like, they just don't waste any time. This is just, they're right in. It's really incredible. I just have a lot of respect for these attorneys. And anyway, so, okay, so we've got, I have a lot planned for this episode, guys. So what we're going to do is, let me pull this up. So for anyone who was here last time or watching on Replay Crew, one of the things I was talking about that I thought would be really important is to really figure out for sure who was driving, if there's a way to know that. Because as we are looking at these pictures of the crime scene, right, with where the car was placed, were any other of you guys who were watching on Replay Crew, were y'all surprised at where the car was? I mean, we were very surprised, those of us here in real time, because it was not at all what you thought. Like where the car was versus the mud, it was really like, huh. And then the angle, and then where it was like in relation to the tree line, it was all very, like, I don't know, it was really crazy. And then of course we also went and saw what it looks like in real life. And so, you know, one of the questions I had was like, how and why, okay, why would someone go down this road, right? Like, I don't mean metaphorically, I mean literally. Why would they turn onto that road? And like, how would you convince someone that they should go down that road? And like, what was the game plan, even if it was a fake game plan, right? Like if you're trying to tell someone, oh, here's what we're going to do. Like, how would you even make this look like it's okay? And then like, and then why the hell, how did the car end up the way it did? And the reason I ask that is because, you know, it doesn't seem natural. Like it almost looks to me like potentially they were going down that road and then maybe a struggle was starting to ensue or something. And that is why the car went off the road. And the other thing that's weird that doesn't make any sense is the whole thing about being stuck in the mud. Okay, well, yeah. The thing is that the mud is the road and they drove into the grass off the road, which is into the grass. And, you know, we saw in that one picture, like you can see that there's some mud, but it doesn't look honestly like enough mud to where they would have been stuck. And the other thing we heard from one of the officers was that where the grass was, that area was actually more frozen solid and was colder than the dirt road part, which was not under any trees. And that would have actually been easier to drive on. So in other words, it would make sense if they were stuck at all. It would almost make more sense if they were stuck while they were on the dirt road. But then if that's the case, how did they get into the grass? And then if getting into the grass got them unstuck, then why were they still there? Like the whole thing with from what we heard in opening statements, right? From what we heard in opening statements, the defense attorney was telling Ezra's story, right? Which is going to be backed up by her taking the stand. And the story essentially is like, the reason it's like the explanation for the car being where it is two things. The reason it's in that area at all is because they were going to go talk at a nature location, quote unquote, right? And then the reason it was stuck in that weird angle where it was in this weird location is because they were stuck in the mud. But none of that makes any sense. Like, if for example, the dirt road was actually covered in ice, and then instead of the grassy area, there was no grass and it was a mud pit. And then you could say, well, they were driving along, then they slid on the ice and slid off the road, which was covered in ice, and into the dirt mud pit. And then they were stuck. That would make sense, right? Like that would make logical sense. Anyway, it's so, okay. So, and shout out to Candace and Random Girl. So for those of you who were here, but one of the questions I was asking is who was driving, and that's why, because there's a lot of questions, right? And another question that I have is, how did Alex end up in the back seat? That's another one. What happened with everybody's shoes? Okay, there's that. And then But who was driving is really important, because again, I have to wonder if what happened to explain why the car is like that is that there was a struggle. For example, Ezra started maybe stabbing him or something, right? And then that's how the car veered off. And that the whole thing about getting stuck in the mud was her story, right? Try to explain it. That would make complete sense, because it's not adding up so far to me. So, thus began the idea for What the Muck, in lieu of What the Truck. Shout out to What the Truck. And also Hipster Business in lieu of Chicken Business. So, so What the Muck is going to be dealing with anything related to who was driving, what happened to the fucking car, shit like that, right? Car shit. Just like What the Truck. And then Hipster Business is going to be like Chicken Business, where it's like everything else that's kind of like, you know, not related to the cars, but just like what the fuck's happening. Random Girl asked a great question. Was there blood in the front seat area? Random Girl, we will find that out today. Today is the day. You're here where you need to be, because the first witness we're going to hear from is the one who tested all that. It's inside the car and did the blood, the DNA, and all that. So we're going to get to that very, very soon. That's the first witness. So, because the previous witness in terms of the forensics was great. He was awesome, Mr. DeVries, and he was the one who did the 3D scanner and really gave us, for the first, honestly, guys, of all the times we've seen Pharaoh done in trials, which is all the time, that was so cool. For anyone that didn't watch it, I highly recommend going back and looking. You really get to see how it looks to use the software, and you really get an idea of the lay of the land, because the attorney just kind of like got asked to just kind of explore the area, both attorneys, you know, and he just kind of, as they're asking him, he just kind of shows you around. It's not like a prepared, you know, slideshow. It's like, here it is. We can explore the crime scene wherever you want to go. We can do it in color, or we can do it in black and white. And it's really fascinating. So you really got a good idea of the lay of the land, 3D. And now we're going to get to all the forensic evidence within that. Okay. But first, and we're probably going to watch these again later on. They're going to become relevant during the arguing, but we're going to watch them now initially. And then we'll probably revisit because they're short. But here's the first installment of What the Muck.
It's a house.
And so the police leave, and the defendant leaves Alex's house at approximately 1:05 p.m. The defendant's in the driver's seat, and Alex is in the passenger seat. And Alex would never be seen again. At approximately 1:25 p.m., Chester Davidson, a man who was driving to work on 430th Avenue, describes seeing a vehicle at approximately 1:25 p.m. blocking his lane of traffic, such that he's traveling on 430th Avenue and he needs to kind of weave around this vehicle. And he described seeing a female in the passenger seat, a female in the driver's seat, and a male in the passenger seat.
So I'm pausing this real quick to say a couple things. First of all, Random Girl says, I've seen 3D renderings by drone, but not like that. I know, wasn't it cool? Wasn't it really cool? Also, did you watch the big tangent that happened in the middle of that? We took a squirrel tangent all the way around the fucking world. I'm sure Maisha will be here shortly. Shout out to Spencer. I've been wondering where you've been, my friend. I was just thinking about you. He said, I don't know anything about this, but my school said say the dude was driving, and that's when she attacked, and then afterwards she did a bunch of things that don't make sense, though it's all senseless. Inappropriate makes sense to Taiwan. So we're gonna get there. So it's all good. It's you know what? Thank you for being honest. So yeah. So and the question that I had when we were talking about this was of course understandable. Most of this when I was talking about this was that like who was driving and how would you prove that, right? Because we know that their DNA is going to be all over the car, you know, and that's when I was like, of course I was kind of getting ahead of myself because we're going to hear from the forensic people, but it almost seemed like that would be a really tough thing to prove. So here's what it is. I went back to the opening statements. Okay. And the answer to that question, I think, is here. This is from the opening statements. I'm going to play this again. And it's in eyewitness testimony is what I think the answer is. So let me play this again. And so this is the prosecutor, okay? Opening statements.
It's a house.
And so the police leave, and the defendant leaves Alex's house at approximately 1:05 p.m. The defendant's in the driver's seat, and Alex is in the passenger seat. And Alex would never be seen again.
Okay. So they leave the house, they leave Alex's house, and Ezra's driving.
At approximately 1:25 p.m., Chester Davidson, a man who was driving to work on 430th Avenue, describes seeing a vehicle at approximately 1:25 p.m. blocking his lane of traffic, such that he's traveling on 430th Avenue and he needs to kind of weave around this vehicle. And he describes seeing a female in the passenger seat, a female in the driver's seat, and a male in the passenger seat.
Now, where that's at is that's right before turning onto the dirt road, okay? So he describes seeing Ezra driving. So that's eyewitness testimony. I am sure we'll hear from this witness. I'm sure I can't wait to hear from. I'm sure we'll hear from this witness. Okay, so now, and what made me think about going back to opening statements, guys, is this arguing, like I was talking about, that is so good. It's such a great argument from these attorneys. A lot of what they argue about, they're referencing claims that they had made in opening statements, and that's what made me think I need to go back and watch these again now that we have a little bit better idea of what's happening. So I went back, and so now we're going to hear what the defense says about who was driving from opening statement.
She sees the police, everything's good, and off they drive. Ezra's driving. Alex is in the passenger seat. And she's getting anxious. She's getting nervous. She's had that happen in the past where sometimes she gets anxious driving and she doesn't want to drive. They pull over, they switch, they continue driving in the random.
So I think what he's trying to argue, this is what you do, right? If you've got a fact that's bad for your case, like you've got eyewitness testimony that places them pulled over in a weird place, kind of blocking traffic, and there's eyewitness testimony that puts Ezra in the driver's seat, well, you can argue that they pulled over so that they could switch drivers, and that would suggest that they switched drivers after the eyewitness saw them, right?
Direction they are, which is basically just on County Road E, straight out of Eau Claire, going west towards Monotony.
Monotony is where the farmer lives, where the whole murder happened.
At some point, the car turns off E onto 430th Street, and it's stopped in front of that muddy driveway.
Okay, that's it. That's what we know so far in terms of what both sides have said about the driving. Okay, now we're gonna watch this other short clip. This is the Hipster Business. And again, this is all going to be really relevant in the arguing that we're going to hear this episode. Shout out to the road trip.
So the police are called. The police come over and they start talking to Jason like, "What's going on? What are you so upset about?"
This is still from opening statements, and the reason that this is what this is about. The Hipster Business here is what's the deal with the claims of sexual assault, okay? In terms of this incident here prior to Alex's murder, okay? Because both sides are saying something completely fucking different, and they're going to be arguing over it quite a bit today.
And Jason says, "My girlfriend was sexually assaulted." The police ask to talk to Ezra, ask Ezra if she wants to talk there in presence of Jason or down at the station. She doesn't want to talk about it in front of Jason. She leaves with the police officer, and eventually they agree a couple of days later to speak. She speaks with Detective Brown about this allegation that Jason made about a sexual assault.
Okay, So what that's about is that's prior to the incident with the murder. That's in reference to John Hanson. Remember the other dude. So this is before the murders. So what the defense is claiming is that it was Jason's idea that Ezra was sexually assaulted, that Jason claimed it. But that's not what the prosecutors are going to say happened. And they didn't actually address that issue specifically in terms of who made that claim in their opening statements, but the defense did. And the defense said that it was Jason who said it. And he's saying that she spoke with the very same detective who then ended up investigating this homicide. Okay. So that's going to come up again later. And the reason that I have these is because what's going to happen is you're going to hear these attorneys arguing about, no, I didn't say that in opening statements. Yes, you did, that type of thing, because they don't have a transcript. And you know what we're going to be able to do is we're going to be able to go back and watch this and be like, yeah, okay, here's what you actually said, right? We will have the evidence here before us, okay, in terms of who said what in opening statements, because they're going to argue over it, okay?
And over the summer and the early fall, her and Alex developed a relationship, a friendship.
Now this is the second huge, well, not the second, in terms of the hipster business theme, this is the second huge point of contention that comes up in the arguing that we're going to hear from them, which is, what was the deal with, okay, how to try to summarize it, in terms of what Alex really believed, right? Is that relevant? Is it probative? Is it more prejudicial than probative? Is it hearsay? Is it speculation? Is it relevant? Does it do, I mean, there's so many questions regarding his beliefs. Remember, he was a philosophy major and a writer. And a lot of what the defense is trying to base their theories on are the books he was reading and the things he was writing and all this, right? And that was a huge part of their, again, opening statements. And so when the prosecution is wanting to ask witnesses who knew them about what Alex's beliefs meant and shit like that, and then the defense is objecting, they're kind of going back to, well, hang on, you guys kind of started this whole thing in your opening statements because of what you guys, by you guys I mean the defense, right? What you said, you by trying to interpret it, and then we're going to hear them argue over what did he really say? What did the defense attorney really say? Because he's going to really couch it, and it's going to be interesting to see. We're going to watch this now, but we'll watch it again later when we see him try to say and explain what he said, and we'll be able to see if he was correct or not in what he's saying to the judge. But we're going to watch this right now, just again, so that way we can already have it in a kind of in our minds.
Based upon these non-traditional ideas, he's accepting of Ezra's fluidity along the gender spectrum. He also has some odd ideas. He tells her right away about his journals, his fascination with violence, his captivation with cannibalism. And she finds this kind of a yang to her yang. She learns about some of his philosophies. Her boyfriend, her ex-boyfriend, Alex, she knows him. She knows that he is a nihilist, and you'll hear about that. He believes life has no meaning. There are no consequences for one's moral actions. She has been back in his apartment before. She's heard his ramblings on about Kierkegaard and fear and trembling. She's heard his ramblings before where he's...
Isn't it interesting how he characterizes it as ramblings? I don't know that I pointed that out before, but it's an interesting way to characterize it, right? As if it's just the rantings of a crazy person to call it a rambling, and not like the writings of a philosophical mind who's like wants to be a philosophy teacher.
Read to her from his journals. Read to her while they were having sex. I've half-heartedly tried to isolate myself from you.
Y'all, do you believe that? I mean, that would have come from Ezra. There's no way to prove that he was reading from his journals to her while they're having sex. I mean, really?
Afraid I would taint you, yet I love you. I am sorry for this failure on my part. I know my touch would kill you, yet I reach out. That is my sin. The violence of my flesh that I lack a soul to correct. She knows of his writings about consent. his writings, merely doing as one will sexually.
Look at his handwriting. You know, I have an idea, and this hadn't crossed my mind before, but okay, I have an idea. We're gonna play this, and then I'm gonna do my idea. Hold on.
Makes consent irrelevant. She would hear him repeat over and over and over again his personal mantra: love and do as you will.
Oh, come on.
She's read his writings about ritual, the mutilation of bodies, self-mutilation, severance of our flesh. Faith demands that we take a razor to our own most. She's read of his fascination with violence. The secret is not avoiding the violence, but in living with it. She knows of his captivation with cannibalism. All are contaminated with violence and vulnerability. He writes about eating and being eaten.
Okay, so this is all going to become very relevant when they're arguing, but here's what I had. Here's the idea that I had. Let me find the right spot.
She finds this piece. Her boyfriend, her ex-boyfriend, Alex, knows him. She knows this, and you'll hear about that. He believes life, there are no before ram guard
Okay, here we go.
and fear and trembling. She's heard his ramblings before, where he's read to.
So I wonder what kind of pen do you think he was using, Super Planner Girl? But look at that handwriting. I wish I could write that neat. Okay, I'm going to see if I can try to read some of this. I mean, we'll see. Zooming in would be helpful. But, of course, he's just taking these little excerpts and putting them out of context. And, again, as many of you guys know, I love philosophy. I almost double majored in philosophy. I'm curious what this will look like in full context. I also don't know much Latin, so I'm curious what the title means, and I'm not going to even try to pronounce it. If anyone wants to try to Google that, go for it. But it's also typed there at the top of the top in where it's typed, the typing is, it's there in case you want to try to Google it. All right, so I'm not going to try to pronounce it, but I suppose maybe it's Latin for love and do what you will, potentially. What does that mean? Love and do what you will. This is, oh boy, something. Oh, just kidding. Passed down by St. Augustine. Okay, now I see. Super Planner Girl. Never mind my question. Gotcha. Okay. Something. I observed something as something. It haunts me. I find something uncomfortable. This is not helpful, is it? You know what I'll do? Here's what I will do. I'll be able to do this before the next video. I will save these and I will zoom in on them to make them readable. That's what I'll do, because it's just too small and it's just, I might be able to even sharpen it to make it look a little bit clearer. So that's what I'll do. And that way we can read the full thing, because I actually am really curious. So that's what I will do. And then we'll do that at the beginning of the next episode. We'll go through these writings and try to read them. That's what we'll do. So the idea is still there, right? But we're just gonna start this over for Slowly Ready. Okay, yeah, so we'll just do that on the next one. I'll make a note. Okay, so yeah, right. Thank you, Super Planner Girl. I got, yeah. So, but you know what is interesting? Even just that one sentence right there, right? Interesting, isn't it? That the defense's whole theme is that his mantra of love and do as you will was the whole mantra. They fucking bastardized the shit out of that and try to say what the defense insinuates that that's him saying, yep, go ahead and just sexually assault people. That's what that means. And it's like, no, I'm sorry. That is not at all. To me, even out of context, I understand better the meaning behind that than, the defense attorney claims to. But conveniently, they leave out that part that it's passed down by St. Augustine. So that was from St. Augustine. That's what that means. Love and do as you will was passed down from St. Augustine. Now, I don't know anything about St. Augustine. I'm going to make a note. We're going to research St. Augustine. We'll do this for the next one. We'll do St. Augustine, learn about him, and also we'll learn about that mantra, and we will zoom in and maybe potentially clarify the writing so we can read all this. But how fucked is it that they leave that out, right? It's not like that was even his. So, okay. All of that's going to really matter because we're going to hear the arguing over what the interpretation or lack thereof of what his writing means and all that, the implications of it. So, all right, let us now, actually, before we do this, I need to mention real quick. For anyone who missed it, I did have a video upload earlier, Murdaugh updates. And one of the reasons I made the video was because I was going to say to people that for anyone who wants me to cover the Buster Murdaugh lawsuit, we can totally do that. And you know what? I fucking forgot to say in the video, I forgot to ask that question completely. I realized it like a couple hours after it was uploaded. So, so what I was going to say is if you want to go over the Buster Murdaugh lawsuit, let me know in the comments, right? Anyway, because I completely forgot, I don't know what that means. Is that also in the writing? Was that something you could see in the writing? But yes, if you want me to cover the Buster Murdaugh lawsuit, y'all just let me know whether you're listening now or listening on Replay Crew. I have that document. So, all right, now let's get into the next episode.
It's a house.
Mr. Nelson, you indicated that you had some matters you wanted to take up regarding Ms. Hoffmeyer before she's called as a witness.
Yes, Judge. I've been handed plaintiff's exhibit number 519, a copy. I'll hand a copy, Your Honor, so you know what we're referring to. It's a photo. We're not objecting on foundation grounds. I understand that it's a photo of a letter that was found in, I think, the trunk of the vehicle in question. We're objecting to the admissibility of the contents of that photo as it's hearsay. It's a letter written by somebody to, I think, somebody else other than Ms. McCandless, and it's hearsay. It's also irrelevant. It has no relevance whatsoever to anything of the case. So
Okay, he's saying this letter is hearsay and it's irrelevant.
All right, well, before we go any further, what is the state's position with respect to Exhibit 519?
Thank you, Judge. The purpose for bringing it in through Katie Hoffmeyer is that she's the person who can say where it was located, which is correct. It was found in the vehicle when she did her inventory of the items.
By the way, we're hearing from an attorney who we haven't heard from yet in this trial, being as it's only day 2, but he will be introduced with the next witness.
That were located in the vehicle when it was found in the farm and then taken to the Wausau Crime Lab. The content will come in. The background there is that this is a letter drafted by Jenna Van de Zand. Jenna Van de Zand, and she gave this letter.
That's the guy we haven't heard from before. Y'all, in my mind, I call him the spring chicken. His real name is Peter Hahn, but the first time I saw him with a witness, I was like, what's this child doing in the courtroom? I mean, I'm not trying to like when you guys see like he's like looks like he's just a little little baby child.
To Jason Mengel on March 19th, 2018, so just a couple days prior to Mr. Woodworth's death. This came after a conversation she had with the defendant. So the content isn't really important to come in through Katie Hoffmeyer. That will be brought in later through Jenna, her testimony. It's entirely relevant to the defendant's state of mind and the information that was relayed about a conversation that the defendant and Jenna had to Mr. Mengel, and the entirety of that relationship between the defendant, Mr. Mengel, and then how that worked with Alex Woodworth and John Hanson, those three things kind of coming together all at the same time, is why this is relevant not only to state of mind, but also to this testimony of Jenna Van de Zandt about what information she relayed to Jason Mengel about her conversation with Ezra McCandless.
So it's multiple layers of hearsay. It's irrelevant.
Okay, I understand that the defense position at this point, but really I think that argument then related to the contents of the letter would really be more appropriate before Ms. Van de Zandt testifies. But for purposes of, I guess, where it is located, when it's located, and so forth, without it being published to the jury in terms of what it is for its content, I guess I don't see that as an issue for Ms. Hoffmeyer at this point in time. Again, as long as the jury doesn't see the contents of Exhibit 519.
The defense respectfully disagrees. If it's irrelevant, it's irrelevant. If it's not eventually proved up to be relevant by Jenna Van de Zandt, then it's not relevant for Ms. Hoffmeyer. There's all kinds of things that I imagine that they found. We don't need to go through the list of the Tic Tacs that were in the car, the list of, I mean, it's not relevant at this point. If at some point we want to, I will agree to the foundation and we can take that up with Ms. Van de Zandt, but I don't want it marked. I don't want it shown. It's not relevant. I don't think they've made an offer of proof to show that it's relevant at this moment in time. I don't think we need to bring back Ms. Hoffmeyer. My objections.
We don't know yet what's in this letter, but what we know is they really don't want this letter to come in. And here's what the deal is. This letter was found in the car, right? So what they're saying is this, that this letter was found in the car, and so therefore they need to get this letter in with this next witness, because again, like I said, this next witness is going to be the one who did the crime scene, right? That this is all going to be your crime scene evidence. And so she's the one who can get this letter in, right, for the foundation. But that there's going to be a witness later on who I guess the letter was to, who would testify as to the contents, right? But the prosecution's like, we need to go ahead and get this letter in now, just the fact that it exists and was found in the car. But the defense really does not want this letter to come in because they're already objecting to it. Like, they very easily could just have let it come in, and later on, when they go to finally bring in the witness who can testify as to the contents, they could have objected then. But they're trying to stop this in its tracks now. So whatever's in this letter, I would imagine, is really bad for Ezra.
In front of Ms. Van de Zandt are going to be for the relevancy issues, the foundation that it was found someplace in the car on this date. We will agree to that. But it doesn't need to be marked and put in front of with the jury with Ms. Hoffmeyer. Judge, briefly,
Yes.
I believe there's reference to an Alex in that letter, and if Your Honor doesn't know yet or might not recall, there's an Alex Zink involved in this case. And so the Alex referenced in that letter, it's the defense position that it is not Alex Woodworth, which again questions the probative value of the letter.
Judge, I don't see a reference to Alex, and
I didn't have the letter in front of me, so fair enough.
I didn't see it, so I'm going through a second time to see if I missed it. I don't see any reference to an Alex. So what is the state's position if there's a stipulation that there would be foundation as to when and where it was found and by whom when we get to the witness that authored the letter?
my preference is just to have it identified as an exhibit, not published to the jury. Then it's cleaner. I understand the defense position. It's not a huge issue for us one way or the other, but I think my preference is to bring it in through, have it marked as an exhibit, have it be identified as where it was located, and then not published to the jury until, unless and until Ms. Van de Zandt can establish relevance to this case.
All right, well, I'm going to allow the state to offer that evidence that this is found, won't be published to the jury, they won't be told what it is, and we'll take up the actual admissibility of the content of the letter at a later time.
Yeah.
So it's marked but not being offered and therefore not being received with this witness.
That's my understanding. It would
Really
just
does
be
not want it in.
identified as to, where it was found, when it was found, by whom it was found. And, when it's tied up, if there is relevance, then if it's offered, we'll argue on whether it will be received, or allow you to argue whether it can be received at a later time.
I understand. I just wanted to, hopefully I don't just need to object during it. And so if that all goes smoothly, I won't,
All right,
but
well,
it's preserved.
I'll tell you what, your objection will be preserved as noted here on the record. And if you don't want to object in front of the jury, that's fine. Your objection will be preserved. Okay? And I'm assuming you're going to object when we get to the other witness.
Yes, we'll need to take it up before that witness.
Okay.
Or maybe.
And, so where was Exhibit 519? So we put it back where it was.
Thank you.
Okay, and I just wanted to make a note about our sidebar at 9:38. Essentially, Mr. Nelson was asking whether the state would object to him going beyond the scope of redirect in a recross. And Mr. DeFore did not object. And so Mr. Nelson was allowed to go beyond the scope of redirect with the last witness, Mr. Trooper DeVries. Okay, does anybody need a restroom break? Ms. McCandless? Yes. So why don't we take care of that right now before we bring the jury back in? Be about 5 minutes.
So a couple things. First of all, I just wanted to say, I really love this judge. Look at how kind he was asking if Ezra needed to use the bathroom, first of all. And then second of all, he always does this. I haven't seen this before in trials, where whenever there's a sidebar during testimony, right, with the jury being present, once they get to a break and the jury's not present, he goes over and makes notes of what the content, what the sidebar was about, and puts it on the record with the attorneys, just to make sure that everybody's on the same page. It's really interesting to me because, I wonder if what that's about, because we know that everything's on the record in terms of there's a court reporter, right? And there's a transcript. But as we know, those are not available until after the trial. So I wonder if the purpose of this is because he's making these notes just for himself and for the attorney, so that if ever something comes up and it's like, oh, what happened? What did we argue about? What did we say? They can't just go to the transcript, but they will have notes about what had happened at the sidebar because he takes notes. And I don't know if that's other judges do that and they just don't talk about it or what, or if they don't do it at all and they just hope technically it's up to the attorneys to remember, but I think it's a really fair way and it's just very thorough. I appreciate that it's very thorough and he's just very measured to me, I feel like so far. So let me know y'all's thoughts. So here's the spring chicken attorney, as I
Ms. Hoffmeyer, can you state your name and spell the last name for the record, please?
My name is Katie Hoffmeyer, spelled Hoffmeyer.
Where do you work?
I work at the Wisconsin State Crime Laboratory in Wausau.
How long have you been employed there?
I've worked for the crime laboratory since September of 2011.
What's your current title?
My current title is a forensic scientist supervisor. I also have duties as a crime scene response team leader.
Have you had different titles throughout your employment there?
Yes, I have.
If you could give me a general kind of chronological order of what you have been titled there.
I began my career at the crime laboratory as a controlled substances analyst. I worked on the bench doing controlled substances analysis for 7 years. I also trained to be a crime scene response team leader, so I fulfilled that role. In 2017, I was promoted to a laboratory quality manager, and then last fall, I was promoted to a supervisor role, still fulfilling my duties as a crime scene response team leader.
I'm going to show you what's been marked as Exhibit 149. Can you take a look at that and let me know when you're able to identify what that is?
State Exhibit 149 is my statement of qualifications, similar to a CV.
So a curriculum vitae
Yes.
talks about your training, experience, education.
Yes.
And is that an accurate copy of your statement of qualifications, reasonably updated?
Yes, it is.
I'd move Exhibit 149 into evidence.
Any objection?
No, Judge, we agree.
Right, Exhibit 149 will be received.
That they do. I've never seen this before in a trial. Have y'all? With every one of their, forensic witnesses, or I would say experts. I mean, they're not hired experts, right? They're all law enforcement, but they do this with all of them, which is they have their CV and they admit it into evidence. I've never seen that before. And it's interesting because I think it makes a lot of sense, right? Like so far they haven't needed to refer to it. Nobody's asked, how like we've seen other witnesses in other trials where they're like, okay, can I refer to my CV? Can I refer to my resume? Whatever the case may be, if you're Dr. Hughes, you've got your notes, whatever. But these witnesses so far don't even end up referring to it at all or needing to look at it or anything like that. So it's interesting. And it makes me wonder if it's just like a protocol measure. Like, why wouldn't you admit it into evidence? Like when you think about it, it's like, well, yeah, why not? Right. That way it's not an issue. That way it's not a matter of, can I get the note? You know what I mean? Like it's a time saving measure, I think, for one thing, right? Because if it's already in evidence, then if there's a discrepancy with the, even if it's on cross or whatever, it's not even a big deal. They don't have to worry about, glancing at it and all that, right? I don't know. But it's just interesting. I don't know if you guys have seen that before, but let me know if you have.
Now, if you could just give me a general background of your education that qualifies you for your current role.
I have a bachelor's of science degree in biomedical sciences with a minor in chemistry from Grand Valley State University in Allendale, Michigan. I also have a master's of science degree in forensic sciences from Boston University.
Do you have any specific education and or training as it relates to crime scene processing?
Yes, I do.
Can you describe for the jury what that is?
Can I clarify educational training or on-the-job training?
Either way, and just specify for the jury.
Okay. I did take courses in my graduate studies on crime scene processing. When I was hired at the crime laboratory, I also received on-the-job training in crime scene response processing to fulfill my role as a team leader.
You mentioned let me step back a second. How many crime scenes approximately do you think you've processed in your career?
I have assisted with processing over 50 crime scenes. That would also include vehicles that are submitted to the laboratory for processing, as well as autopsies.
You mentioned a crime scene response team, correct?
Yes.
What is that?
The crime scene response team is a team of personnel at the laboratory who volunteer to go to crime scenes to assist law enforcement agencies as a technical assistance to help them assess a scene, document the scene in its entirety through photographs, note-taking, and sketches, as well as locating key pieces of evidence within that scene and collecting and preserving those items of evidence.
Is that typically or always at the request of law enforcement?
Yes.
What different types of scenes have you processed? Just if you could give a general idea.
Primarily the scenes that the team will respond to and that I've responded to are in regards to death investigations or homicides.
Were you deployed as part of that crime scene response team on March 23rd, 2018?
Yes, I was.
Where were you sent to?
I responded to a scene in the town of Springbrook.
And the general location, does it sound like 430th Avenue, about 0.2 of a mile west of County Road E?
Yes.
Do you recall what time approximately you arrived there?
I arrived at approximately 9:30 p.m.
Do you remember who requested you? Or which agency, not specific person?
The Dunn County Sheriff's Office.
Did you have anybody else as a part of your response team that day?
Yes. A photographer responded with me, Brooke Laxton, as well as our crime scene response coordinator came to help us with the scene from the Madison Laboratory, Nick Sulkey.
And Brooke, for the court reporter, is that Brooke?
Yes, it is.
Laxton's Laxton?
Yes.
And Nick Stolke, is that Stahlke?
Yes.
What was Mr. Stalky's role?
Mr. Salke assisted just as an additional team member to help with the evidence collection at the scene.
You were the lead that day?
Yes, I was.
If you could provide the jury with a general description of what the scene looked like as you first arrived.
When the team arrived, we parked on 430th Avenue and walked down a long farm road, a dirt farm road. At the end of that farm road was a vehicle that was parked or appeared to be stuck in mud. The back driver's side door of that vehicle was open, and a male victim was hanging outside of the vehicle.
When you say vehicle, would you describe it as a car?
Yes.
Were there any other vehicles or equipment in the area?
There was a large green army trailer, which is how I described it, that was parked next to the vehicle as well.
Is that was one of the things on the last live stream that we were talking about that I commented on. I was like, yeah, it looks almost kind of like a military or an army truck. And it's funny that she also noted that same type of description. As we get into the pictures here, guys, just beware. A fair warning, you know, where there will be blood, there will be a dead body. It's, you know, it's nothing, again, it's if you watch the last one, it's nothing different from that. It's more of the same, right? But for anyone who didn't see it, you know, it's, you see a person who has blood on their clothes, stuff like that. It's not, you know, no close-ups of the face, you know, they have some of it blurred out, but just, you know, just to, I'm gonna go ahead and say it. I'm sure I'll say it again when we get closer there, but I think it's coming up, so.
Upon your initial observations, did you note any blood?
There was blood present at the scene, yes.
Specifically outside of the vehicle,
Yes,
as well as other locations?
correct.
When you arrive at a crime scene generally, what are some of the first things you're looking to identify or preserve?
When you arrive to a crime scene, first you just assess the scene in its entirety. Typically, we'll put priority on items of evidence that are located outside versus that are in a sheltered area or could be preserved.
When you're specific to this scene, did you locate, I'll step back, is there a distinction between footprint impressions and footwear impressions?
Yes, there is.
And what is that distinction?
Footwear impressions would be,
So remember, guys, that what we know so far is we know that the victim was found without shoes, and we also know Alex showed up, or sorry, not Alex, Ezra showed up at the farmer's house without shoes. So both of them had no shoes, right?
would be produced from someone who is walking on a surface wearing shoes, and maybe the impression would be from the tread of their shoe that is visible on the ground. A footprint would be more of an impression where someone wasn't wearing shoes and you see an impression in the ground or on a surface that doesn't have a tread mark with it.
Is it possible for weather to impact an outdoor crime scene?
Yes.
Are there certain precautions that are sometimes taken?
Yes, items may be covered, with a tarp or a box or something by law enforcement prior to us arriving to ensure that that item of evidence doesn't get disturbed or destroyed maybe by rain or snow or wind that is outside.
Are you aware of whether or not any precautions were taken in this case?
Yes.
What were those precautions, if you recall?
The Dunn County Sheriff's Office did cover some impressions that they saw in mud with cardboard boxes just to preserve those items.
Now, let's start with, you talked about footprint versus footwear. Let's start with footprint impressions. Were any footprint impressions located on this crime scene?
Yes.
Do you recall just generally where those footprint impressions were located?
So footprint impressions were located traveling from the vehicle towards 430th Avenue. There was a trail that was visible along that long farm road. I chose to mark kind of that trail with some flags, but then collected or marked off 2 of those impressions as items of evidence.
What is that document, if you recognize it?
State Exhibit 556 is a receipt of physical evidence that I generated at the scene, which lists the items of evidence that were collected. There was a total of 15 items.
So do those, it contains some numbers, correct?
Yes.
Do those correspond with evidence markers?
Yes, they do.
And is that your record of items that were found and how they correlate to evidence markers?
Yes.
Is that an accurate depiction of, or an accurate copy listing of the items that were found and marked in this case?
Yes.
I'd move 556 into evidence.
Any objection to 556?
No.
Okay, Exhibit 556 will be received.
And you mentioned that there were 2 footprint castings taken, correct?
Yes.
Can you describe the process for that?
So casting or a casting material is used to create a 3D model of an impression that is visible in this case, mud. So to cast an impression, a powdered mixture known as dental stone is mixed with water to the consistency of like a pancake batter. That casting material is slowly poured into the impression and allowed to dry, which takes anywhere from maybe 10 minutes to over an hour, just depending on the conditions outside. Once that's dry, then that cast can be picked up and collected, which gives you a 3D model of that impression.
And to be clear, that was a footprint rather than a footwear impression, correct?
Yes, that's correct.
If you could look at what's 284 again, and identify for the jury where, if you're able to identify where those first 2 footprint impressions were located.
Items 1 and 2 were marked as the impressions that were collected or casted. There was a trail of these foot impressions all the way to the road, but I chose to select these because they looked like good quality and then collected those 2 items.
Were you able to identify, I think you mentioned this already, but the direction that those were located, that those were going?
The foot impressions were traveling towards 430th Avenue.
Were you able to tell if they were bare feet completely, or if there was some clothing on them?
In my opinion, it appeared that they were impressions created from a sock because you could see actual fabric impressions in the mud.
Now, you're a manager or supervisor at the crime lab, correct?
Yes.
Does your crime lab or any other crime lab with the state of Wisconsin labs do footprint impression comparisons?
No, we do not.
Now, I want to talk about you mentioned the car, the vehicle that the body was located in, correct?
Yes.
Can you give a general description of that vehicle?
The vehicle was a silver-colored Chevy Impala.
Now, do you recall anything about the clothing that the individual inside of the vehicle, the body, was wearing?
Yes.
Could you describe generally that clothing?
The victim was wearing khaki-colored pants, a gray sweater, a scarf, and socks, no shoes.
Were there any visible wounds during your initial observations?
Yes.
Where were those wounds?
Wounds were visible on his neck as well as on his back.
When you arrived, did you touch, move, alter, tamper the body at all?
No.
Was the body eventually removed from the scene?
Yes, it was.
How was that process coordinated? If you were involved?
Right. The Dunn County Medical Examiner's Office personnel from that office responded to the scene to help recover the body from the vehicle. I was there to assist with that process as well.
Was that after you did your scene processing?
We marked off the items of evidence that were outside of the vehicle and near that rear driver's side door prior to moving the body, just to ensure that they didn't get disturbed.
And we talked about footprint impressions. Were there any footwear impressions that you noted?
Yes.
Where were those?
Footwear impressions were observed outside of the rear driver's side door of the vehicle.
What was done with those footwear impressions?
One of the impressions was marked off and scaled and then photographed.
Is it possible, once you're on the scene, after it's been secured, is it possible for you to say exactly when those impressions were made or by whom they were made? Maybe that's two separate questions. When they were made?
No.
Okay. Is it possible if there are footprints in the same area to tell exactly what the order of those was?
I'm not sure. I'm not capable of doing that.
Now, in the area from 430th up the road, the side road, the muddy dirt road to the vehicle, the car that the body was in, did you notice any obvious handprints or body prints besides the footprints that you identified?
I'm not sure I understand your question.
In that muddy area between the roadway and the car, you identified some footprints that we already talked about, correct? Is that a yes?
Yes.
And were there any, did you see any obvious hand impressions or face imprints or anything like that in the mud between the car and the roadway?
No, I did not.
Starting with evidence marker number 3. Can you point to where that's located on the diagram?
Evidence marker number 3 is located right here between the vehicle and the trailer.
And what is evidence marker number 3?
Evidence marker number 3 is a brown leather boot, which was the left boot.
And perhaps I can just explain, my intention is to have you walk through 4 through 15. So without having to interject each time, if you could walk through, starting with now exhibit or evidence marker 4, state the location and then the item.
So remember, guys, we should be expecting 2 pairs of shoes on the scene because, you know, Ezra again turned up at the farmer's house without any shoes and Alex without any shoes. But the second thing that's interesting, right, is that you could see that on Alex's feet with his socks, right, that his socks were not wet and they were not muddy. So, like, the question is, like, what the fuck, right? Like, what the fuck? You know, because Ezra's got this story about them trying to get this car out of the mud. Who knows, right? Either way, regardless of what happened, his shoes are off. And he was, what we know is he didn't get out of the car once his shoes were off. And I speculated a little bit onto what potentially I feel like could have happened on the last episode about what's going on with this. But we're going to see some more evidence regarding the footwear and the footprints and everything here. So
Evidence marker number 4 is another brown leather boot, which was located right near the rear driver's side door, and that was the right boot. Evidence number 5, evidence marker number 5, was a footwear impression in the mud, which was right outside of that rear driver's side door. Evidence marker number 6 was a blue fleece blanket with reddish brown stains that was outside of the vehicle. Also collected with that blanket, within the blanket, was what I marked as item 6A, which was a cardigan that was found with the blanket at that location. Evidence marker number 7 was a dark brown and green paint chip located on the ground. Evidence marker number 8 was a blue string that was also found on the ground. Evidence marker number 9 was a reddish brown stain that was located on the grass between the vehicle and the trailer. Evidence markers number 10, located between the vehicle and the trailer, as well as number 11, which is positioned closer to the trailer, were both cigarette butts. Evidence marker number 12 was a reddish brown stain located on the grass near the trailer.
Hold on. Did y'all hear that? My jaw dropped when nobody in the opening statements. This is the first time we have heard them say that they found cigarette butts. This has not come up in this trial yet. This was a shocker. My jaw absolutely fucking dropped when they said this. I was like, hang on, what? Because there has been no testimony that either of them were smokers. We've heard a lot about Jason Mengel, Ezra's boyfriend, smoking, but not about them two, either of them. So let me back that up so you guys can hear that again. And by the way, I like the way they go through the evidence. They go through it with this like exhibit, right? Where it's like what you're seeing here, where they've got the lay of the land of the crime scene and where everything's located. And then they show you the pictures of the actual things. It just makes so much logical sense. It's like, why do they do this in every trial?
Stain that was located on the grass between the vehicle and the trailer. Evidence markers number 10, located between the vehicle and the trailer, as well as number 11, which is positioned closer to the trailer, were both cigarette butts. Evidence marker number 12 was a reddish brown stain located on the grass near the trailer. Evidence marker number 13 was a reddish brown stain that was located on the side of the trailer, as well as evidence marker number 14 was another reddish brown stain located on the outside of the trailer. And then evidence marker number 15 was a reddish brown stain that was located in the grass between the front of the vehicle and the trailer.
Thank you. If I could have you take a seat back on the witness stand. You described a couple of items as stains. Is there anything that's done to follow up on those items?
Wow.
Maybe I'll start back with another question. What did you believe those to be?
The reddish brown stains, I believe that those appeared consistent with blood.
Is that based on your training, experience, processing of crime scenes?
Yes.
When you identify areas that you believe to be blood, is there a certain process that you follow?
The items could be tested while on scene with a presumptive blood reagent to see if that reaction turns positive, or the team leader could just choose to collect the stain for further testing at the laboratory.
What was done in this case?
In this instance, while on scene, I chose to just collect those items that I believed were consistent with blood, and I did not do any presumptive testing, mostly due to the frigid cold that at the nighttime while we were on scene.
Did you mark all areas that you thought contained possible blood?
Yes, I marked the either individual stains or an area that had stains and then collected those items.
So when you say collected an item, some of the stains were on, for example, the trailer. How would you collect that item?
So the two stains that were visible on the edge of the trailer were collected by taking a cotton swab, moistening that swab with water, and then rubbing the swab across that surface until the swab becomes discolored. Then that swab can then be packaged and sealed and then submitted to the laboratory for testing if needed.
What about stains? For example, marker number 12 is a reddish brown on grass at marker 12. How would you collect that?
This stain that was at marker number 12 was on.
She got solo cups, obviously. Yes, she was in custody during the trial. Yes, random girl, good question. She was not out on bond. She was kept in custody. Yep.
the grass, I chose to just take a portion of the grass with the blood on it and submit it to the lab for testing.
Does that process alter the DNA in any way?
To my knowledge, it wouldn't, but that would be a better question for a DNA analyst.
Is that a process that you're trained in?
Yes, trained to either physically collect the item or swab the item.
Now, are there certain precautions that you're also trained in to help prevent contamination or tampering?
Yes.
What are some of those different steps that are taken?
Steps are taken to ensure that we don't contaminate a scene by wearing gloves or protective equipment, just to ensure that the evidence doesn't become contaminated unintentionally. So gloves were worn while collecting these items and using clean, sterile swabs and packaging to put those items in.
So once you take a swab, what is the packaging that it goes in?
The swab would go inside of a swab box and then inside of an envelope, and then that envelope is sealed.
What about, for example, with the grass that you collected, what does that packaging look like?
The grass with the stains would have been put in either a paper bag or an envelope, and then sealed.
So items from markers 1 through 15, did those items eventually get turned over to the Dunn County Sheriff's Office?
Yes.
Do you recall the officer that took custody of those?
All items that were collected from the scene were handed over to Rich Day of the Dunn County Sheriff's Office prior to us departing.
I just want to be clear as to which items from that list of marker numbers suspected blood was, either samples were taken or suspected blood was contained on them. Could you go through those?
Okay. Markers number 3 and 4 were the brown leather boots. I can't recall if there was apparent blood on the boots or not, but they were physically collected. The dark blue fleece blanket at marker 6 had reddish brown stains that were visible. The cardigan was also collected at marker 6A. I can't recall if that had stains or not. And then a reddish brown stain at marker 9 was collected, as well as the stains at markers 12, 13, 14, and 15.
I think you said you arrived at about 9:30 p.m. on the 23rd. Do you recall what time approximately you completed processing that scene?
At approximately 6 a.m. the following morning.
There you go. She was there from 9:30.
Tell the jury what is depicted in exhibit number 67.
All right.
State exhibit number 67.
We're going to be starting out with these like footprint, tire, footwear impressions and stuff before we get to the car. So again, heads up, we're getting to the pictures, but we're not going to be quite there yet. I don't think with a dead body or anything like that, just so everyone knows.
Is a photograph of the foot impressions in mud along the farm road that were marked as items 1 and 2.
I'm going to provide you with a laser pointer so you can point out specific areas of interest if you need to. Exhibit number 68. Can you describe what's depicted there, please?
State exhibit number 68 is a close-up photograph of the foot impression at marker number 1, which includes a scale and the directionality that impression was traveling.
Exhibit 69, can you tell the jury what's depicted here?
State exhibit number 69 is a photograph of the Chevy Impala, as well as the green army trailer at the scene.
Okay,
Exhibit
guys.
70.
So now we're here. So just again, fair warning, we're going to be, there's a victim there. So these are the actual photographs. Remember, we heard from the Mr. DeVries with the scanner, which was so cool. And we heard about the difference between what he did versus regular pictures. So now we're getting to these. These are, he even referenced Miss Hoffmeyer. This is Miss Hoffmeyer, and these are the pictures. So
Can you tell the jury what's depicted there?
State exhibit number 70 is also a photo of the Chevy Impala with the rear driver's side door open and the victim in the back seat area.
Are there items of interest that were eventually marked off with markers located between the green trailer and the vehicle?
Yes. Evidence markers 3 through 15 were all contained within this area outside of the vehicle, between the vehicle and the trailer.
Can I have you look at exhibit number 72? Can you describe for the jury what's contained here?
State exhibit number 72 is a photograph of items that were marked off for collection. Items 3 through 12 are in this photograph.
Exhibit number 73, what's depicted here?
Exhibit number 73 is one of the brown leather boots that was collected.
And exhibit number 74?
Exhibit number 74 is the brown leather boot that was collected at marker number 4.
Exhibit number 75, what's depicted there?
State exhibit number 75 is a photograph of the footwear impression that was just outside of the rear driver's door. More photographs of this impression were taken with a scale.
And exhibit 76?
Exhibit number 76 is the dark blue fleece at marker number 6, as well as the brown cardigan that was found wrapped up with that blanket.
And the cardigan would have been designated as a subsection of 6, correct?
Yes, I marked it as item 6A.
What's depicted in exhibit 77?
State exhibit number 77 is a photograph of a reddish brown stain that was on the grass at marker number 9.
And that's one of the samples that would have been collected?
Yes.
Exhibit number 78, what is there?
State exhibit number 78 is a cigarette butt that was collected from the ground at marker number 10.
Go ahead, Mr. Hart.
Thank you. Exhibit number 79?
State exhibit number 79 is a photograph of the cigarette butt that was collected from the grass at marker number 11.
Exhibit 80?
State exhibit number 80 is a photograph of the reddish brown stain that was collected from marker number 12.
Exhibit 81?
State exhibit number 81 shows an overall photograph of the stain at marker 11 and 12, as well as the reddish brown stains that were visible on the edge of the green trailer are markers 13 and 14.
Exhibit 82?
State exhibit number 82 is a reddish brown stain that was located on the edge of the green trailer at marker 13.
If you could describe exhibit 83, please.
State exhibit number 83 is a photograph of, an overall photograph of the stain at marker 14 and the stain at marker 12.
Exhibit 84?
State exhibit number 84 is a photograph of the male victim in the back of the Chevy Impala.
Exhibit
85.
So
State
I'm just pausing it here real quick to say, so remember, one of the things that is interesting is his that's how he was found, right? Half in, half out of the vehicle. So this to me looks like potential causes could include he was maybe more upright, kind of against the car door. Actually, no. So the car was found with the door ajar. I was going to say, was the door closed and he was like up against the door and then the door was opened and he fell out. But If that happened, it was not from law enforcement. So when they arrived, the door was open. So either he was already sort of upright and then Ezra opened the door and he fell out like this, or the door was already open and then he died in this position. But I wonder, part of me wonders if she was trying to get him out of the car and that's how he ended up like this. Now, again, we still have a lot. I still have a lot of questions. Like, how did he get back there? Why was he in the back seat in the first place, right? I mean, was she trying to give them the promise of some canoodling? I don't know. I don't know. Or could he have gone to the back seat to get, we're going to see pictures here of where like the paintings and shit were found. Maybe he went into the back to get a fucking painting or something like that. But again, this whole thing is weird because of where they were. Anyway, and of course, like I said, I think last time as well, if they just wanted to have sex, they could have done that fucking anywhere. Why the fuck would they be going all the way out in the middle of nowhere onto private property where they're trespassing when she's not even supposed to be driving? So there's a lot of questions, right? But again, just as far as this picture is concerned, how and why did he get into the back? And then how and why did he end up in that position is kind of the forefront of my mind as we go through this.
Exhibit number 85 is a photograph of the victim's legs in the position that he was found in the back of the vehicle.
And Exhibit 86.
State Exhibit number 86 is also a photograph of the victim's legs and his position that he was found in the back of the Chevy Impala.
Exhibit 87.
State Exhibit number 87 is a photograph of the back of the Chevy Impala once the body had been removed.
And Exhibit 88.
State Exhibit number 88 shows a reddish-brown stain on the grass at marker number 15.
Now, I'll have you open what's marked as Exhibit number 205. There's a pair of scissors, and I believe you're wearing gloves already. If you could open Exhibit 205, please. Do you recognize what that item is?
Yes.
What is that item?
This is the brown leather boot that was collected from the scene.
From marker number 3?
Yes.
If you could open up Exhibit 206, please.
I don't know yet.
Is Exhibit 206, if you can tell, is that the right boot found on the scene?
Yes. State Exhibit number 206 is the right leather boot that was found at marker number 4 of the scene.
If I could just have you hold that up for the jury. Thank you. And once you've somewhat repackaged that, if we could move on to Exhibit 207.
You'll know it's changing her gloves between every piece of evidence.
Do you recognize what 207 is?
Yes.
What is that?
State Exhibit number 207 is the brown cardigan that was found at marker 6A that was out on the ground outside of the vehicle.
If you can tell just from a cursory view of that item, are there any rips, tears, or puncture wounds that you can easily see?
So you know what, crazy guys?
I don't see any on here.
I am fairly certain that that is the same cardigan that Ezra is wearing in the thumbnail. Let me pull up a picture of that and take a look. I'm pretty sure that's not the one Alex. Now they both had brown cardigans, right? a lot. Actually, that reminds me. Fuck, I forgot my ticker. Hold on. Okay, one thing at a time. So I added that to the ticker, but I forgot to pull the ticker up. So anyway, there's a lot of cardigans and sweaters in this trial, but let me pull up. Yeah, I think this is the same cardigan she's wearing in the thumbnail in the picture. I'm pretty sure. But while I have it paused, let's pull up that ticker. So since last time, I had added a couple things to the ticker, and I was going to let you guys help me decide on estimating where we would be at for some of these new additions. So the new additions are anything art related. So artwork, art show, drawings, etc. I don't think we've had any of that this episode, but we have on the previous episodes. And then the next new one is sweater or cardigan, which we have just heard already on this episode and had heard previously. And then we also have books, reading, writing. So I'm going to go ahead and make some estimates, and you guys are welcome to let me know. I would rather underestimate than overestimate. But yeah, I'm going to go ahead and make some guesses here and keep playing this.
Thank you. And once you've had an opportunity to repackage that to the best you can, we'll move on to exhibits 209 and 210.
Do you want me to open the additional layer?
Can you identify what that is?
So state exhibit number 209 has a manila envelope that was labeled with marker number 10. Inside of that envelope was another sealed envelope, which has my handwriting, the case number, and the marker number 10, which contained a cigarette butt.
Thank you. And we'll move on to exhibit 210, please.
Okay, I think there's two cigarette butts.
You're looking at exhibit 210, correct?
Yes.
What is that item, if you've been able to identify it?
State exhibit number 210 contains an additional sealed envelope inside, which has my handwriting and initials with marker number 11, which was a cigarette butt collected from the scene.
Thank you. I'll have you finish up repackaging these, and I'll have you take a seat at the witness stand. So you processed the crime scene. Did you also have an opportunity to process the vehicle once it was transported to the crime lab in Wausau?
Yes, I did.
When did that occur?
The vehicle was submitted to the laboratory for processing on March 26th of 2018, and then was processed at the laboratory in the following days.
How did the vehicle get there?
The vehicle was transported to the laboratory in an enclosed trailer by the Dunn County Sheriff's Office.
When it was received, and when we say vehicle, we're talking about the car that was on scene, correct?
Yes, the Chevy Impala.
And when it was received at the crime lab, how was it taken in? Was it in a secured location? Where was it put?
Right, the vehicle was transferred from the enclosed trailer into the garage of the laboratory, which is a secure building.
Who processed the vehicle?
The vehicle was processed by myself with the assistance of Brooke Laxton, who performed the photography.
Did Carissa Wobler, that's is it C-O-R-I-S-S-A?
Yes.
Wobbler's W-O-B-L-E-R. Did she assist as well?
Carissa Wobbler did some latent print processing on the rear driver's side door of the vehicle.
You were able to identify this car based on appearance, license plate, VIN number, those things as being the same vehicle that was on the dirt roadway, correct?
Yes.
When you first started processing the vehicle, where did you start?
I first examined the exterior of the vehicle to look for any evidence that may be on the exterior, and then moved to the interior of the vehicle.
What were you looking for on the outside of the exterior of the vehicle?
I was looking for any probative items of evidence, and in this case, there was blood on the exterior of the vehicle.
What did you do with those areas of suspected blood?
Areas of suspected blood were photographed, marked with an evidence number, and then swabbed for collection.
Was that following the same process you described with the crime scene processing?
Yes.
When you said that you collected samples from the exterior of the vehicle, are there a specific number of samples that were collected?
I marked off 3 items of evidence that was collected, and then Carissa Wobbler also examined the exterior of the vehicle for any areas of friction ridge detail. She had areas that she marked off on that vehicle.
The 3 that you marked off, what were those? So if we look at Exhibit 557, there's an item number that you assigned to different items of interest during the processing, correct?
Yes.
And is the item number different than what a marker number might be?
The marker number is what will appear in the photographs with the item of evidence. Then the item number is what is used to keep track of items of evidence that are within the laboratory, so that will have a different corresponding number.
And that would actually be a letter plus a number, correct?
Yes.
Was the vehicle given a letter itself?
Yes.
And that was what?
The vehicle, or the Chevy Impala, was submitted to the laboratory as item B.
So items that were marked and identified during the processing of that vehicle, would they be the letter B and then a number?
Yes.
What were the item number, letter and number for the 3 items that you located, the 3 that you sampled?
The 3 items that were located on the exterior of the vehicle were designated as items B1, B2, and B3.
Where was B1 located?
B1 was located on the exterior rear driver's side door, and it was a reddish brown stain.
Where was B2 located?
Item B2 was a reddish brown stain that was located on the exterior rear driver's side door at marker 2.
And B3?
Item B3 was located on the trunk at marker number 3, which was also a reddish brown stain.
Is that pretty much the extent of the outside processing in terms of marking items of interest?
That was the extent of the processing that I performed, yes.
And then if we move on to the interior, did you note something as what became item B4?
Yes.
What was that and where was it located?
Item B4 was a black and gray coat with reddish brown stains, which was located on the floor of the rear driver's side, the floor of the rear driver's side of the vehicle at marker number 4.
What about item B5?
Item number B5 was described as hairs or fibers that were located on the back of the black and gray coat at marker 4. The hairs were then marked as 4A.
What about B6?
Item B6 was a sock with apparent blood collected from marker number 4B.
And B7?
Item number B7 was a cigarette box that had 2 cigarettes inside, which was collected from the front right pocket of the black and gray coat and was marked as at marker number 4C.
What about items B8 and B9?
Again, too. Maisha's here. Yay.
B8
Hi. I'm so glad you're here.
and B9.
Oh, dude. So there's a lot. So these cigarette butts, right? So happy to see you, Maisha. So that's interesting because, again, we didn't hear anything about cigarette butts in the opening statement. So she's saying there was a cigarette box found with 2 cigarettes in it. So ostensibly, the owner of the black coat was also the person maybe potentially with the cigarette butts or the cigarettes. And, you know, the thing is, we're gonna have to wait to find out about the DNA, right? Because this witness did not test the DNA. Obviously, it would be sent off. We'll find out about this DNA on the cigarette butts. But it's interesting because it does make one wonder at what point, if it was Ezra, was she smoking a cigarette? Like, was this after she killed him? You know what I mean? Like, what the fuck? We also know, again, that she showed up not just without shoes, but she showed up without like any, showed up at the farmer's house, right? Without like any coat or any sweater or whatever. Now, having said that, it's so funny because she tries to, well, a big deal is made out of, she comes from the middle of nowhere and, you know, she shows up at ringing the farmer's doorbell. And it seems like from the description, like she's been out there for who knows how long and who knows where she came from. But when you really look at it, like we've done, mapping it out, it's really not that fucking far. So it's not like she was out in the cold for hours, right? Or anything like that, right? She could have fucking, you know, I mean, taken her cardigan and her fucking coat off, you know, anyway. So, but it is interesting about that, so.
Are described as a black and white Nike shoes. So it was the pair at markers 5 and 6.
Did you note anything about the condition of the shoes, whether they were old, new, clean, dirty?
So this is another new tidbit. We had heard about the boots before this, right? We'd heard about the boots. I think we'd seen some pictures of the boots. The black and white Nike shoes, these are new. These are new. We had not heard about these before, and we still haven't seen them yet, but we're going to see them. It's like, holy shit, what? Here comes the second pair of shoes.
Shoes were muddy and slightly damp.
Muddy?
Yes.
And I'm sorry if you mentioned this, were there any stains visible on the shoes, either of them?
I did notice a stain on the sole of the shoe at marker number 5.
And that would be B8, correct?
Yes.
And that was the left shoe, and B9 was the right shoe, correct?
Yes.
Can you describe B10 and where it was located, please?
B10 was located at the rear driver's side floor at marker number 7. It was described as a wad of dark brown hair.
Now, items B11 through B20 are all described as reddish brown stains, correct?
Yes.
Can you go through and identify where each of those was located? If we could start with B11.
B11 was a reddish brown stain located on the interior rear driver's side door at marker number 8.
And B12?
B12 was a reddish brown stain from the interior rear driver's side door at marker 9.
B13?
B13 was a reddish brown stain located on the interior rear driver's side door frame at marker number 10.
B14?
B14 was a reddish brown stain collected from the interior rear driver's side door frame at marker number 11.
B15?
B15 was a reddish brown stain collected from the back of the front driver's seat at marker number 12.
B16?
B16 was a reddish brown stain collected from the back of the front driver's seat at marker number 13.
B17?
B17 is a reddish brown stain collected from the edge of the seat bottom on the rear driver's side at marker 16.
B18?
B18 is a reddish brown stain collected from the upper interior right driver's side door frame at marker 16.
So
B19?
B19
the
was
random girl was asking about if there was blood in the front passenger seat. This is the answer to that. And we're going to see pictures here in a second.
the reddish brown stain, which appeared to be mixed with some mud or dirt that was collected from the upper interior rear driver's side door frame at marker 17.
So we're still in the
B20?
rear right now.
B20 was a reddish brown stain collected from the back of the front driver's seat at marker number 8.
Starting from running back to front, guys.
And I didn't ask about B23, but was that a same reddish brown stain?
Yes.
Where was that located?
B23 was located on the interior taped opening of the rear driver's side window at marker 24.
Now, to step back to B21 and B22, what were those items and where were they located?
B21 was a reddish brown stain collected from the passenger side rear seat bottom at marker 21.
And B22?
And B22 was a reddish brown stain collected from the interior rear passenger side door at marker 22.
What was B24?
B24 was a canvas painting with reddish brown stains on the edges, which was collected from the front passenger seat.
B25?
B25 was a reddish brown stain from the center of the steering wheel at marker 31.
B26? I'm sorry, B27?
B27 was
You guys hear that? First of all, we get to add a ticker for artwork, but there's blood on the steering wheel. Oh my God, you guys. That's gonna really, dude, I can't wait to get the DNA results, because here's the thing. If that blood comes back to be, well, okay. I mean, it's got to be Alex's blood, right? It's just a matter of how did it get there, from like Ezra's hand or like from a stabby stab. Because again, I'm still wondering if what happened was she started maybe engaging in some stabbing behavior, and that's when the car veered off the road. That's just a working, but again, I don't know, because I mean, did he get into the back seat to try to escape her? I just don't know, because it's like, how did he? That's the thing. That's the only question. It's like, I feel like the only bump that I have so far, of course, we're just getting started is with this, but the only bump I have in that theory so far is him getting into the back seat. Now, it just sort of depends, right? Because there were 16 stab wounds. I mean, it does seem like it's possible he could have been moving from what we've heard so far. But why would he go into the back seat though? You know what I mean? Like, anyway, I'm getting ahead of myself, but yes, that's interesting, right? That there's blood on the steering wheel. That's what I was going to say. And let me go ahead and add another count for our artwork here. Okay.
a reddish brown stain collected from the upper portion of the front driver's seat at marker 33.
I know. 100%.
And what was B26?
B26 was a gray LG cell phone from the center console at marker 32.
Now, up to this point, we've talked about a lot of reddish brown stains. Is there you said a presumptive test is sometimes used to help determine if it's possibly blood, correct?
Yes.
What is that test
That's
called?
interesting.
The presumptive test that was used.
One thing that's interesting is that, you know, I was initially thinking, well, we know he wasn't going to the back seat to get his cell phone to call 911. Like, because again, I'm trying to answer the question, like, what if she started stabbing him while they were driving, and that's why the car veered off the road, because she was stabbing him, right? And he was maybe trying to like stop her, and then the car veered off the road. And then maybe it's like, well, maybe the reason he went to the back seat, maybe that's where his cell phone was. Well, initially, in my mind, I went ahead and ruled that out because it's like, well, a cell phone was found on center console. However, Ezra could have put it there, so I can't rule that out yet.
At the laboratory to indicate the presence of blood is known as phenolphthalein.
And can you, I'm sorry to put you on the spot, but I assume you can handle it. Can you spell that for the court reporter?
Phenolphthalein is spelled PHENOLPHTHALEIN.
Was that presumptive test used in this case?
Yes, it was.
For the items that we talked about up to this point?
Yes,
The suspected blood, correct?
that is correct.
And were all of those items presumptively positive at this point?
Yes,
Were there other brownish stains that were located that were also tested but were negative for phenolphthalein?
yes.
Where were those generally, where were those stains located?
Those stains were located primarily in the front seat of, or front seat area or front compartment of the vehicle.
Now, I want to ask you just about a couple more exhibit or item numbers. B28, where was that item located and what was it?
B28 was a black serrated folding knife, which was collected from the front right pocket of a brown jacket that was located inside of the trunk at marker number 36.
And item B29, what was that and where was it located?
Interesting there.
Item B-
That is a different jacket than the one that was found. The one that was outside the vehicle was like a black jacket or whatever. This is a brown jacket that she said was inside the trunk.
29 was a black handled serrated knife, which was collected from a bag located in the trunk at marker number 37.
Now, there were photographs which we've already introduced as exhibits that also correspond to the processing of the car at the crime lab, correct?
Yes.
Madam Clerk, if I could have the screen, please.
State exhibit number 89 is the front.
We're about to see this crime scene really is a puzzler. No, we don't know yet because she can't testify to that. She's not the she just sends them off, right? Just like we've seen in every other case. There is going to be she just swabbed them and sent them off. There's going to be another person to come in and talk about what was blood and what wasn't blood and what the DNA was. So we don't know yet, but it's a real puzzler about. So both the knives were in the trunk. It sounds like we're about to see pictures here. So, oh, oops.
Front side of the Chevy Impala that was submitted to the laboratory for processing as item B.
Exhibit 90.
State exhibit number 90 is the driver's side of the Chevy Impala.
And in Exhibit 90, there appears to be some discoloration on the, above the front left wheel and the driver, on the driver's side, driver door. Do you know what those discolorations or photographs are? I'm sorry.
Can you please repeat that?
Do you know what the discolorations are? Are those mud or are those drawings or what is that?
This area?
Correct.
That appeared to be some like custom artwork on the vehicle.
Woo, our ticker.
And I'll have you look at Exhibit 91. What's depicted there?
State exhibit number 91 is a photograph of the rear or the back of the Chevy Impala.
Exhibit 92.
State exhibit number 92 is a photograph of the passenger side of the vehicle.
I'm going to zoom in a little bit and we're going to look at on the both the front passenger side door as well as the back passenger side door. There's some green on each panel. Do you know what those are?
The green area again appears to be some custom painting that was on the vehicle.
Thank you. Exhibit 93.
State exhibit number 93 is a photograph of the driver's side rear door.
Exhibit 94.
State exhibit number 94 is a photograph of a reddish brown stain at marker 1 that's present on the rear driver's side door of the vehicle.
Exhibit 95.
Exhibit number 95 is a close-up photograph of the reddish brown stain that was present at marker number 1.
Exhibit 96.
State exhibit number 96 is a photograph of the rear driver's side of the vehicle with marker number 2, which is an area with a reddish brown stain.
I'm going to zoom in a little bit on the number 2 marker. If you could use the pointer, if you still have it, to identify what specifically you're marking with exhibit or with marker 2.
Marker 2 is just focusing on this area here that appears to be stained
Have you looked at Exhibit 97? What are we looking at there?
State Exhibit number 97 is a photograph of a reddish-brown stain at marker 3 that was present on the trunk.
And I'll zoom in again, and if you could just circle with the pointer what we're looking for.
This area right here.
Exhibit 98.
State Exhibit number 98 is a photograph of the floor area at the rear driver's side of the vehicle. The image is a little bit dark, but the gray and black coat is at marker 4, as well as a black and white Nike shoe at marker number 5.
Black and white Nike shoe.
Exhibit number 99.
State Exhibit number 99 is a wad of dark brown hair that was located on the back of the black and gray coat at marker 4A.
Exhibit 100.
State Exhibit 100 is a photograph of the black and white
So
Nike
this is our first look at this Nike shoe. So remember, we have a pair of boots and we have a pair of Nike shoes. These are the Nike
shoe that was found at marker number 5 that shows the mud and apparent area of a reddish brown stain.
Exhibit 101.
State Exhibit 101 is just a photograph of the sole or the tread of the shoe at marker number 5.
Exhibit 102.
State Exhibit number 102 is the right black and white Nike shoe that was found at marker 6.
Exhibit 103.
State Exhibit number 103 is a photograph of the bottom shoe or the tread of the shoe.
Exhibit 104.
State Exhibit number 104 is a wad of brown hair that was located at marker 7 at the rear driver's side floor of the vehicle.
Exhibit 105.
State Exhibit number 105 is an overall photograph of some of the reddish brown stains that were marked at the rear driver's side of the vehicle.
I'll zoom in on, we'll start with marker number 8. Can you circle the area of interest in that? I'm sorry, can you circle the area of interest depicted in the photograph?
The stain at marker number 8 is this area of reddish brown staining.
And marker number 9?
Marker number 9 is focusing on the stain located here.
We'll stay on this photo just momentarily. Markers number 12 and 13.
Marker number 12 is looking at this reddish brown stain on the back of the driver's seat. And marker number 13 is another reddish brown stain on the back of the driver's seat.
Do you know the marker number shown in the photograph here? Is that too blurry to tell?
It's a little blurry for me to tell. I'm sorry.
Exhibit 106, what are we looking at here?
State Exhibit number 106 is a photograph of the rear compartment of the vehicle with some of the stains that were marked off.
And specifically marker, I believe it's 15, is that identified on there?
Yes, marker number 15 is located right here on the edge of the seat bottom.
Just briefly on Exhibit 107.
State Exhibit 107 is a closer photograph of stains at marker 8 and a stain at marker 9.
Exhibit 108, that's again the stain at marker number 9, correct?
Yes.
Exhibit number 109.
State exhibit number 109 is a photograph of stains that were marked at number 11, 10, and 17, which are present on the rear driver's side of the vehicle.
Exhibit 110.
State exhibit number 110 is a close-up photograph of the reddish-brown stain at marker 10.
And if you can, remind us where that's located?
This is located at the bottom of the rear driver's side door area.
Exhibit 111.
State exhibit number 111 is a photograph of the reddish-brown stain present at marker number 11. And it's just focusing on all of this staining right here.
Exhibit 112.
State exhibit number 112 is a photograph of the stains marked at number 12, 13, and 18, and then a tear in the fabric.
I'll just zoom in a little bit on marker 18 and the tear. Can you just identify those again with the pointer?
The stain at marker 18, and then the tear in the fabric at marker 14.
Exhibit 113.
State exhibit number 113 is a photograph of this area of staining at marker number 15, which was present on the seat bottom at the rear driver's side compartment.
Exhibit 114.
State exhibit number 114 is a photograph of a reddish-brown stain at marker number 16, as well as an area with reddish-brown staining appeared to be mixed with mud at marker 17 at the rear driver's side compartment of the vehicle.
Exhibit 115.
State exhibit number 115 is a close-up photograph of the reddish-brown stain present at marker 16, which was in the rear driver's side compartment of the vehicle.
Exhibit 116.
State exhibit number 116 is the reddish-brown stained area, which appeared to be mixed with blood at marker 17, or excuse me, mixed with mud at marker 17.
Exhibit 117.
State exhibit number 117 is the area with a reddish-brown stain at marker 18 that was present on the back of the driver's seat.
Exhibit 118.
State exhibit number 118 is a photograph of the rear driver's compartment rear compartment of the vehicle with stains at markers 21, 22, as well as a tear in the seat at marker 20.
Exhibit 119.
State exhibit number 119 is a photograph of a reddish-brown stain that was present at marker 21.
Exhibit 120.
State exhibit number 120 is a photograph of the reddish-brown stain present on the rear passenger side door of the vehicle at marker 22.
Exhibit 121.
State exhibit 121 is another close-up photograph of the reddish-brown stain present at marker 22.
Exhibit 122.
State exhibit number 122 shows a photograph of the rear compartment facing the driver's side of the vehicle with stains at markers 8 and 24.
Exhibit 123.
State exhibit number 123 is a photograph of the reddish-brown stain at marker number 24.
Exhibit 124.
State exhibit number 124 is an overall photograph of the front driver's side seat of the vehicle.
Exhibit 125.
State Exhibit number 125 is a photograph of a canvas painting that was in the front passenger seat of the vehicle that had reddish-brown stains at marker 25.
Exhibit 126.
State Exhibit number 126 is a close-up photograph of the reddish-brown staining that was present on that painting at marker 25.
Exhibit 127.
State Exhibit number 127 is a photograph of the front side of the painting that had the stain at marker 25.
Exhibit 128.
Exhibit 128 is a photograph of the top of the vehicle with some of the custom artwork.
Exhibit 129.
State Exhibit number 129 is a photograph of the hood of the vehicle with custom artwork.
Exhibit 130.
State Exhibit number 130 were areas of brownish staining that were marked off at areas number 26, 27, 28, and 29.
Do you recall if those items or those areas were presumptively tested for blood?
They were presumptively tested.
And what were the results?
They all tested negative.
Exhibit 131.
State Exhibit number 131 shows a photograph of the marker number 31 on the steering wheel with an area with a reddish brown stain.
I'll go back to Exhibit 131 briefly and zoom in on the steering wheel. If you could use the pointer to identify the area of interest.
It's a small area right here.
Exhibit 132.
State Exhibit number 132 is a photograph of the reddish brown stain that was present on the edge of the driver's seat at marker 33.
Exhibit 133.
State Exhibit number 133 is a photograph of the contents removed from the trunk of the vehicle and a folding knife that was found in the pocket of this jacket.
Exhibit 134.
State Exhibit number 134 is a photograph of a serrated knife that was found inside of this cactus print bag that was inside of the trunk of the vehicle.
Exhibit 135.
State Exhibit 135 is a photograph of the folding knife found in the brown jacket and was marked as number 36.
Exhibit 136, if you could just describe what area this depicts.
State Exhibit 136 is a photograph that was captured with an area that was processed by Carissa Wobbler and marked by Carissa Wobbler.
Exhibit 137.
State Exhibit 137 is also scales that were placed by Carissa Wobbler and photographed, which are present on the driver's side of the vehicle.
Exhibit 138.
State Exhibit number 138 is an area that was marked off by Carissa Wobbler on the driver's side of the vehicle.
Exhibit 139.
State Exhibit 139 is a photograph of an area of interest that was scaled by Carissa Wobbler.
Exhibit 140.
State Exhibit number 140 is also a photograph of an area on the driver's side of the vehicle that was marked by Carissa Wobbler.
Exhibit 141.
State Exhibit number 141 is a photograph of the rear driver's side of the vehicle with an area of interest that was scaled by Carissa Wobbler.
Exhibit 142.
State Exhibit number 142 is a photograph of an area that was scaled by Carissa Wobbler.
Exhibit 143.
State exhibit number 143 is an area on the driver's side of the vehicle, rear driver's side of the vehicle, that was scaled by Carissa Wobbler.
Exhibit 144.
State exhibit number 144 is a photograph of an area on the vehicle that was scaled by Carissa Wobbler.
Exhibit 432.
State exhibit number 432 is a photograph of the rear compartment of the vehicle.
Exhibit 433.
State exhibit number 433 is a photograph of the contents that were removed from that rear compartment of the vehicle.
And I want to look back at exhibit 432 again. So if you look at the center of the items on exhibit 433, there's a small canvas painting. Is that correct?
Yes.
Do you see that item in exhibit number 432? And if so, can you point it out with the pointer?
The canvas painting is here on the floor in the rear compartment on the passenger side.
And I believe you have in front of you what's marked as State's Exhibit 519. Is that correct? And if we could,
Yes.
we can go down with the screen, Madam Clerk. Thank you. Exhibit 519, is that a photograph of a letter?
Yes, it is.
Where was that letter located in the vehicle if it was?
State exhibit 519 is a photograph of a letter that was found in the front compartment of the vehicle.
All right, one of the last things I'm going to ask you to do is to open up a few more items of physical evidence. So if you want to just put gloves on or prepare however you need to. Ms. Hoffmeyer, do you recognize what that item is?
Yes.
What is that?
State exhibit, I'm sorry, I don't remember.
236?
236 contains a black and gray coat that was collected from the rear driver's side floor of the vehicle that was designated as item B4.
Your Honor, I ask for permission to publish these items to the jury in the same fashion as the previous items.
Agreed. All right, go ahead.
If you're comfortable, would you mind holding the jacket up so the jury can see it? And can you rotate the jacket once there's been an opportunity? Are you able to identify what Exhibit 237 is?
State exhibit number 237 is the left black and white Nike shoe that was collected from marker number 5.
Thank you. If you could repackage that partially, and then we'll move on to Exhibit 238. Ms. Hoffmeyer, while you're doing that, I'll ask you a question. You're changing gloves between each item. Is that to help prevent contamination?
Yes, when you're handling items of evidence, you should change gloves between touching those items. And since I still consider this to be evidence, I will continue to do the same.
Thank you. Now you have Exhibit 238. What is that item?
Yes, state exhibit number 238 is the black and white Nike shoe that was collected from marker number 6.
Thank you. And that's Exhibit 240. What is that item?
State exhibit number 240 is the canvas painting that was collected from the front passenger seat that had the reddish brown stains at what I call marker 25.
What is the item contained in Exhibit 241?
State exhibit number 241 contained the black folding knife that was collected from the trunk of the vehicle at marker number 36.
Can you see, is there any notation or a partial notation on the blade of the knife, if you can make it out?
It's a Wisconsin National Guard is on the blade.
Thank you. That's Exhibit 242. What is that?
State exhibit number 242 contained a serrated knife that was found in the trunk of the vehicle at marker number 37.
Thank you. Ms. Hoffmeyer, I just have a few additional questions for you. We left off where you had opened up a number of items of evidence, gone through a bunch of photographs. Once those items are inventoried, photographed, processed at the crime lab, do they eventually go back to the submitting agency?
Yes.
So in this case, the Dunn County Sheriff's Office?
Yes.
Where are the items stored in between the time that they are processed at the lab until they are taken back, sent back, or given back to the Sheriff's Office?
Just to clarify, is that where are they being stored at the lab?
Correct.
Evidence that's not in the process of being examined and is waiting to be returned to the agency is usually held in the main evidence room at the Wausau lab, or if it's at another laboratory within one of their main evidence holding rooms.
Is that a secure location?
Yes, it is.
Who has access at your lab, at the Wausau lab?
All lab employees have access to that room.
Are there precautions taken, whether it's to prevent weather or temperature or anything else from contaminating or impacting the evidence?
The evidence is in the evidence holding room that is a temperature-controlled building.
I want to take a step back to really the initial crime scene processing. There were some footwear and some footprint impressions in different areas that we've talked about. Did you note, or were there any footprint or footwear impressions directly in front of the vehicle, the car?
Not that I observed, no.
Anything directly behind the car?
There were some impressions at the rear of the vehicle.
Do you remember if those were footwear or footprint?
I don't recall.
Okay. Nothing further, thank you.
Okay, does that conclude your direct examination?
It does.
Okay. We probably could have finished that before lunchtime. Mr. Nelson, go ahead.
Thank you. Hello.
Hi.
I want to ask you some questions about foot impressions, okay?
Okay.
I believe, is it okay if I show you the Elmo or
Whatever you want to do. Either way. Just need to give me a heads up on numbers.
number 67?
Okay.
So I want to ask you some questions about the foot impressions in Exhibit 67, okay?
Okay.
That's the marker number 1 at the scene on the muddy road, is that right?
Yes.
And marker number 2 at the scene on the muddy road, is that right?
Yes.
Those are visible on the screen right now, is that correct?
Yes.
And those foot impressions are in what appear to be tire tracks?
I had the banner pulled up because I've been editing it. I didn't see your question until now. And for some reason it didn't notify me because normally it gives me an alert and it says there's comments. So I didn't see your question until now. I just clicked on it. So yes, so the presumptive testing did turn out negative to be blood. You're correct. That's right. And I guess in my mind, right. So in other words, they are sent off, but only if it's presumptive for blood. So then that, yeah. The only testing for blood she did was the presumptive blood. And then in terms of the rest of the DNA, it's sent off if it was positive. So, and I guess that does make it tricky, right? Because like mud and blood, right? It was a muddy situation. But I'm sorry I didn't see that. I don't know why it didn't give me a notification that there was a comment.
Yes.
There's here on Exhibit 283. Have you seen this before?
Yes.
And you see here on the side, there's the brown, the muddy road. Is that right?
Yes.
And there's a label for the footpath. Is that right?
Yes.
The photos that you have of the footpath are just those two markers there, 1 and 2. Is that correct?
There's more photos of the path that are marked with individual yellow flags, but those are the only impressions that were marked with a number designation.
Okay. And so the only markers that we have, we know for sure, are in the tire path, correct?
They are on the road, right? That looks like there are some other impressions visible.
Marker number 1 is a foot impression, right?
Yes.
That's in a tire path, agreed?
I would have to look at the photo closer to agree or disagree if that is actually in a tire impression.
Handing you a copy, so you have one in your hand. Marker number 1 shows a foot impression in the tire path, agreed?
Sir, I can't agree or disagree whether I think that's in a tire impression.
Your answer is you don't know?
I can't tell from this photograph.
Okay. And same question for foot impression number 2 that we see up on the screen. That impression is in the tire track. Agreed?
The impression is in the mud. I can't agree or disagree whether that's a tire track or if I would consider that to be a tire track.
Do you see a track in that photo?
I see a lot of impressions, but I don't see an individual tire track per se.
You don't see a line from left to right going from foot impression 2 to foot impression 1 where there's an indentation in the mud that appears to be a tire track?
I see a lot of impressions above markers 1 and 2 and a line of impressions, but I can't really confirm if that is the edge of a tire impression or if that is created from an impression that 1 and 2 are lying within.
It is hard to tell.
I just simply wouldn't feel comfortable making.
I think that's fair. Like, it's clear that there's tire marks, but it looks to me like there's multiple, right? Like, it was a muddy dirt road. We saw pictures of it. It looked like there were already tire impressions before they drove through it in the mud. So it is hard to kind of tell.
in that statement either way.
Okay. On that same photo, at the top of the photo, do you see a similar indentation from left to right across the screen?
Similar compared to what?
Do you see this ridge that I'm pointing to on with the red pointer?
I do see the ridge.
On the other side of that ridge, there seems to be an indentation.
There does.
That indentation that I'm pointing to at the top of the photo appears to be parallel with the markers 2 and 1 in this indentation right here. Agreed?
They do appear to be running parallel, yes.
And they appear to be at about car width length apart.
I can't tell that without a scale within the photograph.
Okay. You would agree that tire impression in mud would be a smoother surface than the rest of the muddy road. Agreed?
Can you repeat that question?
You would agree that a place on a muddy road where a tire drove across and left an impression would make that part of the muddy road smoother than where the tire had not ridden across.
I believe it would create an impression. I don't know if it would necessarily be smoother than the remaining portions of the road.
Okay. And you don't have any photos here that you've taken or that you saw at the scene that would show impressions other than marker 1 and 2?
There were numerous overall photographs taken of the scene that documented the road, the trail of foot impressions that would show impressions that were present and no more additional close-up images.
These are the only close-ups you have?
I would have to look through the photos again to confirm that.
Okay. You were asked some questions about whether you observed other impressions at other places on the muddy road. Is that right?
Yes.
You were there at what time at night?
9:30 p.m. through 6 a.m. the following morning.
Fair to say that the sun is down during those hours?
Yes, it was.
That you were never there at the scene when the sun was up?
That is correct.
And you were asked questions about what observations you made there that night in the dark. Is that right?
Yes.
And you'd said there that night when you were in the dark, you were not able to make observations of other impressions of a body, a face, a knee, an arm, a hand in the muddy road. Is that right?
I did not notice any other impressions of that nature along that road, but I did walk the distance of that road numerous times to get supplies.
Sure.
And was assessing the road and what may or may not be present as far as evidence related to this scene.
And you agree that at times somebody could have been walking in the grass,
Yes,
and the grass portion in that area was more solid surface?
yes,
And if something had happened, there was no footpath in the grass, agreed?
correct.
Even of just a foot impression, agreed?
It would be difficult to find.
And it'd be
Right.
difficult to find if somebody fell in that harder surface in the grass and leave an impression for you to observe there that night in the dark.
Correct.
All right. So just the fact that you didn't see it doesn't mean it didn't happen, agreed?
That's correct.
All right. I want to ask you some questions about collection and swabbing, okay?
Okay.
You'd said that there's two different ways that you can test eventually for DNA evidence, is that right?
Yes.
There's one way to test. There's two ways to gather the evidence to do the testing.
Yes.
And one is for you to take a swab at the scene, is that right?
Yes.
And another is for you to collect the item itself, bring it back to the lab and give it to the DNA technicians to do that, correct?
Yes.
So I don't want to ask you about the collection in that part. I want to ask you about the swabbing portion.
Okay.
On the swabbing portion, you grab a cotton swab,
Always put it in a solo cup.
right?
Yes.
And then you make a decision about where to place that swab, right?
Yes.
It's discretionary.
Yes.
And you see a brown stain and you rub the cotton swab across that brown stain.
Yes.
Sometimes it's very particular, right?
Particular in what
In
fashion?
a position in where you swab.
Correct. It could be based on what I feel is an area that should be swabbed is up to my discretion. Yes.
And then sometimes it's a wider area that you swab, correct?
Yes.
So depending upon what you see and what you decide, you could swab a area as small as a dime-sized area,
Potentially. Yes.
or you could swab an area 3 inches by 3 inches.
It would be depending on what I'm trying to locate. I typically don't swab areas that large.
Okay, what's the largest area that you swab?
I can't recall.
Okay, and in this case, you don't recall in particular how large of an area you swabbed when you were looking at marker 13 on the side of the trailer,
That's correct.
or marker 14 on the side of the trailer,
Correct.
or the markers inside of the vehicle,
Correct.
or marker 2 that's on the rear driver's side door on the frame of the door in the driver's side, correct? We can show you a photo of that here.
Sure.
I can, you able to see marker 2 there?
Yes.
And the area to, as we're looking at the photo, to the right or to the rear of the vehicle is the area that you swabbed, is that right?
Yes.
And you're not able to tell us today the specific position that you swabbed, correct?
Correct. I wouldn't be able to tell you where within that entire stain I specifically swabbed because we don't document that.
Okay. And you would agree with me that you could swab in one space and get one DNA result, and an inch over get a different DNA result. You would agree?
That seems unlikely unless it were a sample of a mixture. When you sample or swab a stain within a scene, you're looking at areas that kind of like patterns or stain areas or locations, and then you swab and it's representative of that area. So if I would have seen additional stains within that stain, I would have perhaps pursued swabbing in a different fashion than a stain that appears to just be maybe a transfer stain across that surface. I would have no reason to believe there'd be additional reasons to swab from numerous locations within that stain.
But in answer to my question, you would agree that in certain situations, the DNA could differ from one position to another position as small as an inch away.
That could be a possibility, yes.
Okay. You talked about transfer, is that right?
Yes,
And so this exhibit that we're talking about in particular, you use the term transfer, is that right?
yes, I did.
Because that does not appear to be a drip, is that right?
That is correct.
It appears to be my layperson's term, a smear of blood perhaps from clothing?
I will say that I am not an expert in blood stain pattern
We probably shouldn't
analysis,
get
so I don't want to make conclusions regarding the types of stains. However, I am trained to recognize basic patterns within a scene.
And you used the term transfer there,
I
correct?
did, yes.
Why did you use that term?
It's because it's a very light stain that appears to have just been brushed across the surface of that vehicle.
Okay, and what you're saying is you don't know what item, whether it was a person or a clothing or something else that did the brushing, so to speak.
Correct. I have no way of knowing that.
Okay. Going to ask you some questions about the photo on the marker 3 on the back of the trunk. You see that?
Yes,
And that's the back of the trunk, is that right?
yes,
And you would agree that does not look the same as a transfer on marker number 2, agreed?
correct.
All right, and so you took a swabbing of this marker as well, correct?
Yes, I did.
And you were talking about previously that you'd seen foot impressions at the rear of the vehicle?
Yes,
You weren't clear whether the impressions were of a foot or footwear, if I recall, is that right?
that is correct.
You just saw impressions somewhere in the rear of the vehicle.
Yes,
You don't know, as we sit here today, you have no memory of where they were in relation to the rear of the vehicle.
to the rear of the vehicle, and to, I'd have to look at a directionality, closer to the driveway that is marked on the sketch.
So the passenger, closer to the passenger side of the vehicle.
Yes,
And marker number 3, you would agree is on the passenger side of the rear vehicle.
it is towards the passenger side of the vehicle, yes.
And in relation to the foot impression, footwear impression that you observe but you don't have a particular memory of today, you're saying it's behind the vehicle. When I say directly, it's somewhere within the behind the vehicle. It's not off to the side at an angle. Agreed?
It was not directly behind the vehicle, but there was a lot of activity within that, impressions in the soil or the mud at the rear of the vehicle and off to the side.
Okay.
Yep.
More than one?
Yeah.
Okay.
Yep.
And that's near the trunk area, is that right?
To the trunk and towards the passenger side. Yes.
All right. There was this stain that you observed, is that right?
Yes.
And that appears to be a drip.
A heavy concentration of blood.
Correct. And
Yes.
it's going from top to bottom as gravity would dictate?
I can't tell the directionality of
We
that.
see Exhibit 94? You would agree now, looking at Exhibit 94, that it goes from top to bottom in a manner consistent with how gravity would affect a liquid?
It is a line, a stain that's in a line
Going
pattern.
from top to bottom? Yes?
I can't really see where, if it would be an assumption to say that that would be from top to bottom.
Okay. So you're saying it could have been from bottom to top?
It could have been.
Okay.
Yeah.
You agree gravity works from top to bottom?
I do, yes.
Okay. And I didn't mean to be a smart aleck there. You're trying to be very precise with your words, and I appreciate that. Is that fair?
Yeah,
Okay. And so whether it's top to bottom or bottom to top, it's up and down, right?
yes.
Okay. I want to ask you some questions about the shoes, okay? If I could see Exhibit 75. The shoes were Exhibit 237 and 238 that we saw here in person when you pulled them out of the bag. Is that right?
Are you referring to the shoes from the scene or from inside of the vehicle?
The Nike shoes from inside of the vehicle you pulled out of a bag here, and it was marked Exhibits 237 and 238.
Yes,
The black ones, right? The
yes,
sneakers.
yes.
Okay. I want to ask you questions about those. All right?
Okay,
They were found in the back seat of the car. Is that right?
yes,
Underneath a coat.
yes,
And on top of the coat was Mr. Woodworth's body.
yes,
Okay. This impression here at marker number 5 is outside of the driver
Let me hear that.
side
part.
rear door. Is that right?
What did you say?
On the top, it's up and down, right?
Yes.
Okay. I want to ask you some questions about the shoes, okay? If I could see Exhibit 75. The shoes were Exhibit 237 and 238 that we saw here in person when you pulled them out of the bag. Is that right?
Are you referring to the shoes from the scene or from inside of the vehicle?
The Nike shoes from inside of the vehicle you pulled out of a bag here, and it was marked Exhibits 237 and 238.
Yes.
The black ones, right? The
Yes.
sneakers.
Yes.
Okay. I want to ask you questions about those. All right?
Okay.
They were found in the back seat of the car. Is that right?
Yes.
Underneath a coat.
Yes.
And on top of the coat was Mr. Woodworth's body.
Yes.
Okay. This impression here at marker number 5 is outside of the driver side rear door. Is that right?
Yes.
There's a circle I'm pointing here called E5. Is that right?
Oh, I heard
Yes.
that right the first time. So he did say that. So the shoes, well, again, Alex was kind of half in, half out of the car, but the shoes were basically still, his shoes were basically still inside the car. So the boot, well, I say his shoes. We don't really know for sure. The black Nike shoes were inside the car. The boots were outside the car. So I think what he's about to go try to establish here is that there's a footwear impression that maybe matches the Nike shoes, which would show that indeed he did get out of the car, and maybe they were trying to get out of the mud, or maybe he was attacking Ezra or whatever, right? He did get out of the car and got back in the car and then took the shoes off or something like that, right? Because again, my thought is she's got to try to establish, if she's making everything up, she's got to try to establish that he got out of that car. And that's where the shoes would come in, right? So, interesting stuff.
That's the same evidence marker 5 that we see up on the screen. Is that right?
Yes.
And that's pointing to, but follow that arrow, the position right outside the door, correct?
Yes.
And you photographed that, correct?
Yes.
And you're not able to take a cast of it because that's just outside of the ability of your lab.
A cast of that impression
Yes.
could have been collected.
Could have
Yes.
been collected.
Yes, it could.
Okay. And so you chose not to do so.
That is correct.
All right. A discretionary choice that you make on the scene.
Yes.
Okay. That's a photo of the shoe that was found in the rear footwell behind the driver's seat in the vehicle, correct?
Yes.
And as you mentioned on that photo, you observed a presumptive, or maybe a brown or a red-brown smear on the inner portion of that bottom sole.
Yes.
Did you do a presumptive test for that?
I would need to refer to my notes to see if I did or not.
Okay. Do you have those notes with you?
Yes, I do.
Do you have them up there with you?
Yes.
Go ahead. That refresh your memory?
Yes, it does.
Did you do a presumptive test of that reddish-brown stain on the bottom of that shoe?
No, I did not.
Okay.
Oh, no,
If we go back to, apologize here, Exhibit 75, marker number 5, there appears to be a reddish-brown stain in that photo. Agreed?
Yes, there is.
Did you take a swabbing of that reddish-brown stain there?
No, I did not.
Okay. You talked about not knowing about the order of the impressions or imprints in the ground. Is that right?
Right.
But you would agree with me that what we see would be the last impression. Agreed? If somebody had stepped over that, it would have disrupted that, disturbed that, not left it in that condition. Agreed?
That would be possible. If someone stepped on directly on top of the impression at marker 5, then that would have been disturbed.
Because the reason that there's an impression left is the ground is soft, right?
Yes, it was.
And so if, assuming it's someone around the same time and the ground was still of the same consistency, a person stepping on top of that would have left another impression over the top of that. Can we agree on that?
That would be very likely, yes.
Okay, and so what we can agree on, this would be the last impression into that soft portion of the ground, right?
Into that portion of the ground, yes.
Okay. And were you able to determine a directionality of that impression? Where's the front of the shoe impression, and where's the heel of the shoe impression?
There are additional photographs of that impression with a scale that would show the directionality that I would want to refer to
Refresh
speak to
your
that,
memory.
yes.
And is your memory as you sit here now that the direction was towards the rear seat of that car?
I would want to refer to my notes before I made that statement.
Okay. That's the bottom of the same shoe that we previously looked at on Exhibit 100, correct?
I just don't have the exhibit numbers memorized.
Sure,
So.
I appreciate that. And then Exhibit 102, 100 and 101 appear to be the same shoe, is that right?
Yes.
That's 102, which is the right shoe. And then we can go back to 101, which is the bottom of the left shoe.
Yes.
And then 100 is the bottom of the same left shoe with the angle that shows, can you go to 100, sir? Thank you. Which shows the reddish brown stain that there was not a presumptive test taken on, right?
Correct.
So as we're sitting here in this trial, we're not going to be able to know if that is blood and if it is somebody in particular's blood, correct?
Unless it went through further testing at a later date
Okay.
after collection.
Okay. But if my memory serves me correct, you didn't do a swabbing of that at all, did you?
The item was physically collected in its entirety, so if further testing was needed, it could have been swabbed for analysis.
Okay, and that would have been something then, since it's no longer at the scene, it would have been something that somebody like Kevin Scott would do?
Who's
know?
who's Kevin Scott, the DNA analyst? I'm sorry. I forget. Yes, a DNA analyst would perform those tasks.
Okay, all right. But as you sit here, you don't know whether or not there's any way to tell that today, correct?
Correct.
All right. Does that appear to be the same foot impression by marker number 5 that we were previously discussing?
Yes, that is the impression at marker 5.
And that has the ruler that you were mentioning, is that right?
Yes.
Based upon this exhibit, are you then able to refresh your memory as to the direction of that impression in relation to the open rear car door?
So you can see at the bottom of the scale, the arrow pointing north. North is towards the road.
Yes.
So the impression is either going towards or away from the vehicle. I'm not a footwear examiner, so I can't really conclude in what direction that impression is being. I wouldn't feel comfortable making that statement, but it is either going towards or away from the vehicle.
Just because I'm north orientated, I'm going to turn this around, and now north is to the top on the screen. Do we see that?
Yes.
Same photo, right?
Yes.
Correct. If that's north, to the left of that photo would be to the west, is that right?
Left would be west. Yes.
I screw that up all the time. So, and to the right would be east.
Yes.
To the bottom would be south.
Yes.
Okay. And so we can agree that on the left side of this photo, the shoe appears to be wider than on the right side of the photo. Can you agree to that?
I do agree with that. Yes.
Okay. And on Exhibit 285, north would be to the top of this, is that correct?
Yes.
All right, and so So both this photo and this are both to the north now, is that right? You see that?
Yes.
Okay. And so, help orientate me here. The impression we're talking about is here where my finger points. Is that right?
Yes.
North is that way.
Yes.
And then this is getting to the west. Is that correct?
Yes.
On the car is on the west side of the trailer. The
Yes.
trailer is on the east side of the car.
Yes.
Okay, thank you. Some questions about, I believe it is the back seat. Is that exhibit 107 there? So, yes? Yes, thank you. So on exhibit 107 showing marker 8, that was presumptive blood on marker 8 and marker 9, is that right?
Yes.
And then on exhibit 109, that's markers 10, 11, and 17, is that correct?
Yes.
And those are also presumptive blood, right?
Yes.
Then on marker 112, or excuse me, exhibit 112, those are markers 12, 13, and if I recall from memory, 18,
Yes.
and those are presumptive blood as well, correct?
Yes.
And then on exhibit number 118, that is a marker I can't see with my old eyes. 21 and 22 perhaps? Do you agree?
Yes.
And those are also presumptive blood.
Yes.
And so on all those last 4 photos that we saw, the reddish brown stains that we see in the entrance to the back seat of the vehicle and then the back seat are presumptive blood. Is that right?
Yes.
And then here on this photo, we see where this white strip is, a defect in the rear seat. Is that right?
Yes.
And you would agree with me that that appears to be somewhere in the middle area of the rear seat. Is that right?
Yes.
Okay.
Yes, it is.
The door that we see that's closed, that's the passenger side door.
Yes.
The perspective is we're looking in from the driver's side.
Yes.
And this defect, you don't know when or how that got there, correct?
Correct.
You just know that there's you called it a tear, I believe.
Yes.
Okay. And then if we could see, I believe, exhibit 112 again. Again, there's another defect on the rear of that seat, is that right?
Yes.
And that's again something you called a tear.
Yes.
You don't know how that got there.
No, I do not.
But fair to say that both this tear and the other tear are consistent with being punctured by a knife.
I can't make that statement.
You can't rule that out. Agreed?
That's correct.
Yes. Then I want to ask you some questions about the presumptive blood at the scene on the ground, okay?
Okay.
I believe on exhibit 72, thank you, we see, this is again the scene there, correct?
Yes, it is.
And at marker number 9, that's presumptive blood, agreed?
It appeared consistent with blood, however, did not do presumptive blood testing on the scene.
Okay. Number 9, you took a sample of it?
Yes.
And then at some point, did you test it with this, what was the fancy test that you called?
The phenolphthalein. is the
Phenolphthalein.
test.
Did you do that?
I did not. That could be a function that is performed within the DNA unit.
Okay, because you didn't take a swab there, you collected the grass, that was something for the people at the next step down the line. Would that be fair?
Yes.
Okay. And 10 and 11 are the cigarette butts.
Yes.
Okay. 3 and 4 are the boots.
Yes.
And then as we see up at the top there, that's number 12 where my red dot is, correct?
Yes.
And again, you took a sample of that, correct?
Yes, I did.
You can't say whether it's presumptive blood because you just took the sample and passed it down the line.
Yes.
All right. And then number 81, here again, this is the scene where we see number 11, which is the cigarette butt.
Yes.
Number 6, which is the navy blue blanket.
Yes.
And then again, we see number 12, which is up past the driver's door near the trailer. Is that right?
Yes.
And then on the side of the trailer is marker 13, correct?
Yes.
And you did do a presumptive, you took a swab of that, correct?
I collected a swab, yes.
And you did a presumptive blood test for that?
No, I did not.
Okay. And then here where my pointer is, that's number 14, agreed?
Yes.
And you took a swab of that?
Yes, I did.
And again, did you do a presumptive test on that or not?
No, I did not.
All right. And then number 83, this is again a close-up of marker 12 where you took the sample.
Yes.
And then number 14, agreed?
Yes.
And all of those are again documented on Exhibit 285, which is labeling where they are according to their numbers. Is that right?
Yes.
You'd agree with me that E14, E12, and E15 are all south of the open car door.
E12, 14, and 15?
12? So
Yes, they would be, the door would be open and those would be south of the corridor. Yes, I would agree with that.
all right. And then if we can go to the next one, I believe that's 88 that's 15.
Yes.
Which is, again, you took a sample of that reddish brown stain, agreed?
Yes.
And obviously we can see where that is in relation to the car because we see the front driver's side tire stuck in the mud, right?
Yes.
And it's, again, pointed out here on the Exhibit 285, exactly where that is, south of the open driver door.
Yes.
All right. So appears, if we can go back to 72, it appears as if there's reddish brown stains on both sides of that open car door, to the north, as well as number 12 to the south, and 15, which we can't even see here because it's up forward in the dark. Agreed?
Yes.
On both sides of that doorway, there's reddish brown stains.
Yes.
Okay. Exhibit 76, I want to ask you about the blue blanket. We see the marker there of 6, that's to indicate the blanket, is that right?
Yes.
This, where I'm parked on the ground, is eventually, well, that's different than 9, I apologize. Is there a sample taken of the reddish brown stain under the blanket?
No.
The blanket itself was collected.
Yes, it was.
And the blanket itself, you have no knowledge whether the blanket itself was ever tested in some way for DNA. Agreed?
Right, I don't know.
Okay. I want to ask you about the, what you call the cardigan that you pulled out of the bag earlier, okay?
Okay.
We can see that in the photo there, correct?
Yes.
And you'd pulled that cardigan out of what bag was it? I want to make sure I get this right. Exhibit 207. Sound about right?
Yes.
And the cardigan that you showed us had buttons on it.
Yes.
And it had no tears. Agreed?
I did not see any tears just looking in the room with everybody.
And it was there at the scene, correct?
It was.
When you were there, Ms. McCandless was not there. Agreed?
That's correct.
You don't have information as to what Ms. McCandless was or was not wearing when she arrived at the farmer's house, do you?
No, I don't have that
When she
information.
arrived at the hospital?
No, I don't.
Are you aware of what, if any, other clothing what, if any, clothing Ms. McCandless had that was sent to the crime lab?
I know clothing was submitted to the laboratory. However, that wasn't anything that I handled.
Okay, have you seen pictures of that clothing?
I have seen pictures, yeah.
Okay, so the item in Exhibit 619, you would agree is not the item that we see up in that exhibit, correct?
Correct.
This is, item 619 is a photo of a different gold sweater, agreed?
That looks different, yes.
Again, this photo here, marked as Exhibit 619, is different from that's a photo of a sweater that's different than the photo that you pulled out of the bag that was at the scene, right?
Correct.
Okay. And are you aware whether either the photo, if we could switch back to the PowerPoint, whether that cardigan that's in that photo there, which is exhibit 76, whether that cardigan was tested?
I don't know that answer.
And do you have any knowledge as to whether the sweater in 619, whether that was tested?
I don't know.
Want to ask you some questions about the coat, all right?
Okay.
That was in exhibit 236 that you pulled out of the bag, the big black coat, is that right?
Yes.
Had about 3, 4, 5 bags that you had to dig it out of, right?
Mm-hmm.
That was in the car, is that right?
Yes, it was.
You would agree it was not on Mr. Woodworth's person, agreed?
Agreed.
As we can see in exhibit 72 and as well as 84 and 85, he was not wearing that photo, or he was not wearing the photo. He was not wearing that coat, agreed?
He was not.
All right. The coat is, in this photo, you can't see it, but you know based upon later knowledge that the coat is underneath his body.
Yes, it is.
All right. So that's another picture. He's on top of the coat in that position, is that agreed?
Yes.
And then on exhibit 87, I believe, is where we then see the coat in that footwell, is that right?
Yes.
And the coat, as when you held it up, were you able to make observations of the defects to the back of the coat?
I did see defects, yes.
Okay. I think I asked you this, but just to be sure, we agree he wasn't wearing it, it's on the ground.
It's right, it's on the floor of the vehicle.
And underneath the coat are his shoes,
Yes.
or at least a pair of Nike shoes that we've previously talked about, right?
Right, the Nike shoes.
And those, so we agree the Nike shoes were not on his feet, correct?
Correct.
In the pictures that we'd seen previously, we saw that he was not wearing shoes, agreed?
Agreed.
And you would agree that the foot impression at marker number 5 was of a shoe rather than a foot, agreed?
It was a shoe, it was a shoe impression, or there was, the tread was visible, yes.
Okay. All right. I want to ask you some questions about the hair that was found there, okay?
Okay?
There was you said a clump of brown hair found on top of the coat that we've just been discussing, is that right?
Yes, there was.
And that's shown there in exhibit number 99, correct?
Yes.
And the sticker number 4 is actually for the coat, is that correct?
4, and then I sub-designated with the A, so that is, it is pointing to the hair as 4A.
Okay, I did not catch the A, so thank you for the clarification. So the coat is 4, and then the hair is 4A.
Yes.
All right, and then on number 98, I believe we see another. That's showing just number 4 without the A, which is designated for the coat, is that right?
Correct.
Okay, thank you. And then on exhibits 104 and 106, that's a clump of hair in the rear driver's side footwell, agreed?
Yes.
And so that would have been underneath the black coat that we've just been talking about, correct?
Yes, it would have been.
And either underneath or next to the Nike shoes that we were talking about.
Yeah, in that vicinity, yes.
Okay. And there's marker number 7 there, and that's to indicate that particular clump of hair.
Yes, it is.
So we have 2 clumps of hair, one clump designated as 4A,
Yes.
and one clump designated as 7.
Yes.
And you collected both of those clumps and passed them down the line for somebody else to do DNA testing.
Yes.
All right. And so that's another picture, exhibit 106, that's a picture of the rear passenger, or the rear seat, correct?
Yes, it is.
And we see there on the footwell, just at the bottom here, sticker number 7, is that right?
Yes.
And so it's in that vicinity where the second clump of hair was that you found and collected, is that right?
Yes.
Okay. Now, in this photo, you agree that there's no hat on the back of the driver's seat, is that right?
That's correct.
There was a hat there, correct?
I don't recall seeing a hat.
Here we go.
You were not asked any questions in your direct exam about a hat, correct?
I was not.
Exhibit 620 is a photo of the rear of the vehicle, is that correct?
Yes.
And in it, we can see the...
Council, what image number is that? Just so that I have-
Sure. 31, 620 is image 31, 621 is image 33, and 622 is image 34.
Okay, thank you.
You're welcome. So back to exhibit 620, that's the back of the driver's seat, is that right?
It is.
And that appears to be a hat that is halfway on that rear of that driver's seat, is that correct?
Yes.
And at one of the pictures I believe you have of the of the trunk, contents of the trunk, there showed the hat, is that right? Or was the contents of the rear of the vehicle, I believe?
I would have to look at the photos to see if it was collected with the contents from the rear or the front.
Sure. Found it, thank you. Showing you what's been marked as Exhibit 433. It's been previously admitted. Is that a photo of the contents of the rear of the vehicle?
Yes, it is.
And in that photo, we can see the hat. Is that correct?
That looks like the hat, yes.
Winter hat without a little bop on the top, correct?
I don't remember much about the hat, and I didn't collect it as an item of evidence, so I don't know if it had a top or not.
Okay. So no testing of that hat. But here in Exhibit 620, we see that it was partially on the back seat. Is that right?
Yes, I do see that.
And then on Exhibit 621, in the upper portion of that, we can see again the hat on the back of the headrest. Is that right?
Yes.
And then from the other angle here on Exhibit 622, we can see the hat halfway on the headrest. Is that right?
Yeah.
You don't know how that hat got to be in that position that you see it here in the photos, do you?
No, I do not.
You don't know how it got to be just partially on the back of the headrest, correct?
Correct.
Whether it was fully on before and got taken off in some sort of struggle or not, you don't know.
No, I don't know that.
But we know that it's partially on in that photo.
Correct.
You talked about concerns about contamination as part of your investigation, is that right?
Yes.
And that's because something as small and tiny as DNA can sometimes be transferred from one person to another person into a place, is that right?
Yes.
It could be transferred, that's why you wear the gloves, to make sure that if you touch the coat and then you later touch the sweater, you're not transferring something from the coat to the sweater. Agreed?
Yes, that's correct.
And it's the same thing because people can sometimes transfer, like you at this, if they're not wearing gloves and you're out at the scene, you can transfer DNA from one place to another, agreed?
Yes.
So it's very important in your line of work to make sure that you're not contaminating items of evidence, right?
That is correct.
That's like rule number one in your world.
Yes.
The most important rule, correct?
Very important, yes.
Okay. You were at the scene and you saw the pillow that was collected at the scene, is that right? Is there a pillow?
There was a pillow.
And the pillow it's marked in exhibit number 285, is that right?
The pillow is documented in the sketch, however, it was not collected as an item of evidence.
And when you say it was not collected, what do you mean by that? You left it at the scene?
It was placed into the vehicle.
Okay.
And it was documented as being in the vehicle when it came to the lab. And it was not collected. I did not consider it a piece of evidence or collect it for further testing.
Well, what somebody at the scene did is they picked up that pillow, correct?
Yes.
and they took the pillow and they put it inside the car.
That is correct.
And they put it on another piece of evidence inside the car, correct?
Yes.
That pillow could have contaminated what other pieces of evidence it was touching. Agreed?
That's a possibility, yeah.
I mean, essentially, that's a breaking of one of the cardinal rules in your world, right?
The pillow I believe I placed the pillow in the vehicle so that we didn't leave a item of evidence at a scene, as well as some deer antlers that were outside.
Oh, there they are, the deer antlers.
I didn't view it as contaminating the vehicle or any of the items within inside of that vehicle.
But you agree that there was a pillow at the scene?
There was a pillow.
Despite what you previously said, you did collect it, correct?
It was placed in the vehicle, submitted to the laboratory, and then returned to the agency with the vehicle.
This is a picture of the pillow, Exhibit 631, is that right?
That is, yes.
And this is a picture of the pillow that you took from the ground at the scene and placed on top of the painting, is that right?
Yes.
And that's exhibit number 624, correct?
Yes.
There's nothing separating the pillow from the painting, is there?
No, there's not.
So that would be breaking protocol within your world, correct?
If the pillow itself contained blood, then yes, that would. But there was no blood visible on that pillow.
Okay. You didn't test the pillow, did you?
No, I did not.
You didn't take any collections from the pillow, correct?
No.
Why the fuck would you not test or collect whatever the fuck the pillow? Like, why would you not? Like, why would you not? First of all, like, they should know this by now. Like, anything you don't do, it's going to come back and be used against you. Oh, right. Good one, Maisha. And then why, additionally, like, what's the deal with these fucking antlers? Like, were these already there? Like, were these just there from some random deer that, like, had been there? Or were these, like, in her car? You know, as, like, something she had for one of her artwork things or something. Who knows, right? Like, who knows? Because, like, just where it's situated in the pictures, it looks like it fell out of the car with some of the other shit, you know? So, so those are some other questions I have. Add them to the list, people. Add them to the list. So, yeah, all very interesting. I mean, you know, I will say for her, Ms. Hoffmeyer, like, at least she's admitting where she, you know, didn't do everything exactly perfect. You know, that's okay. I mean, it's obviously not the worst investigation we've ever seen. You know, and she was very careful about changing out her gloves and like she did a lot of things right. But that's why it's almost worse, right? And more annoying for me. When it's like, if you're doing everything fucking right, then why would you let just one stupid thing like not collecting the pillow potentially fuck it up, right? Oh God, not Bambi, no. But you know what I mean? It's like, well then that was just the one little thing. Like he's not gonna let that fucking go about the pillow.
And other than blood, there's other ways for DNA to get on items, correct?
That's correct.
DNA is invisible to the human eye.
Right.
So whether there was DNA on that pillow or not, you can't say based upon your observations, correct?
That's correct.
The better practice would certainly not to put the pillow on the painting. Agreed?
Not ideal. I'll agree with that.
Whether it did or it didn't contaminate it, you don't know, correct?
That's correct.
But that's exactly why you have the policies and procedures that you do, is because you can just never know, right?
Yeah.
That's all. Thanks.
Mr. Hahn, any redirect?
Just briefly, there were some questions, Ms. Hoffmeyer, about the lighting, the fact that you were there in the dark. Is there supplemental lighting brought into a scene when you're processing something in the middle of the night?
Yeah, occasionally additional lights will be brought in. We have lights, a lot of different lighting fixtures that we carry on the crime scene response vehicle that we can bring out to the scene, and we have a lot of really good flashlights.
Did you feel like you were hindered by darkness
I will say,
when you were processing this crime scene?
one thing I will say to the defense attorney's credit is he could have been a lot meaner about that mistake, I feel like. And he did not go nearly as hard as he, could have.
No, I did not.
There was a question or a line of questioning about the possibility of different DNA being contained in the same single stain.
Correct.
Did you see anything about the stains that were sampled in this processing of the vehicle that would have indicated that there was any reason to believe there were multiple sources of DNA?
It's something that I can't know from just looking at a stain, but as I described before, you select areas of stains that are present and you believe that those are representative of the stains in that location. And if I felt like there was a need to document more, I would have definitely done that.
You're a supervisor at the crime lab. We've established that, correct?
Yes, I am.
Are you familiar with submission guidelines?
I am, yes.
If you could explain for the jury what submission guidelines are.
The laboratory has submission guidelines for the evidence that they will or will not accept for testing. And each discipline at the laboratory has their own set of submission guidelines that they follow.
For different types of cases, are there exceptions where more items of evidence will be received for analysis than other types of cases?
The laboratory will put a priority on homicide investigations and will typically accept more items of evidence for those types of crimes.
If you're aware, was that emphasis or that exception followed in this case?
If it's pertaining to the items that were submitted for DNA analysis, I don't oversee that unit, so I'm not sure what exceptions would have been made for this case.
Those submission guidelines, while there may be exceptions made, are there, even if it's a homicide case, are there still limitations on the number of items that will be received at the crime lab?
Yes, there are limits on the numbers of
Here's
items
what I
they
think is
will
going on here,
receive
guys.
per submission.
I think what's going on here is he asked a question he didn't know the answer to, which is like cardinal rule. You don't fucking do that. Because I think what he was expecting her to say is, yes, they made exceptions and we were able to get in more evidence than they usually would let in. But instead, she was like, well, I don't know, I don't oversee that. And then he's like trying to say, like, what was it? Hold on, let me back it up a second. He flips it around. He's trying to fix it, basically.
While there may be exceptions made, are there, even if it's a homicide case, are there still limitations on the?
Right. So first he's like, yeah, so there's exceptions, and they were gonna. I think he was hoping she would say, yeah, they made an exception for us. But now when she's like, yeah, I don't know. Now he's like, oh, so are there limitations, right? I think he's trying to make an excuse for why the fuck the pillow wasn't tested or admitted into evidence. And the thing is that it's stupid. I think he shouldn't be drawing attention to it because what's going to happen is it's just going to come up on recross. And here's the thing is that it doesn't make logical sense because it was literally, if there was like a whole bunch of items that didn't get fucking submitted, that'd be one thing because then it'd be like plausible that like it was just too many. But when it's just the one fucking pillow, it's like, yeah, I don't think they were like, oh, hold on, guys, you've reached your limit. You can't you can't get this one pillow, and you know what I mean. So, not to mention, she said she didn't even try. So,
Number of items that will be received at the crime lab?
Yes, there are limits on the numbers of items they will receive per submission.
Nothing further, thank you.
All right, you recross?
While there's limits on the number of items that may be submitted per submission, you would agree that there is not a limit on the number of submissions, correct?
Can you repeat that sentence?
You just testified and told the jury that there's limits on the number of items that can be submitted to get tested per submission. I believe that was your testimony.
Per submission, yes.
But you agree that there is no limit on how many times submissions are made. Agreed?
A lot of that is handled on a case-by-case basis based on the needs that are expressed from the law enforcement agency and the attorneys on what is needed for that case. So I'm not sure if there would be a limit. There will be a time when the lab just cannot continue to test items.
Sure. But there's nothing written in the policy to say you can only make 3 submissions or 5 submissions or 10 submissions. Agreed?
Not that I'm aware of, right?
It's a case-by-case analysis, correct?
Yes,
It's discretionary.
yes,
And the agency that is submitting it gets to make a pitch to say, here's why this is important, correct?
yes, they would express the need for the investigation, yes.
And then your lab or somebody at your lab would make decisions on whether they would be persuaded to then do additional testing on that additional submission. Agreed?
They would make that determination, yes.
So you would agree, essentially, there's no limit to the amount of items that could be tested, right?
I don't agree with no limit because we can't test thousands of items of evidence due to the resources that we have within the laboratory. So there is a limit that would be reached at some point, but it's handled on a case-by-case situation.
Okay. So the limit would be something less than 1,000.
Much less than 1,000, yes.
Okay, but probably upwards, I'm sure you've had cases in which there's more than 100 items.
Yeah, yes.
It wasn't this case, though.
I don't know exactly how many items were tested within this case.
That's all.
Nothing.
Okay. All right. Thank you, Ms. Hoffmeyer. You may step down, and I imagine you're free to leave.
Yes.
And what are the issues that should be addressed before we bring the jury back in?
Your Honor, the first is the state wants to introduce as an exhibit, it's a phone download regarding text messages between Alex and Ms. Cobes. And so there's only one text message that the state intends to introduce, and it's made from February 25th of 2018, where Alex sends Ms. Cobes a message stating Jason found out and had a fit at Racy's. Ezra got stressed out and blew up at me for not talking about my past. Woke up to a text asking me to forget her name and not talk to her again. The state believes this has occurred right after the kind of Jason Mingle confrontation on February 24th at Racy's, where he confronts both Alex and John Hansen. And so I believe it falls under the statement of recent perception exception under 908.045 sub 2. It's a statement not in response to any litigation, which narrates, describes, or explains an event or condition recently perceived by the declarant, Alex, made in good faith, not in contemplation of pending or anticipated litigation, and while the declarant's recollection was clear.
All right. And you're offering it, I take it, for the truth of the matter in the message itself?
Yes.
And what about confrontation issues?
Well, I believe it's an exception because.
Well, it's an exception to the hearsay rule, but.
Yeah, and it's not testimonial either.
But, okay, so you believe it's not testimonial, that it's a deeply rooted hearsay exception?
Yes, Your Honor.
Okay, Mr. Nelson? Okay.
Please, since I just found out about this like a minute ago.
Sure.
And I just found out what hearsay exception the state is planning to go under. By the way, statement, not that it matters, but statement of perception is not considered firmly rooted, I don't believe.
It's not considered what?
Firmly rooted.
Can I respond to that?
Well, why don't we do this? Just me.
But
Oh, okay, I'm
Ready.
sorry.
I
thought
don't
you
think
was talking.
firmly rooted is even relevant anymore. But,
Well, I think it's, I guess it goes to whether it's testimony.
The thing that's really crazy is that John Hansen, as far as I know, is not a witness. And I don't know how the fuck he got out of fucking testifying, or he got out of the subpoena. I don't know how the fuck he escaped this. Because he's like, I mean, my God, I mean, he's a main character, if you will. I mean, dude. But isn't it so nuts? It's so nuts to wrap the head around this whole like love triangle situation. It's just wild. But anyway, so they're about to argue over this text message.
Testimonial or not.
well, I don't think the statement's testimonial, so I'm not objecting on confrontation grounds. I'm objecting
Okay.
on hearsay grounds.
All right.
Okay. Well, first of all, prior to the hearsay grounds, let me just say that the state has to clear an authentication hurdle. And I don't think that this witness can authenticate that this text came from Alex.
Okay.
She received a text on her.
Dude, this defense attorney, while I don't really enjoy her so far from what I've seen in terms of her with witnesses, she's fucking the boss lady when it comes to arguing this shit. Dude, I love it. It took a couple minutes of what, and I was like, oh, she's the queen. She's the queen. Dude, she argues, she's great. So, and I think you guys will see when you hear her talk as it goes on, she explains things so linearly, logically, clearly, and it's not emotional, it's not petty. It's just, she knows her case law backwards and forwards. It's really impressive. So she's starting with authentication. Here's all the reasons with this. Here's all the problems with this text message, right? Is what she's saying. And she's saying the first problem is authentication. Now, that makes sense as a really good place to start, because why? Well, as we know, how do text messages come in at trial? Well, they have to be authenticated. And in every trial, except for Karen Reed, that comes from the custodian of records, from the cell phone carrier. That didn't happen in Karen Reed, but whatever. Every other trial, they bring in Verizon, they bring in the people, and they bring in all the, and they authenticate it that way. So she's starting with authentication, which is a really logical place to start. So let's see what happens after that.
Her phone. How does she authenticate that it is in fact Alex Woodworth who made the statement? I think the state should address that, because that's a condition precedent even before we address the hearsay issue. Statements have to be authenticated to be admissible, including text messages. And so how is that matter going to actually be authenticated that it came from Alex Woodworth to Samantha? Has she gone and looked at his phone and looked at the original of the text messages? Just because a text message came from Alex's phone is not sufficient to authenticate it as having been made by Alex Woodworth. She apparently was not there. I don't know if the state is going to proffer that she had a subsequent conversation about Alex where he stated he had told her about this text, but they have to prove more than just throwing in a text message and saying she can testify about it under a hearsay exception. So before we even get to hearsay, I would like to know what the state's basis for authentication is.
All right, well, I guess I'll throw it back to the state.
Thank you, Your Honor.
And Your Honor, first of all, that goes to weight of admissibility. But if the witness looks at the other messages in the download, Ms. Koobs was planning on moving or having Alex move in with her. And so the messages before and after that both talk about making arrangements for that download, or excuse me, for that move to happen. And so the other messages before and after also provide context to the witness.
All right, well, again, until I hear what all of that is, I guess I don't know, but I think a witness with familiarity with somebody in the context of conversations they were having by text message, I think that would be a reasonable basis for authentication of a message. You can certainly cross-examine. I guess the possibility exists that somebody was pretending to be Alex Woodworth on the other end of that. But really, in the context of all of this, how realistic is that? So the court would be satisfied that the witness, based upon the circumstances, if she was a party to a number of conversations and text messages, that would be sufficient to authenticate the message. And again, you can certainly make that argument. I mean, if that is ultimately an issue in this case as to whether somebody was pretending to be Alex Woodworth, texting on the other end. But now let's get to the hearsay.
Of all of the freaking crazy ass unexpected twists and turns in this trial, wouldn't that be a crazy one? If there was some Alex Woodworth imposter and he causing all this drama?
Exception.
Well, since the state is the proponent of the evidence, I think they have some.
If that ends up being the case, I'm going to go ahead and make a hypothesis that that person is Ezra.
Duty to explain why they think it fits within this exception and what the case law is.
And, Your Honor, we did brief this in our state's response to defendant's motion in limine to exclude hearsay, where we went through the number of these exceptions, statement of Recent perception was one of the exceptions the state outlined, as well as cited a number of cases. So I would direct the defense to that brief if they want more. I think I cited to State versus Ballos, 230 with second, 2 at 507. I cited State versus Weed, 263 with second at 434.
Well, let me just say this. I know what the Ballos case is off the top of my head. That's about a 911 call in a domestic violence case. And basically, State versus Ballos stood for the proposition that it really didn't, even though it was a pre-Crawford case, that it really didn't violate the right to confrontation, and that a statement of a domestic violence victim made in a 911 call was an excited utterance exception. So it kind of preceded the United States Supreme Court rulings very much in I think it's Washington versus Davis v. Washington, and Hammond versus Indiana. I'm sorry, I'm going off the top of my head, Judge.
Yeah.
The statement of recent perception is different than the exceptions that are cited by the state. And the lead case on it is State v. Manuel, which is State v. Manuel, Manuel. I believe that is the lead case, which is cited at 275 with second 146, or the version I'm using is at 2004 Wisconsin Appellate 111. And in State v. Manuel, so first of all, it does require the declarant be unavailable, which is the case here. Furthermore, State v. Manuel said with regard to this, they held that it was a non-testimonial statement, which I concede this is a non-testimonial statement. And basically what happened in Manuel was this, and I'm just going to read the overview from the case. After a man flagged down a car, the defendant walked up to the vehicle and shot.
Slow down just a little bit.
Yeah, sorry. I'm bad when I argue. A defendant walked up to the vehicle and shot the driver in the neck.
Excited.
All right. The man who flagged down the car made a statement to his girlfriend that the defendant had shot the victim. The trial court admitted the statement into evidence. And the defense argued that wasn't permissible. So it was very much like a present sense impression, but the declarant was unavailable. And there was no other reasonable inference that the man's statement was anything other than a spontaneous comment to his girlfriend, motivated by his need to explain why he wished to take her and their son to a motel for a few days because of this violent incident that had been witnessed. And the circumstances surrounding the statement rendered it sufficiently reliable to admit it, and that cross-examining the person would be what the court said was of marginal utility. That's factually really different. I mean, the way the state wants to use statement of recent perception is to virtually admit any hearsay statement made by any person at any time, or in the context of this trial, made by Alex Woodworth at any time to any person. That's not what the rules allow for. It has to be an actual statement of recent perception. So what Alex is texting his friend on February 25th at some point in the morning, because it says that this is in UTC time, -6. So at the 1:09:40 p.m. is in Wisconsin time or UTC time? That's a little unclear to me. But what he's telling his friend, or what precedes this conversation, is he's basically telling his friend that he and Ezra broke up. And she's asking what happened, and he says, Jason found out and had a fit at Racy's. Ezra got stressed out and blew up at me for not talking about my past. Woke up to a text asking me to forget her name and not talk to her again. So this part of this statement that he makes to his friend Sam are events that occurred the previous evening. He's telling her basically that last night Jason found out and had a fit, and Ezra was stressed out and then blew up at him for not talking about his past. So those are events from the night before that he's discussing. Those are not statements of recent perception. They're nothing like the events in State versus Manuel. Now, the next part of this is that he woke up to a text asking me to forget her name and not to talk to her again. We understand that that text message in and of itself, the actual text, not Alex's discussion about it, but the actual text will be admissible in court because it is a statement of a party opponent, because it's a statement of Ezra McCandless, and they're going to be able to authenticate it. But Alex's state of mind about what she had done in terms of the text, that he woke up to it, how is that relevant to this trial, that he's telling this to his friend? Or even that he's telling his friend that Jason had a fit the night before, or that Ezra was upset about something because he hadn't talked about his past. So we first, even before we reach the hearsay issue, how does that tend to prove or disprove a fact of consequence in this particular trial? How does the fact that he communicates to his friend about waking up to this text tend to prove anything? I agree the text itself can come in. But, so I'm objecting, I'm adding a relevancy grounds and a hearsay grounds because these are not proper statements of recent perception.
Okay, State, wanna?
Yes, Your Honor, if I could, if the court would take a look at State versus Weed, W-E-E-D, 263 West 2nd, 434, 2003 WI 85. That's a 2003 decision of the Wisconsin Supreme Court.
I'm sorry,
I have to
counsel,
say-
the site is 263 with second one.
Anna, can you?
Wisconsin.
I feel like she did a fucking great job. I mean, what she says makes a lot of sense. Now, let me just clarify something here, because Wisconsin is a kind of an anomaly when it comes to how they how their court system works. So whenever you hear them say Wis Second, that's the Wisconsin Second Circuit. So normally when you hear circuit court, what you're thinking probably is federal appellate court level, right? Typically that's how it works. So here it's Wis Second, Wis as in Wisconsin. And so you might think, okay, well, if it's Wis Second, if it's a Second Circuit, well, then isn't that Wisconsin like a state appellate court? What's crazy is this is actually their trial court level. So the way that, you know, regular states have their, like the, you know, the trial court, which is just usually done by county, here in Wisconsin, not here, I'm not there, in Wisconsin, it's done by these circuits. I believe there's 69 circuits in Wisconsin, but that's their trial court level. So it's kind of an anomaly because, again, you hear circuit and it's like that's normally your federal appellate level. But here it's the state trial court level. So, but what's the other thing that's interesting about that is you don't usually hear people citing case law from the trial court level. Because why? Mandatory binding authority. You want to go to the highest level available, court level, that's on point. So it's interesting that they're not citing either Wisconsin Appellate Court or Wisconsin Supreme Court or U.S. Supreme Court or what have you. But they're all citing, you're going to hear this a lot, Wis Second, Wis Second, Wis Second, Wis Second. They're all citing these cases that are on the trial court level. So that's interesting. And I don't know, it might be, I remember learning at some point that there's something else that's funny about Wisconsin, like they don't have an appellate court level. I'll have to look into that and make sure. But I'm wondering if the reason they have it done this way, where it's the trial court level is called circuits, is because they bypass the appellate court and it just goes to the Supreme Court. Shout out to Habe. Glad you're here, my friend. So, so we shall see. But yes, I think this is really fascinating. And so now we're going to hear more from the state.
Second, 434, 2003 WI 85. In State versus Weed, 3 days before the homicide in that case, an individual made a statement. The victim made a statement to another individual saying he had unloaded the gun that ended up being used in the homicide. The court found that that statement made 3 days earlier was a statement of recent perception under the statute. 3 days, not the day before, as we have here, but 3 days before. The court said, and I quote, from Weed. And this is at paragraph 14. The circuit court admitted the hearsay statement under the recent perception exception to the hearsay rule. The exception for a statement of recent perception under WISSTAT section 908.045 sub 2 requires that.
So again, with the second circuit court, and then the WISSTAT, that's the Wisconsin statute. Oh, you heard it correctly, Maisha. Yes, indeed. State versus Weed. They're going to actually use that quite a bit. It's going to come up more than once. And I'm wondering, see, I want to look up these cases, but if they're trial court level, it's unlikely that they're going to even be available. Most trial court cases are not available, even like on your law, like your case law websites, like Westlaw, for example, because they're just not used. Now, again, if Wisconsin is just eliminated in appellate court, then that could be an exception. I'll look into it because I would love to read more about this case law. Having said that, if cases are in the trial court system or trial court level and then they've been appealed since this trial happened, then they would be even more likely to be findable. So let me do some research on that.
1, the statement was not made in response to the instigation of a person engaged in investigating, litigating, or settling a claim, and was made in good faith with no contemplation of pending or anticipated litigation in which the declarant would be an interested party. 2, the statement narrated, described, or explained an event or condition recently perceived by the declarant, and again, in that case, 3 days earlier was found to be recently perceived. And 3, the statement was made while the declarant's recollection is clear. There is no question in this case, Your Honor, under the definition and the factors set out in Weed at paragraph 14 that this is a statement of recent perception. It relates to an event that occurred the night before, the day before, and an event that occurred that morning. Clearly, those are matters of recent perception. There's no question that they are made while the information is clear in his mind because he's very clearly describing what happened. And there's no question that at the time that these are made, this communication is made, this text is sent on February 25th at approximately 1:09:40 p.m. That's the time in Central. At that time, it will be Standard Time, which is UTC time -6. That it was not made in contemplation of any pending or anticipated litigation. Obviously, Alex Woodworth could not be anticipating that a little less than a month later that the defendant would murder him, and that therefore it's important that this information get out. It's relevant because it shows Alex's knowledge that in fact the defendant had terminated their relationship, and is relevant to show that he knew that. And it's relevant towards later on, we'll hear testimony from other witnesses that Alex honored that termination, that he did not initiate communications between himself and the defendant, that the defendant then chose to initiate communication with him on March 22nd, but that Alex understood the relationship was over, and that's when he understood it was over at that point in time. And so it's relevant for that purpose. So for all those reasons, Your Honor, it should be admissible. Thank you.
Well, Judge, I want to say the following. I do believe that the state has accurately summarized the Weed case, though the more recent case on this is State versus Manuel. I don't think there's a per se time limit is like a statement of recent perception, which really, a statement of recent perception really has to kind of happen right there. Excited utterances require the stress. This exception doesn't. But it seems to me that the focus when I...
The shade. Yes, Hebe, it is. That's right. She stabbed her boyfriend 16 times. Yes, that is right. But this is okay. So you're Right. So this trial, though, has never been done gavel-to-gavel on YouTube. This is a first. This is a YouTube first. We are the first people to do it. Squirrel Crew for life, yo. So, I don't remember what year she got sentenced. Probably because this trial was October of 2019. She did get sentenced. Yes. Yes. So this is done, right? But again, this case and this trial is so fascinating to me. And again, the whole trial is not even available on YouTube. I've said this before. I don't want to be redundant, but just since we've got somebody new here, I had to go through the Court TV archives to even find it. And I didn't even know initially if it would even be available anywhere, gavel-to-gavel. But anyway, so this is the first time it's being streamed gavel-to-gavel on YouTube. So, so even for people who know this case, like I did, there's still a whole lot new going on, and it's actually really crazy and awesome. It did go under the radar. Yes, I have said as much myself. Yep. I'm so glad you're excited. Yeah, I've gotten some similar feedback as well for some people who are like, oh, I did hear about it. But yeah, it did go under the radar. It totally did. It totally did. Yeah. And when this trial happened, I wasn't even watching trials yet because I didn't start watching trials until 2020. So yes, Maisha's reminding me that she knew the case already. But again, nobody knows the half of it. And I include myself, even though I've always been fascinated by this case, because again, you'd never know it all until you watch it gavel-to-gavel. I mean, the things that I knew about this case, it's like none of them, like it's not even the tip of the iceberg. So anyway, not to mention, I'm loving watching these attorneys argue. So I was going to say something though about, oh crap, I lost my point about the case law. Let me back it up a second so I can remember what it had to do with the case law, what they were saying here. Hold on. Let me see. Oh, I know what it was. I remember my point. So the snark though, how she goes, well, the state, hold on. I don't want to mess it up. I want to quote it exactly.
9:40 p.m. That's the time in Central. At that time, it will be Standard Time, which is UTC time -6. That it was not made in contemplation of any pending or anticipated litigation. Obviously, Alex Woodworth could not be anticipating that a little less than a month later that the defendant would murder him, and that therefore it's important that this information get out. It's relevant because it shows Alex's knowledge that in fact the defendant had terminated their relationship, and is relevant to show that he knew that. And it's relevant towards later on, we'll hear testimony from other witnesses that Alex honored that termination, that he did not initiate communications between himself and the defendant, that the defendant then chose to initiate communication with him on March 22nd, but that Alex understood the relationship was over, and that's when he understood it was over at that point in time. And so it's relevant for that purpose. So for all those reasons, Your Honor, it should be admissible. Thank you.
This part here is why I backed it up.
I want to say the following. I do believe that the state has accurately summarized the weed case, though.
Oh my God. I do believe the state, listen to that compliment, putting that in quotations. I do believe the state has accurately summarized the weed case. It's like, yep, they summarize. Oh my God, dude, this is such an underhanded, like, or whatever you call it. Like, this is the shade. Dude, this is awesome. I love this. I do believe the state has accurately summarized the weed case, but then she's going to go on to say, but it's not the applicable case.
The more recent case on this is State versus Manuel. I don't think there's a per se time limit, is like a statement of recent perception, which really, a statement of recent perception really has to kind of happen right there. Excited utterances require the stress. This exception doesn't. But it seems to me that the focus, when I look at the language in Manuel, has to do with the reliability of the statement.
I appreciate y'all, because there's a lot of people who have, most people haven't. I mean, of everybody so far that I know, I mean, y'all too, I think are the only ones who've ever heard of this. Everybody else has been with us is brand new to this. So, so I appreciate y'all being Actually, I think also Andrea and Ireland knew this case. But yeah, other than that, everybody else is new to it. So yeah, she does look like a little girl. Have you seen the thumbnail where she's all like hipstered out, as it were? But yeah, this is, dude, I've been loving this because it just goes to show you just don't get. Me and Maisha were talking about this the other day, like how, like I was at least saying, like, this is kind of why I kind of moved from the true crime sort of, I guess you could call it, I don't know if you want to call it genre, but like true crime documentaries, right? This is why I kind of moved away from that into trials, because you just miss so much. You miss so much because there's so many details and that you can't possibly put it into an hour or 42 minutes or even a couple hours, right? Because one day of trial is like 9 hours, right? And yeah, anyway, so.
So, the question is partly, is Alex's statement, is there a degree of reliability and a lack of self-interest in this statement that about what happened the previous night at Racy's? I mean, we have an engagement of these different people who are in some rather intense emotional relationships. So I would argue that the portion of the text regarding that really does not bear that indicia of reliability, that the portion of the text where he said he woke up to a message from Ezra saying she didn't want to see him anymore, that, in my opinion, does bear some indicia of reliability, and I can see the state's argument for that, but the other half of this doesn't. But regardless, we still have the whole question of why is his state of mind on February 25th about what happened the night before, or his statements, how are they relevant to this trial? I don't understand the state's theory of admissibility, so I think the state should explain that and see perhaps if I'm missing something.
Well, okay, I'm ready to rule on this. The court's going to allow the statement. I believe, first of all, the declarant is unavailable, fits within a hearsay exception. It's not testimonial, and it appears.
Let's talk about hearsay real quick. So, what is hearsay? Hearsay is an out-of-court statement made to prove the truth of the matter asserted. Okay? So if it's not for the truth of the matter, it doesn't matter anyway. Then it's, sorry, pun not intended, but pun. If it has to be proved for, it has to be for the truth of the matter, right? So if somebody just says something like that's why you'll hear them talk about that, right? It's not for the truth. Sometimes they'll say it that way. So there's a lot of exceptions, right? And one that we don't hear so often, but I'm sure it comes up, and we just don't hear it so often, is declarant unavailable. But we're hearing that a lot in this particular trial, declarant unavailable. So who is the declarant? The declarant is the person who made the statement. Now remember, it can be written, it can be verbal. So the declarant, being the person who made the statement, is unavailable. Now, why does that matter? Well, because if the person who made the statement can be cross-examined, then it's different, which is the reason why one of the hearsay exceptions is a party opponent, because a party opponent is automatically at the trial and is in a position where they can be cross-examined. So if the declarant is unavailable, and another good example of this is in the Murdaugh trial, they were able to get around a hearsay objection with Maggie because of the fact that she was unavailable, and it went to her, something went to her, I forget what it was. It was something that went to her state of mind. It had to do with Blanca when they were doing her proffer. So it went to her state of mind, and because she was unavailable, that was a way that they were able to get that testimony in. So, oh, I think I've missed a couple questions. Hold on, let me just see something real quick. What do you mean by this, Maisha? You can voice chat on Discord. You can even just send a message with your voice. People do it all the time. If you're on the Discord and you see DSN, Daddy Shortnuts, he does like daily jokes using the voice thing. But you can also voice chat, but I'm not sure what you mean by that. Anyway, so right. That's correct. And it's right. It's not provable. Right. That's the whole point. Because again, the whole thing with law is cross-examination is how you get to the truth. That's why being cross-examined is the point. So the reason the person needs to be present is so they can be cross-examined. That's right. What did you mean? This one I have pulled up on the screen, though. I'm not sure what you meant, though, Maisha. I think I explained that you can voice chat on Discord, but I don't know what you mean by explaining true crime. Was someone asking what true crime was? Because I know sometimes messages don't pop up, so I don't know if I missed something or if it just didn't come through. But yeah, you can do that. You can do voice calls on there. You can. You can do it. It's totally doable. But I don't know what you wanted to explain though about true crime. I mean, like, I guess, I'm just saying it. I'm saying it because I know that there's people that understand that as being a genre, right? I would put live trials not in true crime because in my mind, the way that true crime has been differentiated is more like a narrative along with it, right? And usually like a documentary form where it's like, it's outlining the case, right? Like, here's what happened. I mean, and I'm subscribed to a lot of true crime channels on YouTube, I still really enjoy a lot of them, but I will tell you that it still doesn't give you the same as watching the entire trial. What I like to do is I'll watch, if a trial has already happened, then I might watch the true crime sort of like synopsis, maybe like before I watch the trial or something. I mean, I don't know how to say it. I'll watch both. Like, how to explain. In my mind, it's not a substitute. Let me put it that way. Like the true crime, even if it's a really great channel or whatever, in my mind, it's not a replacement or a substitute for watching the whole trial, but it might be something you watch in addition, at least for me, right? In addition to. Usually I won't want to do it after because then I'll just be like, oh my God, they just left out so much stuff. So I don't know, but, oh, thank you, Haby. Well, I appreciate that. Yeah, I don't know where everybody's been tonight, man. We've been missing a lot of people. I don't know if it's just because like school's getting started or what, but there's been a lot of our normal regulars who haven't been here. So I think that's probably part of it. We've just had less people. But yeah, so, and I'll give you an example, like with Murdaugh, right? I can't even watch any Murdaugh true crime stuff. I can't. Like, it's just, even one of my favorite true crime people, which is how I actually learned about this case in the first place. I've been following this channel on YouTube since they first started. And they finally did a Murdaugh one recently, right? And it, they've probably been working on it for years, and that's why they only just now did it. Dude, I made it like 10 minutes in, and I was like, I can't, because they were getting so much stuff wrong. Like, that's the problem, right? Because like, as y'all know, I would consider myself like a Murdaugh scholar. Like, I know that case and everything about that entire fucking thing inside and out, I would say, more than anybody should, It's why I did the deep dive. People are still telling me I should probably write a book. Anyway, but it almost ruins it anyway, because it's like, anyway, I know when they're getting shit wrong. So, right. And the thing is not every trial is available to watch. I mean, that's the other thing. Like, that's when I will say, like, there's some, like, for example, which one is it? Like, Casey Anthony would be an example of where that trial's not available that I know of. So that would be a good example of when, older trials that weren't televised or ones that just, they didn't allow cameras or whatever. Yeah, then that's completely different. But Yeah. Well, hey, B, if you want to know what happened after that, I put out a video actually earlier today, with updates. You would probably be missing a good chunk. Did you watch the evidentiary hearing with Justice Toll? Yeah, I can tell you everything you wanted to fucking know about that. So I also have covered, dude, I cover everything in Murdaugh, like as much as I can. So like I've also covered Miss Becky. She got her ethics violations. I forget how many it was, 70 something. I've covered that. Like I have a playlist called, what is it called? Murdaugh, the Neverending Story. And that's all the that's all the Murdaugh videos that are not the actual trial. So that has like the Miss Becky, that has the evidentiary hearing, that has the video I made today, which is updates out of like Hampton County, including Alex's appeals. So like, yeah, I have the two Murdaugh playlists. One is the Murdaugh Murders Trial Series, which is the trial, Gavel-To-Gavel, obviously, right? And one of my proudest achievements, as you guys have heard me say a bazillion times. And then I have the Murdaugh, the Neverending Story, I think is what it's called, which is everything. It's not the trial. Oh, sorry. I forgot. I have a third playlist that's Murdaugh related, and that's called Gloria Satterfield, The Fall That Started It All, which we still have to finish that series. But that would be my other. So I have 3 Murdaugh playlists. Am I forgetting one? Is there a fourth? There might be a fourth. Shavy says, you're sending me down a YouTube rabbit hole. Keep me up nights due to obsession. Thank you. You're very welcome, dude. And if you want, I've said it before, I'll say it again. I recommend to everybody watching the Murdaugh deep dive, as I've, just explained it real quick. Like, the first couple episodes, I started out doing like with EDB, and then by request of the chat, people were like, oh my gosh, like we want to hear you. It's hard with you and her talk. And then I started doing, that's how I ended up doing it without even EDB. Like, this has just happened over time, right? Because I started out with like the We Heard stuff because of the challenge from her channel. Anyway, but boy, as we go along in that trial, man, dude, it's epic. It's epic. I feel like we really solved all of the mysteries, actually, and there were a lot, and we went through it step by step. And I'll tell you, man, I didn't sleep. I like barely slept, right? Because my mind was just trying to solve it. And I would just walk around my house pacing and just trying to work it out in my head. And it's like a puzzle. And everybody that was there for that deep dive said it had the same effect on them, like in a good way. Like they were having to really think. And we were all here watching this trial, even though everybody had seen it before, and we were all trying to solve it, because all these little details, man, we left no stone unturned. I guess I'm getting goosebumps just thinking about it. Honestly, it was so great. It was so great. It really challenged everybody. And it was also really fucking funny. We had a lot of inside jokes from it. And there was a lot of laughing, just a fuck ton of laughing. Anyway, so yes, but I've got you covered for Murdaugh. And the thing is that with this trial, I know you just joined us recently tonight, Hebe, but I'm doing a similar format where as I'm going through it and I'm coming up with more questions, I'm adding additional presentations in, like I ended up doing with Murdaugh. So, and this episode, we've got some of those, like we've got What the Muck and Hipster Business. And I've got another presentation we haven't gotten to yet that we will get to when they do their end of day housekeeping. So it's like there's going to be adjacent sort of like projects that go along with it, where it's like an ongoing thing trying to solve this particular question, if that makes sense. So it's kind of a unique way to do a trial. But it was great with Murdaugh because it's like Gavel-To-Gavel trial plus deep dive plus like solving the mystery, like playing detective. It's like all of the things. It's just great. Yeah, I know. And the thing is the public, like legally, right? Oh, It's a House. Maisha, It's a House. So by the way, the story from that's from, you only play that. It's a House. Yeah, that's where it's one of many. Where the fuck is it? Hold on.
It's a house.
That's from the 911 call. Sorry, didn't need to put that on repeat. That's from the 911 call. I clipped that from the 911 call. And by the way, I did a great breakdown of that 911 call as well. We noticed so many fucking things nobody noticed. It's pretty insane, actually. But yes, trials are public. And I was actually just thinking about this. Oh, what was it about? Oh, fuck. There was something that happened just yesterday, maybe, that really got me riled up about the importance of this, even though I already know it's important. But, you know, they're public. Oh, somebody was trying to, hold on. Who was it? I can't fucking remember now. But it really was like, somebody was trying to say something that was like going against it. But basically, trials and court documents and all that, I mean, it's all public. It's public record. And unless it's sealed, right? Like by sealed, I mean documents or a sealed hearing or something like that. But it's public record. The public has the right. And so, you know, beyond the fact that I enjoy watching trials and covering them, it is really important. Like, boy, our constitutional rights, man, that's what I think. That's one. Is that what I was thinking about? Right. I was thinking about right yesterday. I think it was. I was going down a whole thing about our constitutional rights. I say a whole, like in my head, right? Thinking about how much more important. Right. Okay. Hold on. I'm remembering now. So it was, I know what it was. It was the presumption of innocence. Yeah, that makes sense. As per usual, I was thinking about the presumption of innocence, okay? And the Sixth Amendment. And the thing is that I was thinking about the founding fathers, right? Here's what I've been thinking about. I've been thinking about this a lot lately. I've been thinking about the founding fathers and how they had the foresight somehow to imagine what would happen if the Constitution was not written as it's written. And here's why I was thinking about this, because there's a common thing I think about a lot, which is this, what's the way to put it? There's an oxymoron. It doesn't, I mean, it's a logical fallacy, okay, with the government, because there's a presumption of innocence, right? And I've talked about this before on other live streams, but there's a presumption of innocence. However, it doesn't, here's why it's here. Okay. The government is supposed to have the right person, right? Like, for example, what is being asked of the citizenry is to give a presumption of innocence to those who are accused of a crime, but to also trust that the government has the right person. Why? Because otherwise it would be a disaster. Everybody would be out on the street. Like, can you imagine if imagine if the presumption of innocence, if every single person actually genuinely believed that, then imagine what that would mean, because then the citizenry would imagine that the quote unquote bad guy or whatever is still out there, right? That the person is still on the loose, that they don't have the right guy. So the problem is that the government needs the citizenry and the public to feel safe. And the only way they can do that is to be like, yeah, we have the right person. You guys are all safe. But the problem is that completely contradicts the presumption of innocence, doesn't it? And this is why I have problems. I cannot handle thinking like that. Like that bothers me, because it's like they want people, it's like gaslighting. It's like they want people to believe both things at the same time when they're directly contradictory. Like they cannot both be true. They cannot both be true. Otherwise, the presumption of innocence is just a formality. That's the best case scenario is, okay, let's say they have the right person, but then the presumption of innocence isn't real. It's a formality. And that makes me feel so ill, because that's not what the founding fathers intended. And here's what I was thinking about is that with the founding fathers and the Constitution, Sixth Amendment, they had the foresight to predict like these very issues. that the government would end up with gaining so much trust from the public that they have the right person, that they're doing their job or whatever, that what would happen is the government would not remain checked. And you can see examples of that, like with Karen Reed. You can see examples with that, like out of Georgia with the young thug RICO trial. There's tons others, right? You know, Delphi, like where the shit they're getting away with in Georgia, by the way, is just bizarre. But anyway, I mean, it's like you can see why the founding fathers wrote that shit into the Constitution. And I'm not even going to get onto my whole thing about the importance of defense attorneys, but obviously none of it will be protected. Our rights would not be protected were it not for defense attorneys. And that's the thing. It sucks, but the prosecution does not have our rights in their best interest. They just don't. That's not their job, sadly. It's the defense attorneys that do. Anyhow, so, but all that to say that part of the founding fathers and the Constitution and the rights, we have a constitutional right to a public trial. That's where I was going with all this, right? So, like, that's part of it, right? Think about it, guys. This matters. Like, the founding fathers had the foresight to be like, the public's going to need to be there to make sure the government is not fucking around. The public needs to be able to see the trial. Man, isn't that just so powerful, though? Like, and here we are in 2024, and it still matters, and people are still fucking around. And it's like, you know, it's just, they had a crystal ball, I feel like. But yes, completely agree. The public needs to see these. Right. It's so true. It's so true. There was another trial. God, which trial was it? There was another one, this was today, I think, where there was a quick little synopsis on Law and Crime or something like that, right? You know, I think it was Law and Crime. And they were giving a little synopsis of some case, and it was I don't remember what it was. It wasn't Murdaugh, but it was some other trial that I followed Gavel-To-Gavel, and I followed a lot of them, so I don't remember. But like, and they fucking got basic details wrong. And it's just like, you know? So it's just, but yes, and yeah, Sarah Boone. Dude, that's going to be fucking interesting, though, to see her defend herself. It's going to be interesting. I'm excited for that trial. I'm way more excited than if it was, I mean, I would have watched it regardless, but like, man, I'm even more excited now. That's going to be really crazy. So, yeah, and the other thing is, like, I have to say, shout out to South Carolina for, like, they're actually doing the work in terms of the corruption. Like, there's been a number of, like, different, like, police officers and shit like that have come out with, like, doing some stuff. And anyway, they're firing them, they're getting rid of them. It's just so different from, like, what we see in Massachusetts. And anyway, but oh, the ad is hilarious. I know it really is. Her handwriting is on point, though, isn't it? But I don't know. I just think about these things. It's the shit, you know. It's funny. Like, you learn the Constitution in, like, elementary school and stuff, and it's like, whatever, right? It's so funny how everything comes full circle, because it's like, I feel like just recently am I only just now understanding the weight of it. The weight of the fact that the people who wrote it could look into the future, right, inside their minds, and imagine the problems that would happen with the government. Because the Constitution is to protect us from the government. And I'm not anti-government by any stretch, like that, obviously, right? Like, I'm not, but I'm just saying, like, that the significance of the Constitution in terms of, and especially in a way that it's so poignant, it's kind of easy to miss, because it's just like, oh, the Constitution, right? We've all heard of it since we were babies. You know what I mean? Like, it's just like so normal and blah, blah, right? But if you really think about the point of the Constitution and, you know, and what it says and what it does and how it is the highest law of the land in the US. Like, the US Constitution is the highest authority. And it's our rights. And yeah, exactly. Yep. I know. And it's just, it's like, I almost feel sad that for so long I didn't give it the credit it deserves, you know? I really, but really, I don't know that I would have really fully even grasped the significance of it were it not for studying law and therefore the Fifth and Sixth Amendments, right? I mean, and the Fourth Amendment and other ones, but mainly I would say you guys hear me talk about the Fifth and Sixth Amendments a lot. And I think they're just really fucking important. And, you know, just while I'm on this topic, kind of don't ever talk to law enforcement without an attorney. I don't care. I don't care what the circumstances. I'm sure you guys have heard that before. It's the type of thing that needs to be just drilled into everyone's head, including my own, because when you're in that position, it's going to seem like the right idea. Don't ever do it. Don't ever do it. Don't ever do it. Don't ever do it. You only need one word, attorney. That's the only word you need to know, guys. Attorney. So yeah, so checks and balances, absolutely. Yeah, it's just because the thing is you look at these other cases, like out of like Karen Reed and Delphi and the RICO trial, and it's like they would just fucking charge a tree stump, right? If there was nobody stopping them, they would just charge a tree stump with murder. You know, why not? The only people fucking stopping them are the defense attorneys. It's crazy, right?
So the court, in the Manuel case, so you're talking about present sense impressions, a different hearsay exception that was involved. This is a statement of recent perception. The court believes that it's sufficiently recent, and also that for those other reasons, it is not in response to any investigation or a claim, and it does narrate or describe a recent event. As to relevancy, I think it goes to the panorama of the evidence, the context of the relationship between Ms. McCandless and Mr. Woodworth, Mr. Mangle, and all of those circumstances. It's part of the overall puzzle of what has occurred in this case. The court believes it is relevant, so we'll allow that through this witness, again, assuming that the authentication is sufficient. Mr. Nelson?
Judge, I understand Your Honor's ruling under 90107, rule of completeness. We'd ask that the previous 5 text messages also come in. The conversation begins at time step 1, message 30, in which Alex says, things just went really bad between us, and I don't think she is going to be in town again. And then Sam says, oh fuck, what happened? And then he responds with the message that we're talking about. So I think from the rule of completeness standpoint, I think those previous messages in which Alex begins by saying, things just went really bad between us, and I don't think she's going to be in town again, would also then be admissible.
All right, well, does the state have any objection to that? I certainly...
No.
Okay, the court believes that the entire thread there for the rule of completeness should be included. Okay, so are we ready to bring the jury in, or are there any other...
Sorry, Judge, there's one more issue. Yesterday, there was some questioning regarding opinion from the defense relating to Jason Mingle, and they cited 906.16, bias of witness. And so I guess the state's concern is, yes, the defense can ask a person if they have, bias, but it's limited to any party to the case. And Mr. Mingle's not a party to this action. So I just don't believe that asking opinion related to what a person may think about Jason Mingle is relevant.
Well, at least, I don't know if we're going to go back to argue about that yesterday, but as I understand it, Mr. Nelson was trying to connect Ms. McCandless to Mr. Mangle, and I assume if there's bias against Mr. Mangle, there may be bias against his girlfriend as well. Maybe that was his argument. I don't know. But we didn't get there. We didn't go there because she wasn't aware, that witness wasn't aware. But that's yesterday. That's water over the dam. So,
sure, Judge, I just wanted to, in case it was brought up, I would be objecting. So I wanted to just.
All right. Well, certainly any evidence of bias against Ms. McCandless would be fair territory.
Correct.
Okay. Anything else?
Yes.
Yes.
Because I'm assuming we're going to run through several witnesses quickly, and based on what the state list is and what they asserted and what occurred yesterday, the state is taking the position, I believe, and they should correct me if I'm wrong, that they are entitled to bring out character evidence, opinion or reputation evidence as to whether or not Alex Woodworth was a peaceful person because the defense raised it in its opening statement. And I do agree that that's actually a fair statement of the law. There's case law on that. However, character evidence for reputation and opinion is extremely limited, and the kinds of questions that were being elicited by the state yesterday were totally improper. And all the state may do in character evidence under 90404 and 90405, which are that the character of a victim, which is allowed, the peacefulness of the victim, often by the prosecution in a homicide, to rebut evidence the victim was the first aggressor. So first of all, that's allowed. And second of all, the method of proving character under 90405 is strictly by reputation or opinion, and the statute states, in all cases in which evidence of character or trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct. In State v. Jackson, 2014, Wisconsin 4, which was a first-degree intentional homicide case, there is an extensive discussion about what foundation needs to be laid and what is permissible under 90405. And the Jackson case is very instructive at paragraphs 66, 67, 68, and 72. And in paragraph 72, I'd like to read from that case because it specifically discusses what the foundation is for character evidence that has to be made. The foundation for reputation is deliberately simplistic. Properly framed, the reputation testimony can be elicited in less than a minute. The streamlined foundation befits the evidence modest probative value, citing Dan Blinka's treatise on evidence, and I'm sorry, I'm not seeing the actual underlying treatise, but it says a proper foundation for reputation testimony requires showing 4 elements. 1, the witness belonged to or is knowledgeable about a community to which the subject belongs. Number 2, the subject has a reputation for a particular character trait, meaning that it has been the subject of discussion among that community. 3, the witness knows the reputation. And 4, the witness testifies to the reputation. So it's basically a 4-question examination. The court earlier says at page 66, 66, reputation testimony, and the same is true of opinion testimony, is one form of hearsay in which a witness will testify about the subject's reputation within the community. And then it defines opinion testimony. Opinion testimony permits the witness to testify about his or her own opinion of the subject's character. Neither reputation nor opinion testimony include evidence of specific instances of conduct, except perhaps in cross-examination or rebuttal. Reputation and opinion testimony, the court goes on to say, have significant persuasive limitations before a jury because they tend to be of a sweeping and conclusory nature. Reputation testimony in particular has been aptly but disparagingly described, disparagingly described as, quote, irresponsible product of multiple guesses and gossip, again citing Dan Blinka. This type of reputation evidence does not permit the jury to hear about specific acts. In this case, the counsel for Mr. Jackson, who happened to have been me, was trying to admit some specific acts of conduct to show that the decedent had a reputation for violence. And the court disallowed me from being able to present that evidence because Mr. Jackson didn't know about these things. And the only thing that could be brought in was if the foundation could be laid, would have been these 4 questions. Are you part of a common community or a describable community you're part of? Has there been talk about his reputation for violence? Does he have a reputation in this case would have been violence? For them, it's peacefulness. And what is do you know the reputation? What is the reputation? So if they want to ask those questions of these witnesses, that's fine. But the questions that were being asked yesterday were much more like, what kind of person is he? So if they want to say, do you have an opinion, lay the foundation, how long they've known Alex Woodworth, do you have an opinion as to his character for peacefulness? And the witness can say, yes, they have an opinion. They can certainly say, what is that opinion? If they can demonstrate that the witnesses have discussed that among each other and that they're part of a common community, then they may ask about what people have discussed, what not specific facts, but what is his reputation. But they cannot go farther than that. It's clearly objection.
Let's stop there.
Thank you.
Does the state disagree with that characterization?
Yeah,
I have never heard anybody actually say that. Like, I'm not saying she's wrong. I'm sure she's right. I've never heard any other attorney bring this up about this idea that you have to have these 4 factors and it has to be like a thing about the community. Like, oh my God, like, it's just weight of like, dude, she knows her shit. She knows her shit.
I do and I don't. All right. The problem with that characterization is that the statute specifically allows, if you look at 90405, it allows reputation, it allows opinion to prove character, and it also allows specific acts of conduct or specific instances of conduct to prove reputation. If you look at sub 2 of 90405.
All right. You know, what a great idea. Let's do that. You know, it's like, now that you mention it, where is it? Here it is. All right. What do the statutes say? So let me pause this really quick and let me look. So there was something I was going to look here for. So hold on. So there is still a Court of Appeals. Interesting. Let's see if I can find. Oh no, that won't work. Interesting. So that, hey, that State v. Weed case it is. So remember what I said? That's so funny. Remember when I was like, you know, if they have a case that was trial level then, but is in the Court of Appeals now, we might be able to pull it up. State v. Weed looks like it's going through the appellate system, so we might be able to actually look at it. But before I go on to that, let me stick to what we've got going on here. All right. So WIS 904, WIS 90404, WIS 90405. What are they talking about? Let us see. So 90404, character evidence not. Now remember, these are always based off of the federal, right? So when we think of federal, it's what, 404, right? 403 and 404. So this is 90404 and then 90405. So similar numbers, right? But character evidence not admissible. So the character evidence in terms of the federal rules of criminal procedure, character evidence is 404B evidence. But anyway, so character evidence not admissible to prove conduct, exceptions, other crimes. So 1, character evidence generally, evidence of a person's character. Now, here's what they're talking about, because remember, typically in trials, what is the reason this would be brought up is because somebody's trying to make it seem like the defendant is bad, right? Here, it's a kind of an interesting situation because they've got Jason Mengel, who's not a party to this case at all, and you've got, or sorry, that's not what it's about. They're talking about Alex Woodworth, right? That his about his character of being peaceful, right? So it's like the opposite of what it's usually used for. So evidence of a person's character or a trait of that person's character is not admissible for the purpose of proving that the person acted in conformity therewith on a particular occasion, except one, character of the accused. Okay. Evidence of a pertinent trait of the accused character offered by an accused or the prosecution to rebut the same. So they're saying that you can I guess what they're saying is if you're the one who's accused, if you're the defendant, you can offer evidence of your own character. That would make sense, I guess. A character of victim. Interesting. Except as provided in blah, blah, evidence of a pertinent trait of a character of the victim of crime offered by an accused or by the prosecution to rebut the same, or evidence of a character trait. Oh my God, there it is. Peacefulness. There it is. Holy shit. Evidence of a character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor. Well, shit, there it is. There it is. That's literally what they're arguing. Yeah, that's an exception. Absolutely, that's an exception. Yeah, there's no way around it. That's clear as day. Can you guys see it? That's 90404B. Done. Done. And then let's see, subsection 2. This is what Mr. Oh my God, what's his name? Dufour was just saying. He was just citing this one. Except as provided in paragraph 2, evidence of other crimes, wrongs, or acts is not admissible to prove character of a person in order to show that the person acted in conformity therewith. This subsection does not include evidence when offered for other purposes such as proof of motive, opportunity, intent, preparation. Yeah, that's what he was just saying. And then there's the greater latitude. Okay, now let's go on to 90. So that 90404B is really important here. And then let's go on to the next one. (90405) methods of proving character. 1, reputation or opinion. Now this is like what the defense attorney was saying. Remember when she was like saying how you have to have the community opinion type thing? In all cases in which evidence of character or a trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct, okay? And then specific instances of conduct. In cases in which character or a trait of a character of a person is an essential element of a charge, claim, or defense, proof may also be made of specific instances of the person's conduct, okay? All right. So we have these are what they're talking about. So now we know. Let's see what else is on here. Here we go.
It's a house.
Classic. Okay, so now let's go back to our episode here.
As in cases in which character or trait of a character of a person is an essential element of a charge, claim, or defense, proof may also be made of specific instances of the person's conduct.
That's literally, dude, y'all. Literally the sentence I just read. That's really funny.
And it's our position that obviously because of the allegations of the defendant, as it relates to Alex, that his peaceful character is a
100%
essential element of the claim in this case that the defendant murdered him.
Yes.
And it's made
It's clear as day, like I said, 90404B, clear as day.
that by the defendant's allegation that, in essence, that he is the initial aggressor.
The defense
And
is gonna
so,
have to,
yes, we can
the defense is going to have to concede on that. There's no way around that. That's clear as
prove
day.
by specific acts of conduct. And if you look at paragraph 68 of Jackson, it says that's something that the court needs to take a look at and can consider as long as it is part of that. Jackson eventually found out that because of the fact that Jackson was not aware of those conducts and the purpose of the admission of them was solely for McMorris evidence, is what the court looked at it under and looked at it under the McMorris standard, that those were not admissible in that case. But in this case, we believe that specific instances of conduct showing that he is are certainly admissible in this case because they tend to show the defendant's character for peacefulness under the circumstances. We also, and certainly counsel is right, we can ask them if they have an opinion. We can ask them how well they know them and what their opinion is as well. And I believe the specific instances of conduct are admissible because of the fact that it is an essential element of this offense.
Now, how is Mr. Woodward's character an essential element? There are two elements to first-degree intentional homicide. Element number one, the defendant caused the death of Alex Woodworth. Number two, the defendant did so intentionally. And in fact, a more complete...
This is actually exactly my point. This is what I was just saying. Listen to this.
reading
I would like that.
of the Jackson case.
Sorry. Like I was just saying, it's clear as day from the statute that they're entitled to bring this evidence. However, the problem is he kept talking and now he gave her something to argue, even though it's not really what the point is. But she's totally fucking right. Hold on. Let's listen to that again.
But in this case, we believe that specific instances of conduct showing that he is are certainly admissible in this case because they tend to show the defendant's character for peacefulness under the circumstances. We also, and certainly counsel is right, we can ask them if they have an opinion. We can ask them how well they know them and what their opinion is as well. And I believe the specific instances of conduct are admissible because of the fact that it is an essential element of this offense.
No,
Where he fucked up was he said the word element. Had he not said the word element, this would be a different argument from her. She'd have something else on already, but it would be different. He said element, and now he's toast because he's right. She's right. He said element. Element of the crime. She's about to outline it for us.
how is Mr. Woodward's character an essential element? There are two elements to first-degree intentional homicide. Element number one, the defendant caused the death of Alex Woodworth. Number two, the defendant did so intentionally. And in fact, a more complete reading of the Jackson case clearly shows that it is not an essential element, reputation or opinion evidence. The specific acts of conduct are in the province of the defense. We can cross-examine these witnesses about specific acts of conduct about Alex Woodworth, but it is not an element of the defense, nor is what they know about his character a specific element to even a lesser included of the defense. The state has the burden here of proving an intentional homicide occurred, or perhaps if lessers are submitted to this jury, and they're certainly being requested, the state has further burdens to disprove Miss McCandless's beliefs and the reasonableness of her beliefs. That's not an essential element because those things go to her state of mind. What other witnesses say about Mr. Woodworth's character does not go to Miss McCandless's state of mind in any way, shape, or form. So they are limited.
Also, but I think you're conflating with Morris evidence with the character for peacefulness that's allowed.
Like I said, she went off on a different train because he said, Mr. Dufour said elements of the charges and that started this whole thing. But this is not really what they're arguing about.
When there's a claim that the victim was the first aggressor, I think they're just different situations. It doesn't matter, in the court's opinion, it doesn't matter whether Ms. McCandless was aware of that instances of peacefulness and so on and so forth. It's just different. And so, she makes her claim of self-defense based upon, what she will testify to, and the court's allowed quite a bit of latitude, other knowledge of Mr. Woodworth and his writings.
So they've already made an agreement that she's going to testify. That was obvious because of the opening statements, but the judge just said that she's going to testify. So.
Other situations and so forth. But that's different. That goes to her state of mind and when exercising what she claims is exercising the privilege of self-defense. This, in the court's opinion, is different. once a claim is made that Mr. Woodworth was the first aggressor, then I do believe the state is entitled to go forward with both opinion and reputation testimony. Now, in sub 2, the specific instances of conduct, I don't know, is there anyone aware of any particular authority where this issue has come up? Mr.
I'm sorry.
Are you aware of any particular authority where this type of situation has come up?
I'm not aware of any off the top of my head, Your Honor, no.
I did find something, but quite frankly, it's from 2001 and it's unpublished, so I was not citing it to the court.
It's too old.
It's too old.
Too old for unpublished.
Too old. So I'm not even going to say the name of the case. I was all excited when I read it, but now I'm very unexcited.
Okay.
Judge,
Go ahead.
I might have a case here. Just give me 30 seconds.
Which case?
Judge State v. Evans, 187 Wisconsin, 2nd 66.
I should Joy can get that.
You said Evans?
Evans?
I'm sorry, what was that site again?
EVANS.
Correct, Judge.
That's 187 was second 66.
And this was a case in which the defense was prohibited from bringing in specific instances of conduct in their direct exam of a witness. So while it wasn't the state, it wasn't this reputation for nonviolence, it's the same situation in that it was somebody who was trying to bring in specific instances of conduct as a part of the direct exam of their own witnesses. And the court made rulings based on facts in that case that could not be done on direct. For the reasons in that case. I mean, I don't want to...
Well, let me ask you, does the state have specific instances of conduct that it is intending to offer, or is the state plan to stick with reputation?
Well, I think, I mean, one of the things that we will intend to introduce is through Court Fox, that they had specific discussions about the issue of self-defense, that Alex Woodworth and he, in the context of having observed videos relating to some protesters and counter-protesters where there was some fighting, they had some discussions about the philosophical morality of self-defense, and that Mr. Fox had the opinion that it was okay to use violence in self-defense or defense of others, and that Alex Woodworth expressed that he did not believe that you could use violence in self-defense, but he could potentially see himself using violence in defense of another. So I don't know if that's a specific instance of conduct. I think it goes more towards the basis for Court Fox's opinion.
I would have loved to have been a part of that conversation. I can just picture that, dude. That was two people. I mean, I'm guessing Court Fox, we hear his name a lot. And this is another one of those witnesses that is not on YouTube. No one I've never seen this testimony. I keep hearing the name, so I assume this person testifies. But again, because the whole trial's not been on YouTube, I mean, it's crazy. So, but Court Fox sounds like he was a really good friend of Alex's, and then they had these specific conversations. And one of them was about when can you use self-defense, which is just so fucking interesting to me and fascinating. So, yeah.
To an extent, as to why he believes that Alex Woodworth has a peaceful character, but I don't know that's actually a specific instance of conduct.
Right. Well, what about with Miss?
Oh my God. Why does he have such a tiny cup of water? Hold on. Why does he have such a tiny cup?
I believe that you could use violence.
Give him a regular sized cup, people.
In self-defense, but he could potentially see himself using violence in defense of another. So I don't know if that's a specific instance of conduct. I think it goes more towards the basis for Court Fox's opinion to an extent as to why he believes that Alex Woodworth has a peaceful character, but I don't know that's actually a specific instance of conduct.
Right. Well, what about with Miss?
There it is. Look at his tiny cup. Why?
Is it Miss Cobbs?
I'm not aware of any specific instances of conduct. I'll be asking her.
All right. So why don't we do this? Let's get the jury in and take the testimony that we can get. And then we can address that later if the issue of specific instances of conduct are anticipated, but we'll stick to the manner described in section 90405, subsection 1 for now. Okay? Are you ready with the witness?
So what I hear Your Honor ruling is that they can do it in the four-step process that we've talked about that was outlined in State v. Jackson.
Well, I think that's the reputation part of it. But yeah, reputation or opinion evidence.
An opinion, I understand it's not going to come up with Ms. Cobbs, but with Mr. Fox, he can give his opinion, but he doesn't get to say the basis for his opinion. As Mr. DeFore was just trying to let, he might have that foundation, but he doesn't get to say that hearsay conversation.
We may come back to it. I'm just saying, if you don't have it with this next witness, then let's bring the jury in, let's have them hear some testimony. Okay.
Hi, can you please state and spell your name for the court reporter?
All right, guys. So now we're getting into the next couple witnesses, and these are friends of Alex and Ezra's. So I need my ticker.
Samantha Kobes, SAMANTHA KOBS.
And what is your occupation?
I'm a high school English teacher.
And did you know a man named Alex Woodworth?
Yes.
When did you first know him?
I started working at a coffee shop in November of 2013, and he was a regular customer, so probably shortly after that.
And is this coffee shop Racy's?
Yeah, Racy Dillings.
Oh, it's Racy, all right.
And so did you become friends with Alex?
Yes, as a customer first. So he was there a lot, oftentimes for hours. And you just get to know the regular customers fairly well. And eventually we became friends, and he started working there at one point.
How would you describe Alex when you first observed him as a customer?
Alex was, we would joke and say he basically lived there because he would come in with books and he would be there for hours and hours. He had his regular spot that he sat in. He kind of looked like a very young version of an old man. We would joke that he would just sip his coffee and...
I literally said that on the very first day of the trial when they had, it was his mom, and they brought that picture in of him. And I actually literally said he looks like, in a good way, I was like, he looks like an old soul, like an old grandpa in a young body, which is, so it's really funny.
Read his books and kind of keep
when I heard her say that when I was making this video, I was like, oh, wow, that's funny.
himself, at least when he first started coming to the coffee shop.
And around do you know what year you started to become friends with Alex?
I would say probably towards the end of 2014. Yeah, maybe like November, December. We had become closer.
And were you friends with Alex up until his death?
Yes.
And so would you and Alex hang out outside of Racy's?
Yeah, so it started off as hanging out a lot at Racy's. I think the crew there, when you're not working, you're typically still there hanging out. So it kind of started off that way, but we would occasionally go and grab a beer together, sometimes after work, or just visit each other at work.
And how would you describe Alex's personality?
Objection.
Sustained.
So in November of 2017, did you learn that Alex was involved in a relationship?
Yes.
And did you learn who that relationship was with?
Yes.
And who was it with?
Ezra McCandless.
And were you familiar with the defendant?
Yes.
How did you know her?
She also would come into the coffee shop.
Do you know when you got to know her?
It was probably the summer before that, November, so maybe just a few months before that.
Okay, summer of 2017?
Yes.
And I guess if I can back up a little bit from, you learned in November of 2017, Alex was in a relationship with the defendant.
Yes.
Before that, did you know Alex when he was involved in relationships?
Irrelevant.
What is the relevance?
I think based on the defendant's characterization of Alex, I think prior observations of relationships is relevant?
Well, I'm going to sustain the objection unless there's, some,
Okay.
just sustain.
And so you knew the defendant beginning the summer of 2017.
Yeah. Yes.
And she was how did you know her again?
She was a customer. I'd only met her a handful of times. So by no means did I know her well, but I knew of her.
So fair to say you were much closer with Alex than the defendant?
Yes.
Did you learn that the defendant was involved in a relationship with Jason Mengel?
Yes.
Objection, irrelevant.
Overruled.
And what did the defendant tell you about her relationship with Jason Mengel?
Objection.
Overruled.
Objection.
In November, that same November, I had been told that she was trying to actively leave that relationship. There was a day that I went to the coffee shop and I was visiting Alex there and she was there as well. And we were all kind of talking, but I asked her if she wanted to go get a drink. And we went across the street to a bar, which I learned she wasn't old enough to be in when she was asked to leave. And when we were at that bar is when she told me, she kind of debriefed about some of the things that she'd been going through in that relationship. And, I shared some experiences as well. It was kind of just like a bonding moment of, talking about unhealthy relationships and the importance of kind of leaving those.
And so, was there anything specific she told you about the relationship with Jason Mengel?
I was under the impression by our conversation that he was very controlling, and she seemed to feel uncomfortable and was struggling to leave that relationship.
And do you know when you had that conversation with the defendant, when you went to a bar?
I think that was near the end of November, maybe very early December.
And did you later learn that the defendant and Alex's relationship ended?
Yes.
How did you learn about that?
On February 25th, I was texting with Alex. He was going to be coming to my apartment because he was going to take over the lease from my current roommate. And I told him, we were just discussing the lease, and actually simultaneously I'd received a message from Ezra on Facebook asking if she could come and look at the apartment because I'd made a public post saying that I had a room to fill. So when I was texting Alex about the apartment, I also told him that Ezra had reached out and was showing interest as well. Up to that time, I didn't know that anything had happened between them. But he asked if I could not mention him because they'd had a falling out the day before, which would have been February 24th.
If you turn to the second page of that exhibit, there's some highlighted portions. And if you could read number 30, that's an outgoing message to you. Is that right? Could you read that for the jury?
Yes. Things just went really bad between us, and I don't think she's going to be in town again.
And how did you respond?
Oh, fuck. What happened?
And then down below right there, how did Alex respond?
Jason found out and had a fit at Racy's. Ezra got stressed out and blew up at me for not talking about my past. Woke up to a text asking me to forget her name and not talk to her again.
Thank you. Move exhibit 152 in evidence.
Okay.
Now 403 cumulative, I think the content is already in. I don't know that we need to document 152.
All right, well, I'm going to overrule if you'd like to. I'll receive it. And again, any objections previously made or noted. Counsel, also your microphone is off, but that's okay. You can keep it off unless you need it. Okay. All right, go ahead.
And after that, did Alex make any steps to move into this new apartment with you?
Yes, he He came over and got an application, signed the application, and he had paid the $30 application fee, and then was approved by the landlords and the property manager.
And after Alex sent you this text, did you see him after that?
Yes.
And did you notice any change, visible change in Alex's demeanor?
I went into the coffee shop, I believe it was March 10th, and he seemed troubled. He just seemed more quiet. It was a short interaction that night. And then he came to the apartment on March 13th to meet the property manager. And then once she left, we talked for a while. And I guess I understood why he was upset.
Did you also learn that there was a potential sexual assault investigation pertaining to the defendant and John Hansen?
Yes.
No foundation.
No overrule. I think this sounds like a foundational question.
Were you aware that the defendant and John Hansen had some sort of relations?
Objection, no foundation. This witness does not have a foundation to testify.
Well,
Her awareness is not based upon personal knowledge. It is based upon gossip or hearsay.
all right. Well, I guess let's start that way. Let's go back. Foundation, any person.
And I can move on. Did you ask Alex something about the defendant and her relationship with John Hansen?
Objection, hearsay.
Sustained.
That's her statement. So what did you say to Alex regarding a sexual assault investigation?
Oh, yeah.
Hearsay.
That's what you're
Irrelevant.
saying.
Well,
This is really interesting because she's trying to say it's her statement. That's still hearsay, though. This is really interesting.
so you're saying it's what did this witness say
Yes.
to Alex?
What did you say to Alex? It's her statement to Alex.
Still hearsay.
Well,
If it's for the truth of the matter, it's still hearsay.
all right. I'm going to overrule. I'm going to allow you to answer the question.
I don't really know why he overruled that, but sometimes they do.
I was aware that there was an accusation between the defendant.
Move to strike. No foundation.
Okay. Well,
Move to strike.
I'm going to strike the beginning of that answer, but if you would just answer the question. What did you say to Alex without any background or explanation? What did you say to him?
I said, do you think she's going to also accuse you of sexual assault?
Ooh.
And how was Alex's demeanor when you made that statement?
Wow.
He said he didn't know, but he wasn't worried about it because
Wow. Okay, let's listen to that again. That is why the defense, they must have seen that coming somehow. I don't know how they saw that coming. Holy shit. That is a hell of a thing. Speaking of foresight, right? She had some. Holy fuck.
he had months worth of text messages to prove that it was a consensual relationship.
And
Oh, I forgot to back it up. I was so shocked. Let me back it up now.
This does not have a foundation to testify.
Well,
Her awareness is not based upon personal knowledge. It is based upon gossip or hearsay.
all right. Well, I guess let's start that way. Let's go back. Foundation, any person.
and I can move on. Did you ask Alex something about the defendant and her relationship with John Hansen?
Objection, hearsay.
Sustained.
That's her statement. So what did you say to Alex regarding a sexual assault investigation?
Objection, hearsay. Irrelevant.
Well, so you're saying it's what did this witness say
Yes.
to Alex?
What did you say to Alex? It's her statement to Alex.
Well, all right. I'm going to overrule. I'm going to allow you to answer the question.
I was aware that there was an accusation between the defendant.
Move to strike. No foundation.
Okay. Well, I'm going to strike the beginning of that answer, but if you would just answer the question. What did you say to Alex without any background or explanation? What did you say to him?
I said, do you think she's going to also accuse you of sexual assault?
Crazy. There you
And
go.
how was Alex's demeanor when you made that statement?
That is some damning testimony. That is some damning testimony right there.
He said he didn't know, but he wasn't worried about it because he had months worth of text messages to prove that it was a consensual relationship.
And were you personally concerned about living with Alex in this apartment?
Objection, irrelevant, no.
Well, I don't know what the answer is, so
Her concerns about Alex are irrelevant. It's 90404 and 90.
I have to say, she's got a pair of defense attorneys that are fighting for her, as she should, as she should. They are fighting like hell. They're doing a great job, really. Even if I don't always like their style, they're doing a great job.
403, 90402.
Honestly, they have a shit case, right? You know, this is what they were handed. It's looking pretty bad for her, facts-wise, right? They're doing a fucking amazing job, I feel like.
But in particular, 904.
I mean, I think the lawyering is great on all sides here, and I like the judge. Just adds to this trial.
404, which we had all this hearing about.
I could rephrase.
I guess some indication, where are you headed with that? Is this something we need to have a hearing outside the presence of the jury?
No, I can move on. Let me ask you this. Were you in a romantic relationship with Alex?
No.
But you two were going to move in together.
Yes.
Were you going to share a room or have different rooms?
It was a 2-bedroom apartment, and we would have had separate rooms.
And do you know if Alex has any reputation for peacefulness?
Yes.
Okay, I'm going to sustain on foundation. I think we just talked about that and the various elements of that.
Do you have an opinion whether Alex has a reputation for peacefulness?
Objection. Same objection. Repeat
Sustain.
Y'all look at him.
Okay, do you have an opinion as to Alex's character for peacefulness?
Objection, 90404. No foundation.
Overruled. You may answer that question.
Oh, she got it in.
Yes.
Do you have an opinion as to Alex's character for peacefulness?
Yes, I found him to be very peaceful. He was very
I
calm.
guarantee he was making a note right there for the appellate record.
He was kind of an old spirit, and I felt that we were very compatible as friends because of that.
No further questions.
Y'all,
Okay.
look at her cardigan. I'm just saying. While it's not brown, it's maybe more of like a burnt mustard yellow. Y'all, the number of freaking brown/yellow-brown cardigans in this trial is on another level.
Cross-examination.
Ms. Forbes, I want to ask you some questions about your comments about this young lady here next to me, Ms. McCandless, okay?
Yes.
You said
Like
that
this
you had
one.
a conversation with her in November, is that right?
I believe so, yes.
And you bonded based upon both of your experiences in unhealthy relationships.
I believe I meant that the conversation was something that we could, both add to, but I don't know that it was like I didn't mean to suggest that we became friends after that.
You had a conversation,
Yes,
and the conversation was about unhealthy relationships.
yes,
Unhealthy relationships that both of you had been in.
yes.
An unhealthy relationship that she was in at the moment she was having that conversation.
I don't know whether she technically was in the relationship or trying to leave the relationship.
Trying to leave would mean that she hadn't left yet. Agreed?
Correct.
So she'd still be in it. Agreed?
Yes, but I don't know which she was.
Okay. Either in it or trying to leave it,
Yes,
but not yet left.
yes.
In that, in your, what you knew about regarding, based upon that conversation and your, with her, you found her to be weak and vulnerable. Agreed?
Yes,
I think another word you've used in the past is fragile.
probably, yes.
You'd said you were friends with Alex, is that right?
Yes,
Alex had told you he in the fall, November, December of 2017, that he was in a relationship, correct?
yes,
He did not immediately disclose who that was, correct?
correct.
He was secretive about that, agreed?
He was respectful of the privacy of that other person.
He was also not telling you, correct?
I wasn't asking.
You had to find out from somebody else other than your good friend who this person was that he was entering a relationship with, correct?
I would disagree with that.
You eventually found out who this person was,
Yes.
and you found that out from Alex.
From the things that he said and, you know, thinking about the things that he'd said, I figured it out.
So while he was respectful, he was certainly still telling you about that relationship, right? He
Mentioning that it existed, yes.
mentioned it existed. He also mentioned facts. He mentioned it was a male, correct?
I don't know that he said it was a male. I think he said he was seeing someone who was identifying as a male, possibly, but
So I appreciate that distinction. So he made mention that the person he was seeing identified as a male, correct?
yes.
And that he told you that things in that relationship would get kind of freaky, correct?
I don't know that he used that word.
You used that word when you spoke with the police in describing what he talked about regarding their sex, right?
Yes, I don't know that he used that word, but I do recall having conversations, yes.
Okay, so for whatever reason, when you talked about what Alex had talked about, you chose to use the word freaky, right?
Sure. Yes.
You agree with that?
Yes.
Your relationship with Alex, you said, was friendship, right?
Yes.
What we would commonly think of as platonic, correct?
Yes.
You did not have a sexual relationship with him, did you?
No.
You were not dating him, correct?
No.
There was no, like a better term, tension or attraction between the two of you in that category. Agreed?
Agreed.
Your knowledge of him and his character was based upon your platonic friendship that you had with him, correct?
Yes.
You didn't read his journals, did you?
I read some of his writing. I don't know what journals you're referring to, but I'd read some of his
So you're
writing.
familiar with his writing?
Some of it, but as a writer myself, I think people write differently depending on what they're writing.
Sure. Are you familiar with the portion of his journal from November 9th, 2015 on DOJ 2482, in which he writes, I half-heartedly try to isolate myself from you, afraid I would taint you, yet I love you. I am sorry for this failure.
Hold on, you said November of 2015?
I apologize, it's November of 2017, I misspoke. Yes, it's from November of 2017. It's DOJ page number 2482 from his, and I believe I'm allowed to do this on cross-examination.
Okay, go ahead.
Your Honor, are you, I'm objecting because this is not McMorris for a witness. McMorris as to what the defendant may have in mind regarding these journals, but not with Ms. Cobbs.
It's not McMorris evidence, it's going to rebut her opinion testimony, and I can say what she does or she doesn't know in order to bring in specific instances.
All right, well, first of all, I thought there was a relevancy objection, and that was based, I thought you said 2015, so I thought, well, that certainly that would not be relevant, but if it's this November of 2017, I will allow you to go into that on cross-examination.
Are you aware of his journal from November 9, 2017, in which he wrote, I've half-heartedly tried to isolate myself from you, afraid I would taint you, yet I love you. I am sorry for this failure on my part. I know my touch would kill you, yet I reach out. That is my sin, the violence of my flesh that I lack a soul to correct. Are you familiar with that writing by Mr. Woodward?
No.
Are you familiar with his writing from December 3rd of 2017, in which he writes, merely doing as one will sexually makes consent irrelevant?
No.
Are you familiar with his writing from October 29th of 2017,
erotics always contain.
Objection, relevance. We don't even know if Ms. Cobbs has seen these. I mean, she's
Well,
seen.
that's the question, whether she has or not.
Right, so before he's reading them, I would prefer that she be shown them to
He's
see
reading them
if
into
she's
the
actually
record,
seen these before they're read in open court.
I believe that that's the requirement. I get to cross-examine her to see if she knows something so that I can, for lack of a better term, discredit her opinion because it's based upon.
I'm going to overrule the objection. Go
And Your
ahead.
Honor, also it's the rule of completeness. These are entire long journals and they're taking sentences out of them to try to make them construe what they really are. So, I mean, if we're going to go down this line, then she should be able to see the entire article to understand what Alex is saying.
We have no objection to the admission of his entire writing history and catalog.
Well, due to confusion, waste of time, and so on, and I think we're going to get there at some point, so we're not going to go into the entire journal at this point. So go ahead, Mr. Nelson.
Thank you. Are you aware of his writing from October 29, 2017, which he writes, erotics always contains violence. That cannot be avoided. The secret is not avoiding the violence, but in living with it.
No.
You said that you met with him on March 10th, is that right?
I believe March 10th I went to the coffee shop,
You
yes.
saw him on March 10th, correct?
I believe so.
You made observations of him?
Yes.
And
Mr. Nelson, would you please put your microphone on while you're addressing the witness?
Thank you,
He's
Judge.
Elaine.
Sorry about that.
I mean, he's not Elaine, but
And
with the
when
microphone.
you met him on March 10th and made your observations, as you testified before, he seemed troubled. Agreed?
Yes, he wasn't, peppy and bouncing around the coffee shop like he often was.
He seemed troubled.
Yes.
And then you saw him on March 13th, correct?
Yes.
You spoke with him.
Yes.
He spoke with you.
Yes.
And then you understood he was upset.
Yes.
That's all. Thank you.
All right, any redirect?
Yes, are you familiar with a nihilist or the word nihilism?
Yes.
What is that?
From my understanding, it's kind of an outlook in which I could be very wrong. Maybe you don't necessarily see a purpose in life as in, like there's a lack of religion and there's no afterlife and that everything just is as it is and things can't be explained.
And would you ever use that to describe Alex?
I think that as a philosopher, I don't know. He was incredibly intelligent, so I don't know that sometimes I understood his views on things, but he certainly was devoid of a religious outlook on life, I think, towards the end.
So would you think he was more concerned about himself or more concerned about others?
He was definitely more concerned about others.
And did you worry about him as a cannibalistic person, like he was going to eat you?
Never.
Did you worry about him being violent towards you?
Objection
Never.
beyond the scope, 90404.
No further questions.
Okay, any, I guess, recross, limited to the
Yes,
redirect?
I have one in particular. Are you familiar with his January 1st, 2018 resolution in which he writes, "I need to be more selfish." And he goes on to say, "Selfishness needs to find a place in my values." Are you familiar with that?
No, but that sounds like something he probably would have written.
Thank you, that's all.
Okay,
Well, can I ask a follow-up to that?
I think that's it. You can step down. And she released from her subpoena?
That's beyond this.
Yes, Your Honor, but that was beyond the scope of my recross, so I feel like I should be able to ask a follow-up.
She
I didn't
asked-
ask about,
She asked if he was selfish, and she said no, and I
I think that was within your redirect, so, within the scope. Okay,
can you please state and spell your name for the record?
Allyson Kexel, ALLYSONKEXEL.
Okay, I'm gonna have to have you speak up a little bit more. What is your occupation?
I am a barista at Racy Delene's Coffee Lounge.
Speak up even louder if you can.
Sorry, Andrea.
It's all right.
I am a barista at Racy Delene's Coffee Lounge.
Perfect.
And do you know the defendant?
Yes.
And prior to March 22nd of 2018, how long did you know the defendant?
Approximately a year.
And how often would you see her?
Most days of the week, probably 5 to 6 days.
Was this when she was living in Eau Claire, Wisconsin?
Correct.
And what would you and the defendant do together?
We, of course, spent a lot of time at Racy's together, talking, drawing. I served her when I worked there as a waitress. We would go for walks together. She would shoot photos. We would spend time doing art together occasionally.
And did the defendant talk to you about her relationships?
Yes.
And what did she say?
Objection, vague.
What did she say?
Irrelevant.
I'll sustain on vagueness if you could be.
Which relationships did she talk to you about?
Specifically Jason.
And are you referring to Jason Mengel?
Yes.
What, if anything, did she say about her relationship with Jason Mengel?
Objection, irrelevant.
I like her earrings.
Overruled.
Generally, our conversations were about how she felt uncomfortable in that relationship, micromanaged more so.
Did the defendant talk to you about her gender identification?
Objection. This has been document 298. There's much litigation about this.
I sustain the objection on that.
Interesting.
Can we have a sidebar, Your Honor, about
Yes.
that?
Go ahead.
What did the defendant say about her gender identification?
Mostly that she was fluid, meaning some days she felt
Prosecution won that sidebar, clearly.
more masculine than others, that she would off and on wear makeup, change the style of clothing that she would wear.
And were you aware that the defendant and Alex Woodworth were involved in a relationship?
Not until months after.
When did you learn that?
I can't recall.
Do you recall observing an argument on the date of a pop-up art show?
Yes,
And was that on February 24th, 2018?
that is correct.
Is that the date when you learned about the defendant and Alex being in a relationship?
I can't recall.
Okay. So can you take me to this day on February 24th? What did you observe that day? Were you at Racy's coffee shop?
Yes.
And did you observe an interaction between Jason Mengel and the defendant?
Correct.
What did you observe?
Jason had asked Ezra to come outside so he could speak with her. It was around the time that we had to leave we were volunteers for the art show. And I went outside to bring her with me. I was giving her a ride there. And they were having what looked like a tense conversation outside in the parking lot.
And did you hear anything during that conversation?
I remember Jason saying something to the effect of,
Objection, hearsay.
Well, is this offered for the truth of the matter? Or is this offered, what is it? What is the purpose for the?
It's just describing, it's not for the truth of the matter asserted, it's to describe the context of that argument.
Objection, irrelevant.
Right. Well, court has made a provisional ruling. I'm going to allow it. So I'm going to overrule the objection.
he said something to the effect of being upset with her sleeping with his friends.
Well, yep, that's valid.
And what did you observe the defendant doing during this time?
Standing there kind of complacently, in distress. I had, from a distance, asked her if she was ready to go. She snapped at me and said no, that she was in the middle of something. So Brianna Larson and I went to the art show together. She was also a volunteer.
And so did you observe Jason Mengel talk to anyone besides the defendant?
Correct.
Who else did he talk to?
Alexander Woodworth and John Hansen.
Did you observe when Mr. Mingle was talking to those individuals?
Yes.
Was it one at a time or both?
Correct.
Together? One at a time?
Individually.
And so when you observed Jason Mingle talking to Alex, what was Alex's demeanor?
Collected. Cool.
Did it turn physical?
No.
Were you able to overhear yelling?
No. Most of us were inside. They were outside alone. But there was no yelling that I could see from inside.
And so you talked about how the defendant snapped on you when you were supposed to ask her to go outside or to leave the situation. Is that right?
Correct.
And so did you go to the art show without her?
Yes.
And did you later have communication with the defendant?
Yes.
How so? Did she call you or text you?
She sent me a direct message over Instagram.
And what did she say?
I can't quote that verbatim. Something to the effect of, she apologized for the way that she had talked to me.
And did she ever join you for the art show?
No.
During your friendship with the defendant, did she mention a person named John Hanson?
Yes.
And what did she tell you about John Hanson?
Objection, irrelevant.
Overruled.
Andrea, could you be more specific? We were all friends with John. So.
Okay. Was there a time where the defendant discussed spending a few days consecutively with Mr. Hanson?
That is correct.
And what did she tell you about that?
She told me that she had stayed there for the weekend and that she had participated in spending time with John and his son, and that they had made dinner together and things of that nature.
And did she appear upset?
Absolutely not.
Was there anything negative stated by the defendant regarding that few day stay with Mr. Hanson?
No, she seemed excited.
So after the sort of pop-up art show event where Jason Mingle had those discussions, did you see the defendant after that?
I don't believe so.
Did you learn if the defendant had moved?
Yes.
Do you know where she moved to?
Objection, no foundation. Irrelevant.
I'm going to sustain irrelevance, unless you have.
That's fine. It's,
Okay.
did the defendant talk to you about Alex Woodworth?
Occasionally. Just passing conversation. We all knew him, so just conversations as a friend group, I suppose.
Did she talk to you about having a relationship with Alex?
Not necessarily an intimate one. However, she did spend nights there occasionally.
Do you recall her telling you how Alex felt about her?
Yes, there was a conversation about that.
And what did she say?
She had told me that Alex had expressed intimate feelings for her.
Do you know what those intimate feelings were?
He, I believe, at some point or another had told her that he loved her.
And did you see the defendant and Alex together at Racy's?
Yeah.
And what did you observe?
Having conversations, sitting together on the couch, sitting closely at times, which wasn't anything uncommon.
And when you observed the defendant and Alex together, did the defendant appear afraid of Alex?
No.
Did you also learn that the defendant would also stay at Alex's house?
Yes.
Do you know when that was?
Multiple occasions, but I don't have dates.
I have no further questions.
Okay, cross-examination.
Ms. Kexel, you made observations of Ezra with Alex at Racy's, is that right?
That is correct.
And that was essentially from the fall of 2017 up until this event.
Thank you.
Thank you, Judge. It was essentially from the fall of 2017 until this event in February 24th of 2018. Is that right?
Summer 2017 until March.
Until February 24th.
Excuse me, yes, until February 24th.
Okay. It was during those times where you saw Ezra and Alex sitting on the couch together.
Correct.
They seemed to get along well.
Yes.
They were in close proximity, right?
Correct.
Smiling,
Sure.
talking.
Yeah.
And you learned from Ezra that according to Ezra, Alex had expressed his love for her, correct?
Correct.
And then February 24th, everything changed.
Sure.
That's all. Thank you.
Any redirect?
No.
Okay, you may step down. Thank you.
Can you please state and spell your name for the record?
Brianna Larson, BRIANNALARSON.
What is your occupation?
I'm a barista.
And where do you work?
Racy's and Skill Shop.
Are those both coffee shops?
Yeah.
And
Skill Shop?
and what city do you live in?
Eau Claire.
And back in summer of 2017 to March of 2018, did you also live in Eau Claire?
Yes.
And are you familiar with the defendant?
Yes.
And how do you know her?
I met her at Racy's.
And when did you first get to know the defendant?
I met her at Racy's. Jason brought her to Racy's and introduced me.
And Jason, do you refer to Jason Mengel brought her?
Yes.
And did you two become friends?
Yes.
Were you pretty close with her?
Yes.
Did she have a nickname for you?
Yes.
What was that nickname?
She called me her wife.
And how would you describe the defendant when you first met her?
I'd say she was pretty bubbly, easy to talk to.
Did the defendant talk to you about her personal relationships?
Yes, sometimes.
And when she talked to you about them, were they always about men?
Objection irrelevant.
I can't remember.
Well, hold
really.
on. What's objection is relevance?
Correct, Judge.
I'll withdraw the question.
Okay. All right, it's withdrawn.
When you became friends with the defendant, was she in a relationship with Jason Mengel?
Yes.
Did she talk to you about her relationship with Mr. Mengel?
Yes.
What, if anything, did she say about that relationship?
Sometimes it was regarding how he felt about how she was changing her image sometimes, and it didn't make her feel very good.
So what do you mean how she was changing her image?
Just like changing how she dressed or taking piercings out of her face she didn't feel was appropriate anymore. She just didn't feel like wearing them. And Jason, it was like Jason, how she described it, felt like he was, like the person he was in love with was changing.
Well, for like piercings, where did she have a piercing?
Septum,
Irrelevant.
septum piercing.
Objection irrelevant.
Okay. Hold on. Stop. All right. Okay, Ms. Larson, if there's an objection, I just ask you to just stop and don't answer the question until it's been ruled on, okay?
Okay.
All right. Okay, so, Mr. Nelson, you made the objection.
Yes, sir.
And so I'm going to sustain on relevance as far as the,
I think it provides an explanation of the change of the defendant during this time, as well as context on their relationship.
well, the relationship, okay, but some of those other details I don't think are relevant.
Okay. So did the defendant talk to you about any other relationships besides her relationship with Jason Mengel?
Sorry, I just like need a moment. I'm pretty anxious right now.
Okay.
It was mostly just like him kind of putting her down about her image and changing it, but
Sure. So I'm moving on though. Is there any other relationships that the defendant talked to you about?
not that I remember right now.
Do you remember her talking to you about her relationship with Alex?
Yes.
And when I mean that, Alexander Woodworth.
Yes.
What did she say about her relationship with Alex?
I don't remember specifically exactly what was said, but
Objection, no foundation. If she doesn't remember, as she just stated, I don't think she gets to guess.
I'm going to overrule your objection. If she can, has a gist of what was the conversation, I think that is sufficient. Word for word, I don't think that's required. So I guess, Ms. Murdaugh, please follow up with that. Just lay a little bit more foundation.
So what are you able to recall that the defendant told you about her relationship with Alex Woodworth?
they would just like hang out. Sorry, I'm having a really hard time right now.
Did the defendant say if she liked Alex or not?
Yes, it was all positive things. I do remember that, and I did see like the relationship in person as well. And
what did you observe when you saw the two of them together?
They would sit close, and they would giggle and laugh about things, and I don't know, share drawings and literature.
Did you learn that the defendant moved out of Jason Mengel's apartment or house at some point in their relationship?
Yes.
Objection, irrelevant, and foundation. I don't know where the foundation is for this when she asked it in that manner, if she learned.
Well, to me, again, it sounds like a foundational type of question, so I'm going to overrule. Go ahead.
Do you know if Jason Mengel and the defendant lived together at some point?
They did.
Do you know when that was?
It was right before. I know that when she moved out, it was Valentine's Day.
Okay.
So I know it was up until that point. I don't remember when it started.
And where did the defendant live after she moved out of Jason's apartment?
I'm not sure of specific places. I know that her car was a place of staying, but I don't know if she stayed at specific places other than the car.
Wow.
Did the defendant tell you what she and Alex would do together?
Yeah, they would. Yeah, it was like a relationship. It wasn't like details, but they would go on dates, sleep together.
Did the defendant tell you she was scared of Alex?
No.
Did she ever tell you anything negative about her relationship with Alex?
No.
Did the defendant tell you that she was concerned about what was written in Alex's journals?
No.
Were you also friends with Alex?
Yes.
How long were you friends with Alex?
I'm trying to think of when I first started going to Racy's. Might be 3 years ago now. I know it was in the fall time. I just got a new job and he'd work nights at Racy's, and I went there for a new place to go and meet people. He was one of the first people that served me and became my friend there.
And would you and Alex, was it you'd always hang out at Racy's?
Yeah.
And did Alex talk to you about his relationship with the defendant?
Yeah, sometimes.
Did he talk about any feelings or emotions he had for the defendant?
Yeah.
And what did he say?
He did tell me that he did love her.
Do you know approximately how long the defendant and Alex were in a relationship together?
I don't know the specific dates. I know it was in the fall time. I found out about the relationship when I went to a fire and she was there and she told me about it. I think it was probably around October. I know it was starting to get cold out.
And do you know when their relationship ended?
Probably around February, is my guess.
Okay. Did the defendant talk to you about John Hansen?
Yes.
And did she talk to you about spending time with John Hansen when Mr. Mingle was gone for a weekend?
Yes.
What did she tell you about that?
She told me that her and John hung out for a weekend, and she drank a lot of wine, and he helped her hold her hair up while she threw up and was just there for her, and she told me she had a really good time.
Isn't that interesting? Because this came up in opening statements from the defense, and he talked about how, like, I guess that's when he, in the opening statements, he claims that like she was taken advantage of like sexually, right? And then he portrayed that as like this was a negative experience. So it's just really interesting to hear from like one of her friends that she had a really good time, especially when you hear, yeah, she got really drunk, she was throwing up, she had a really good time. It's like, wow, interesting stuff.
And when she told you she was having a really good time, did she appear upset?
No.
Did you learn that the defendant filed a report against John Hanson?
Objection, no foundation, it's false.
All right, what? I'm going to overrule.
Can we have a sidebar, Judge?
Interesting that she's,
All right.
I mean, getting emotional, maybe. I don't know. It's hard to tell because, you know, she doesn't really show emotion, but like she's pretending. I don't know. Interesting, you know, with this witness, but not when it came to anything with Alex, right?
Excuse me. Objection is sustained, and Ms. Nodoff is going to rephrase your question.
Did the defendant talk to you about an investigation regarding a sexual assault?
I didn't hear it from her.
Okay, then I don't want you to go any further. And do you recall being at Racy's coffee shop on February 24th, 2018, the date of the pop-up art show?
Yes.
And what is this pop-up art show?
It's like an unknown place where the art show is, and it's released that day. So people wait to find out the location and see what art is there.
And did you have plans with the defendant for that show?
Yes.
What were those plans?
We were supposed to volunteer, just like help things go smoothly with the art there. Some of it was you could grab it or do other things with it. So we were just there to help people along with the art.
And did those plans change?
Yes.
And how did they change?
Jason came to Racy's that day very upset, and he found out about the affairs that were happening.
Objection, move to strike. Lack of knowledge, no foundation, opinion.
Well, I'm going to sustain, but if you just, Ms. Nodoff, if you ask her what she observed, just stick to, and here's the thing, I know you're nervous, I don't want to get you more nervous, but you can only testify about what you know of your own knowledge, okay? And your own observations, not what other people are telling you.
I know.
Okay, so Ms. Nodoff, go ahead with the question.
So did you observe a conversation between the defendant and Jason Mingle on that day?
I did. I didn't hear it. I could see it through the windows at Racy's outside.
Okay, so can you
and I could see Jason moving his arms a lot. He had a very angry face. And then he came inside and asked John to come outside with him. And then asked, after he had John come outside with him, asked Alex to come outside with him. He was a very stern, angry voice.
And did you observe Alex Woodworth go outside?
Yes.
And what did you observe of Alex when he was out there with Mr. Mingle?
I couldn't see him through the window, but after Jason was done, I went outside, and Alex was just sitting on the bench. He was fine. I think that he was just like, I don't know. He was very calm about it.
Okay.
I guess.
And did Alex tell you what happened during that conversation?
We didn't really talk much about it. We had to go to the art show like right after, so I didn't really bring it up.
My question is, who was working with
I just
Racy
asked him if he was
everyone
okay,
with
and he
art?
said yeah.
And so after this date, did you see the defendant again after the pop-up art show date?
Art show again.
Yeah, I did see them, but it wasn't as often. I guess I did see them after.
I'm sorry, who's them?
The defendant.
Okay, and anyone else?
With the group? I'm sorry, can you repeat the
So
question?
you said you saw them together.
Oh, no, I just meant like her.
Okay.
Sorry.
And where would you see the defendant?
At Racy's. She'd come by sometimes.
And were you guys still friends?
Kind of. There was a lot of drama happening. I kind of just stopped talking.
Interesting.
Didn't really want to be a part of it.
I mean, that makes sense.
And
And
after,
that makes sense. That makes sense because she's, the problem is like they're all friends with each other, right? But it's interesting that if you're in that position, it kind of puts people in a position that, like this friend, right? Not that they deserve to be in the position, but where they have to kind of, take sides in a way, right? So it's interesting that she wasn't really that much friends with Ezra anymore after that falling out with the affairs. It makes me wonder if, because she thought Ezra was kind of in the wrong or maybe using people. Of course, they're not going to get into it in the trial, but it's just interesting that after that whole thing, she wasn't really friends with Ezra anymore, even though it didn't involve her. So
February of 2018, this pop-up art show, did you notice any change in the defendant's demeanor?
Objection, vague, irrelevant,
how is it vague?
opinion 90404.
Observe any change in her demeanor?
If she wants to talk about a specific date and how she made an appearance, but just a general opinion is 90404.
All right, well, I'm going to sustain the objection. If you have something specific, you can ask about that, but that's pretty general and open.
Sure. Did the defendant, you described her as kind of bubbly at first. Was she still a bubbly, friend when you saw her in February of 2018?
Not so much. There was times, but it seemed like she was going through a hard time.
And did the defendant ever talk to you about cutting herself?
Yes.
And what did she say?
Objection, vague, time.
Trigger warning, guys.
We were at Racy's. We were outside and it was night out.
Trigger warning.
And we decided to smoke a cigarette. And she talked to me about how she cut herself. And so I talked to her about it because I've also done that myself. It's just like reaching out. We just talked about it and how sometimes you need a physical thing to break up the emotional pain.
Do you know when this conversation took place?
I believe it was either late of that year or right in the beginning of that year.
So either December or January of...
Somewhere around that time.
Interesting.
Did the defendant show you where she had cut herself?
Yes.
And where was that?
It was on the arm.
What did you observe?
Even lines, I guess, on the arm.
Now, why does this matter? Well, because, the defense in their opening statements and presumably what we will hear from Ezra when she takes the stand is that, she carved the word boy into her arm so that she wouldn't forget what happened, right? But the thing is that this is going to show that this was something that she did. It was like self-harming, whatever. I know I have trigger warning up there for that reason. And that, that it just makes it less likely, right? It makes it less plausible that she was just trying to carve boy into her arm so she wouldn't forget what happened. Even though when she goes up to the farmer and speaks to the, law enforcement initially, she says she forgot everything that happened. So, yeah.
Wasn't too many.
No further questions.
All right, cross-examination, Mr. Nelson?
Yes, thanks. Just follow up right away about that. How you doing? You okay?
Yeah, I'm doing fine.
Okay. Want to ask you some questions about this conversation you said you had with Ezra the end of 2017, beginning of 2018, okay?
Okay.
And it was about her telling you that sometimes sounds like she was in emotional pain.
Okay.
And she needed to break that up by doing something physical, correct?
Well, it was...
The cutting, that's what I meant.
Right, we're talking about the cutting.
And she told you that the reason she did it was she was in emotional pain and wanted to do something physical.
No, this...
Break it up. That's what you had said. Agreed?
She didn't specifically say that to me. I talked to her about it, and I said, it's okay. Like, I've done that sometimes. We can do that to break up the physical pain from the emotional pain, because emotional pain can be too much.
Understood. I misunderstood it before. So these were your words that you shared with her.
Yes, talking to her about it.
Kind of
trying to be a friend.
Yeah, a mirroring. She tells you something and you're like, you're not alone.
Yes.
You're saying this happens, correct?
Yes.
In fact, I suspect within your friend group, it's not uncommon.
That is
Within people your
presumptuous.
age
Ew.
that
gross.
you've talked
No.
with within your friend
No.
group, it sounds
No.
like this
Bad. Bad.
act that you talked about, that's not
Oh,
uncommon.
no.
Objection relevance.
Stop. No.
I wouldn't assume
First
that all my
question,
friends.
Sorry.
Sorry.
Okay, we'll just stop.
Wow.
Recorder didn't get it. Okay, so,
Wow.
Mr. Nelson, you asked the
That
question,
was
state objection
not-
relevance. I'm overruling the objection. You can answer the question. I think you did, but do you remember what the question was? Because we didn't get
I
it
mean,
down.
It was the wrong objection. They should have objected to speculation. Honestly.
What was the answer to the question?
I'm kind of confused by the question.
Sure. You were talking about, as we're talking about cutting, and you're sharing that that was an experience that you've done, correct?
Right.
And my question to you is that act that you were talking about, of cutting, to, as you say, deal with the emotional pain with something physical. My question to you is, you would agree that that's not uncommon within your friend group?
I would say that I wouldn't know that. I feel like a lot of my friends have other ways of coping, and it's not always cutting.
Okay, but some other friends, and we don't need to name names, but some other friends have shared with you that that's something that they've done, correct?
Correct.
Okay.
So he's obviously trying to normalize it. And then also to, point out, he's trying to make it benefit, their theory, which is of course what you're supposed to do, of the fact that, this idea that it's doing something physical to break up the emotional pain, I guess he's trying to sort of suggest perhaps that, this was her way of dealing with the alleged, sexual assault that, likely maybe didn't really happen. But anyway, at the very least, he's trying to normalize it, I think. So
I want to take you through chronologically here quickly. You met Ezra. She's bubbly, right?
Right.
Easy to talk to. Yes?
Yes.
Friendly.
Yes.
Outgoing.
Yes.
Trusting.
At the time, yeah, I didn't know her very well.
She was trusting of others. Not that you were trusting of her. She is trusting of others, correct? She was open and generous.
She was pretty open.
Okay. Generous.
Yeah.
She talked to you about Jason Mengel, who she was living with, correct?
Yes.
Told you about how he was putting her down, correct?
Yes.
That he was, I think your terms were, she was worried about how he was changing her, correct?
Oh, no, he was worried about how she was changing her image, that she was changing. And he was nervous he was losing the person he loved.
This is what Ezra had expressed.
Yes, Ezra told me about, yeah.
So
the whole
Ezra
image
told
thing.
you about what Jason told her.
Yes, and then I later heard it from Jason,
Okay.
different time.
So Ezra was growing in a certain direction, and it sounds like Jason didn't like that direction in which she was growing or evolving, correct?
Correct, it seemed like he was getting nervous.
Okay. And then in February, on February 24th, you were at Racy's inside, correct?
Correct,
And you looked out the window and you saw Jason, right?
correct,
And you saw Ezra.
yes,
And Jason, you said, looked angry.
yeah,
He was waving his arms around.
yes,
Without hearing it, did it appear as if he was yelling?
yes.
Pointing his finger or shaking his hands at Ezra?
Doing, yeah, a lot of arm gestures.
Okay. And Ezra was complicit.
Yeah,
She stood there
yeah.
meekly.
I couldn't, I guess she just stood there.
She just stood there, correct? You didn't see her making any physical response. Agreed?
I remember.
It did not appear as if she was even verbally responding. Agreed?
I suppose I couldn't hear anything, so I couldn't say.
But you didn't see anything to indicate that she was making words with her mouth, right?
No, I had a better angle of Jason.
Okay. Did you see Jason pause to appear to listen at any time, or was it just Jason was on an angry rant?
I don't remember fully, but it was mostly Jason speaking. Yes.
And then after that, you didn't see much of Ezra around Racy's. Agreed?
Agreed.
prior to that, you'd heard that her and Alex were also in a relationship, correct?
Correct.
And that Alex loved her, correct?
Correct.
And then on this February 24th, Alex was spoken to by Jason as well, correct?
Correct.
And what you heard was a stern, angry voice, correct?
Like I said, yes. When he came inside, he just said, "You need to come outside with me. I need to talk to you." And that's the voice I heard. It was stern and it was serious.
And when, after Jason had been done moving his arms and being angry at Ezra, did you see where Ezra went?
I know that after he was done,
Did you see?
Prosecution could be objecting here because it misstates testimony. She's actually corrected him several times, saying stern and serious, but she's not said angry. And he keeps saying angry. And then, anyway, yeah, she's not saying angry. She said stern and serious, and he keeps saying angry. But they're not objecting, so, whatever.
Where Ezra went?
her and Jason went over into an alleyway area after he was done speaking to John and Alex. I don't know where she went while he was talking to them. I'm assuming outside on the side, but I don't know specifically where she was while he was talking to them.
She didn't come into Racy's. She was out of your view.
Yes.
And at some point you saw Jason go over and, for lack of a better term, collect her.
I couldn't see at that point. There wasn't windows on that part. There's two big windows, and I could only see what was going on there, and she was not in my view.
Okay, so
I'm not sure.
So once Ezra left Jason, you didn't see Ezra again that night, correct?
No. We left Racy's to go to the art pop-up, and the last time I saw her that day was when she was talking to Jason by the alleyway at Racy's.
And so...
Which is why she didn't show up, sorry.
You're fine. I just want to make sure I get the chronology right.
Yeah.
We had Jason and Ezra outside, correct?
Yes.
You don't see Ezra anymore.
Right.
You see Jason yelling at Alex.
Correct.
Jason yelling at John.
Correct.
John and Alex leave.
Alex was still outside. I don't remember where John went.
You come
He
out.
might have still been inside. I know he came back inside.
You come outside and you observe Jason.
I only saw Alex on the bench at this point. Jason and Ezra were off talking in the alleyway area.
So you came outside and you observed Jason.
I observed Alex.
In addition to observing Alex, you observed Jason.
I suppose. Not close.
Sure.
But yes.
You saw him with your eyes.
Yes, while I was leaving, yes.
And he was in the alley.
Yes.
And he was in the alley with Ezra.
Right.
And that's the last that you saw that night, correct?
Yes, correct.
Okay. That's all I have. Thanks.
Any redirect?
No.
Okay. Thank you, Ms. Larson. That's all. Please step down. And she released from her subpoena, free to go?
She is for today, but she's not fully released.
Okay. So you may have some reason to recall her?
Yes.
Okay. Okay, I want to go back to the sidebars that we had during these last few witnesses. The most recent sidebar, about 4:05 p.m., during the testimony of Ms. Larson, there was an objection that the defense and Mr. Nelson made when there was reference to us filing a sexual assault report or filing a report of sexual assault, something along those lines.
So,
we had a sidebar. Mr.
Couple things. So first of all, I love it. Like I mentioned this earlier at the beginning of the stream or early in the stream about how he always does this. He discusses, what they talk about at sidebar, puts it on the record, which again, I think is because of the fact that, they don't have the transcripts immediately. And this way, if they need to refer back to a ruling or something that was talked about, they have notes. I think it's great. But also, how awesome is it for us, right? Because this is as close as we're going to get to learning what they talk about at sidebar, right? So this first sidebar he's referencing here has to do with the sexual assault claim about John Hanson, right? Because that was the first time Ezra did that. And, that was, we heard from that first witness, what was her name? Samantha Cobes, about how she had said to Alex about Ezra, do you think she will do that to you also? So let's hear what they're going to say about this. This end of day housekeeping is really interesting. There's some really good lawyering going on, I think.
Nelson, anything else that you want to put on the record with respect to that objection?
No, Your Honor, sustained the objection, and the state moved along, so.
All right. Ms. Notoff, anything else you'd like to put on the record regarding that?
No.
Okay, and just for clarification, for future witnesses, as I understand it, and we're going to hear evidence about how all that came about, that evidence is not yet in the record. However, as I understand it, and correct me if I'm wrong, but that the defendant did not actually go and file a complaint or report with a law enforcement agency, that it came up as a result of someone else calling the police, and then there ended up being an investigation, but it wasn't that she went and filed the report. Anybody disagree with that at this point?
Judge, I think it's a little bit splitting hairs. The incident, there was somebody else called the police, responded to Josh Triankler's house. That's who called the police. It was because Jason Mengel and Ezra had come over to the residence, and Jason was upset about John Hanson. The officers who responded talked to Miss McCandless, and she actually was given the opportunity to talk somewhere else. She requested that they go to the police department to speak. That's where she described multiple incidents of unwanted behavior at the hands of John Hanson. So
That's not correct.
There are police reports which detail this information. And
I believe I've read those police reports, but that's my understanding of how this came about.
I agree with how it came about. I don't agree with his summary of her statements. Her statements are recorded, and
well, and again, there will be a witness related to what she
Yes,
said
tiny
about
cup
that,
also.
and I'm assuming the state will put that on. Okay,
I guess they give everybody tiny cups in Wisconsin.
so, but maybe it is splitting hairs a little bit, but I think given the pretrial rulings and so forth, I mean, the court is going to allow the evidence of those facts and circumstances, but had ruled that the state is not allowed just to say she filed for the purpose of attacking her credibility and saying she filed a false report. As I've indicated, it may appear, when all the facts are out, but that maybe she was less than candid.
Yeah, let's talk. This is interesting. So I want to know what you think, Maisha. So yeah, this police, like he said, thank God, he said it's going to come in, which means we're going to learn about it. Again, I don't think any of this is anywhere on YouTube. This never was in any of the summaries or whatever. This is why I love this shit, right? Because this actually really fucking matters. This is the first time she makes a false claim of sexual assault, right? And we're going to go to, I have it in the video from Hipster Business that's going to become relevant of what happens in opening statements, because they're going to be arguing about this. But we're going to have to hear from the dude who got the police involved. What did they say his name was? Josh something. And then I would imagine the way the police report's going to come in is from the police officer, whoever it was. But this is interesting as to why there's all this discrepancy about it, right? Because, again, it is documented. And so even if it hasn't come into evidence in front of the jury, they should all be on the same page, right? So I'm wondering what your thoughts are, Maisha. I'm going to play this for another second, though, while I await your response.
Maybe not, but that's not the point of allowing that testimony in. The point of allowing that testimony in is for the background panorama evidence, as in the court's provisional ruling. So in any event, go back to the next
Right. Yes.
most recent sidebar, I believe was.
It is. Yeah, what's going to happen is it's going to have to come from the law enforcement officer, and we're going to have to wait to see. I don't think that's on you. This is, dude, how interesting though, right? And the other thing is, again, I'm really surprised. I don't know how the fuck, to my knowledge, John Hanson does not testify. Now, it's possible that maybe I'm wrong, maybe because, again, it's not all on YouTube and I haven't been through everything in the archives yet as I'm going through it in chronological order. Maybe I'm wrong, maybe just, but I mean, I don't know how the hell he got out of that, first of all. But it's interesting too that any of it is even really okay, from the standpoint of the fact that she made these allegations about Alex, right? And these allegations that she made prior about John Hanson were proved to be false, it's interesting that it's even really allowed to come in, because it is kind of like a 403, 404 issue of like prior bad acts, right? Of like, she has a habit of doing this, or she's done this before. So again, to me, I think it's completely relevant in terms of understanding what happened, but I am surprised actually that any of it's really being let in from a standpoint of like the federal rules of criminal procedure and whatnot. But I'm sure we're going to hear more about it, right? Because he said there's a provisional ruling, and we don't know what that is yet. That's why I wish we could get the court documents. Maisha says, I'm learning a lot from watching this trial for the first time. Awesome. That makes me so happy. I'm learning a lot too. This is why we love live trials. So yeah, awesome. We love it. Learning is scrolling, as I always say.
Ms. Kexel was on the stand, and I didn't know the specific time. Oh yeah, 3:42 p.m. I'll call it a double sidebar, because we had a sidebar and then we returned to that.
Love it.
This related to, it was the defense had made a motion in limine previously about excluding lay opinion testimony. I believe at the sidebar, we basically clarified that the witness could testify to what she observed and what was what Ms. McCandless had said, but they could not be giving opinions about Ms. McCandless struggling with gender identity. And counsel, either Mr. Nelson, Ms. Murdaugh, wish to make any further record with respect to that?
That's it.
Before they may put something on the record. So yes, so Maisha says showing her making false allegations goes against her code. Absolutely it does. But that's exactly why I'm surprised it's coming in. because 404, right? Like, oh, I don't have that pulled up. So, well, hold on. I've got the book. Let me just look at the book. Let me read. I've got the hard copy. So 404. I'll read from the book since I don't have the website pulled up. Character evidence, other crimes, wrongs, or acts. Prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion, the person acted in accordance with the character or trait. Here are the exceptions, okay? Exceptions for a defendant or victim in a criminal case. The following exceptions apply in a criminal case. Defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, prosecute. And actually, this is like almost verbatim of what we read earlier with the Wisconsin Rule 90404. But let me see if it's exactly the same. Yeah, it is like pretty much exactly the same, I think. So, but the important part here, the exceptions were really more important for the prosecution, for what they were arguing about being able to ask about Alex's tendency to be peaceful. Here, it's the other way around, where what's relevant is really the first part, which is when it's prohibited, right? Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. So like what that's saying is it's prohibited if you're trying to show because they did it then, they're doing it again now. So hopefully that makes sense. So I totally agree. It goes against her credibility, but like this is the checks and balances in terms of just the way that the rules work, right? This is the checks and balances in terms of what's written from like the legislation, because think about it, right? This is the whole thing. It's all the strategy, because you're absolutely right. It does go against her credibility, and it's completely relevant here. Like that's what I was saying. And the reason why it's so interesting is because there's a rule 404, that specifically gives reasons why you can't do that, right? And this came up a lot in Murdaugh, right? It came up, there was a ton of 404, 403, 404, right? For example, with the financial crimes, because the defense kept saying that the prosecution was bringing up the financial crimes to try to say, because he did these financial crimes, he would also do murder, right? So so different, but kind of similar, right? So, and there were some other things as well that happened with 404 there. So we hear this all the time in trials. 403 and 404 are really common. And so then you have to find ways to get around it, right? Like with the so for every rule, there's an exception. So it starts with the rule. The rule is here's when it's prohibited, right? if you're going to try to prove that on a particular occasion somebody did something and so therefore they're going to do it again type thing, right? And then the second part is all the exceptions. Isn't it brilliant? So then that's where it's up to the attorneys to argue for whichever side they're on. Do they want the way it's prohibited, or are they trying to say, no, there's an exception? So that's why it's so fucking interesting. I love it. And actually, sorry, here's the section with the other crimes, wrongs, or acts. Here we go. This is subsection B. Other crimes, wrongs, or acts, prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with that character. And then here's when it is permitted. So essentially, these are more exceptions. It can be used to prove motive, opportunity, and here we go. Let me read this in full because this might be really relevant here. Permitted uses. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. And that's how in Murdaugh they got it in, because it was used to prove motive. That's how they got the financial crime stuff in. That was how they got around this whole thing with the 403, 404. They said it's used to prove motive, right? Notice in a criminal case. In a criminal case, the prosecutor must A, provide reasonable notice of any such evidence that the prosecutor intends to offer at trial so that the defendant has a fair opportunity to meet it. B, articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose. And C, do so in writing before trial. So this is saying if they're going to try to introduce any evidence about, other crimes, wrongs, or bad acts, as they say. And now here's also methods of proving character by reputation or opinion. This is exactly what they're talking about right now, dude. Holy shit. Let me read this part. This is Rule 405, subsection A. When evidence of a person's character or character trait is admissible, it may be proved by testimony about the person's reputation or by testimony in the form of an opinion. And this is literally what they're just talking about. On cross-examination of the character witness, the court may allow an inquiry into relevant specific instances of the person's conduct. And this is what they were arguing about earlier, where they said it needs to be specific. So then here's subsection B, specific instances of conduct. When a person's character or character trait is an essential element of a charge, claim, or defense, the character or trait may be proved by relevant specific instances of the person's conduct. Now here, this matters because it says person. So it's not it doesn't say defendant, it says person. So again, what's really funny is these rules are being used for Ezra, for Alex, and even for Jason. Sometimes it's come up. But like with Alex, again, they're trying to show this tendency towards peacefulness, right? The prosecution is, right? And then with Ezra, right? This right now, at least, it's coming up about this whole thing about filing this police report, or we don't really, jury's still out on who fucking filed it, right? But these allegations of sexual assault that turned out to be false. So anyway, isn't it so fascinating though? Okay, so let's keep going. Learning.
Accurate recitation of what we said.
Okay, Mr. Nelson.
That's accurate, and if the defense preference is if the state is going to do that, since there is a very narrow purpose of that and a narrow way to put that in, we will not be objecting if they simply lead very directly to make sure that they're only saying what the court has ordered they can say. What did you see? What did Ezra tell you? Those things alone.
All right. And then, again, the court had ruled that we're not having people's opinions, that's not relevant, what their opinion.
I'm going to back it up a second to make sure, because I can't remember if they moved on from the police report or not. But I will say, whatever the thing is, that's very fair of the defense to say that. They're saying and it's a great suggestion. And this doesn't happen often, but it does happen. I've heard it in other trials where they say, okay, we want you to lead, right? Isn't that so wild? We want you to lead. Like, in other words, you have to lead the witness directly to the answer you want specifically, because by asking the question more generally, you could end up with information that's not admissible, right? Isn't that crazy?
Most recent sidebar, I believe, was Ms. Kexel was on the stand, and didn't know the specific time. Oh, yeah, 3:42 PM.
Oh.
I'll call it a double sidebar because we,
Okay. I wonder if what they're talking about is here, they got into the questions about the gender identity and then like the piercings. So let's see.
had a sidebar, and then we returned to that. This related to, it was the defense had made a motion in limine previously about.
Yes, I think it is because that, remember, I even said, oh, the prosecution won that one because they were able to ask questions about the gender. So let's see.
Excluding lay opinion testimony. I believe at the sidebar, we basically clarified that
About what?
the witness could testify to what she observed and what was what Ms. McCandless had said, but they could not be giving opinions about Ms. McCandless struggling with gender identity.
Okay, there it is. There it is. Okay, yep.
And counsel, either Mr. Nelson, Ms. Murdaugh, wish to make any further record with respect to that?
That's an accurate resuscitation of what we said.
Okay, Mr. Nelson.
That's accurate, and if the defense preference
I love
is
that they were
if
doing
the state
this.
is going to do that, since there is a very narrow purpose of that and a narrow way to put that in, we will not be objecting if they simply lead
Incredible.
and lead very directly to make sure that they're only saying what the court has ordered they can say.
It's
What did you
interesting.
see?
I want, see, this makes me want to know what else is out there, right? Right, like what is the thing that they don't want to come in? I'm really fucking curious.
What did Ezra tell you? Those
Interesting.
things alone.
All right, and then again,
What are they
the
worried
court
about?
had ruled that we're not having people's
know.
opinions,
Probably.
that's not relevant, what their opinion
We would,
was.
the only way we see this is the thing. We need a scroll in Wisconsin. Though the answers to the answer to that question is out there, and I'll tell you where it is. It's in the motion in limine, and that is available, but you have to be in person in Wisconsin to get the court documents. If we had someone who could go in person and get the court documents for this motion in limine, we could learn exactly what it is that they were worried about coming in.
Okay, anything further
being
on
nosy.
that? Okay, as it relates to, I think really what is sort of an unresolved issue, and that relates to section 90405 subsection 2 and any specific instances of
There we go.
conduct, would ask the council overnight if you would kind of refine your positions on that, and we'll take that up.
This is when it gets really
and
interesting.
Unless you want it, you're prepared to make some more argument about that now. I don't know that I'm going to be able to get through State versus Evans in just a couple of minutes.
I think, Your Honor, Evans and is probably.
It's so crazy because this is the end of the day, and the attorneys are like, "We're not." They are ready, dude. They are just like, they are here. So is the judge, but the attorney's like, "Dude, you gotta just, yeah, thank you, Maisha. Calling all Wisconsin squirrels." Dude, they really go hard in the paint. This is awesome to see. I love it. This is some really good arguing.
Is a good case as it relates to that. It makes it very, it goes through methods of proving character and talks about this, and it goes through the committee notes to Federal Rule 405. In that case, it didn't allow it, but
That's literally what we just read. No, wait, sorry. We reread 404. Let me look.
that was because it's essentially in Evans, the specific instances of conduct were instances of the.
We did read that. Rule 405 was the methods of proving character, with the one where it said by reputation or opinion or by specific instances of conduct. So we did read 405. Cool.
Complaining witness in that case having lied, and it was a case of sexual assault, I believe, if I recall correctly. But at any rate, yes, sexual assault, and there were specific instances where they claimed that the witness had lied, and the court said, that's not an essential element. Whether she is a liar or not a liar is not an essential element of the offense. Here we're dealing with character for peacefulness, which, because of the defense, is an essential element. Yeah. Certainly, it's not an element that we have to prove normally in first-degree intentional homicide. Counsel is correct. There are normally two elements. However, because of the fact that the defendant.
So remember earlier when they had the mid-afternoon housekeeping, and remember when I said that he fucked up because he said the word element, And then the female defense attorney, I think her name is Deja Vishni. And then she went off on the whole thing about the elements of homicide. And I was like laughing because I was like, he kind of stepped in it. He prepared during these other witnesses, dude, he prepared a way to argue. He's like, I'm not done with this argument yet. And I'm going to find a way to make it seem like I didn't fuck up. And elements, dude, this is awesome.
It has raised self-defense, and I believe they're going to have a sufficient
He did not want her to let her get the better of that exchange is what this is.
basis and meet their, I don't know if I want to, I'm not sure that's exactly a burden of production, but at any rate, there's going to be sufficient evidence for them to get an instruction on self-defense. Under those circumstances, we have to prove beyond a reasonable doubt that the defendant was not acting in self-defense, and a part of that is going to be the character for peacefulness of Alex Woodworth, because that's a portion of what we can use to prove that she was not in fact acting in self-defense, because we're entitled to prove his character as part of our proof that she was not acting in self-defense. Statute specifically, 90404 specifically permits that, and 90405 describes how you can prove it. And because it is an essential element of the case that we prove that she was not acting in self-defense beyond a reasonable doubt, it becomes an essential element of the case that we can prove by specific instances of conduct. That's essentially our argument.
Judge and we disagree. If
I understand you disagree.
Well, but I just want to, the defense is her state of mind. And I understand that the state can put in character evidence of his reputation or opinion for nonviolence. But specific instances of conduct, that's different. And the reason it's different is specific instances of conduct have nothing to do with her state of mind, her belief. If whatever these specific instances of conduct, which the state has still not told us about, but if they had these specific instances of conduct that they had reason to believe Ms. McCandless was aware of, I think that might be applicable. I'm not saying it is, but only under that scenario. But if it's somebody else's experience, and there's nothing to connect that to Ms. McCandless having knowledge or awareness of that experience, I don't see how that would get in, especially when, in this case, Your Honor has already ruled that the defense is prevented from putting into evidence any character evidence of Mr. Woodworth regarding his writings post this February 24th event, after which Ms. McCandless no longer had access or read or spoke with Alex. And so under that reasoning, if the reasons that those later portions of his journal are not admissible is because Ms. McCandless didn't know about them, how then can the state come back and say, we're going to put these specific instances of conduct in that some other witness knew about, but no proof that Ms. McCandless knew about, so it is not essential to their disproving her belief or the reasonableness of her belief, because they have no foundation to say she knew about it in any way, shape, or form.
Well, I don't believe that it is the same. You're, again, I think conflating the McMorris evidence, the McMorris rule, basically, and the court not allowing other information or other character evidence that the defendant was not aware of. It's different. I don't believe that specific instances of conduct would have to be something that she would be aware of under the circumstances under 90404 and 90405 in a homicide case where, again, the defendant has essentially made a claim, and at this point, not by evidence, but by opening statement, essentially, that he was the first aggressor. I think that's the rule. Now, I'm trying to think of how, ever a character trait would be a essential element of a charge, a claim, or a defense if it wouldn't be under these circumstances. So, but that's, I'm going to do some reading and sleep on that.
And again, with Court Fox, just so that the court and everybody's aware, the testimony is going to relate to specific discussions he had with Alex about the use of self-defense, the use of violence in self-defense, which conversation occurred in sometime during March of 2018. He doesn't remember the exact date. It is clearly after the breakup between the.
Wow, so he said March 2018. Okay. Wait, hold on. Yeah, no, that's right here. So March of 2018, so that is super relevant because that's the month. So this murder happened March 28th. Wait. March 28th, 2018? Either the 22nd or the 28th. I think it's the 28th, but in March. So this is the same month.
Defendant and Alex, because there was also discussion of the breakup and whether or not Alex was going to be interested in going back with the defendant if she was interested in it. So it's all part of the same discussion. So it occurs in, a time frame very, very near to the events
March 22nd is when it was.
at issue here. So it's not, I don't think a quote specific instance of conduct, close quote, but a discussion as to Alex's state of mind and what he would do and his beliefs as it relates to violence. And as such, I think so I don't know that it's not technically specific instances of conduct.
Well, if it isn't, then why would it be otherwise admissible then?
I believe it would be, it's a discussion. It comes in as it's a hearsay exception for then existing mental or emotional state as far as its admissibility, as far as the hearsay portion of it, and as far as relevance, it goes towards his character trait for peacefulness.
Yeah.
Well,
it's relevant.
Okay, Mr. Nelson, I know
he says it's not being offered as a specific instance regarding character trait, but then he finishes his argument by saying it goes to his character trait. And so they're trying to offer it in under 90404. And the only way you offer it in under 90404 is opinion or reputation or a specific instance of conduct. And they've conceded it's not a specific instance of conduct. We think we would all agree it's not opinion, it's not character, so it's not admissible. It's
okay. Well, I'll let you finish up your argument tomorrow.
I love this so much.
But just part of that, Judge, is when it talks about conduct, that's different than hearsay. What people say they're going to do, I don't think has as much weight as what somebody observes somebody actually doing.
Yeah.
Actions are what we're talking about.
Okay. Now, the next question is, do you have any other witnesses where this is going to be an issue tomorrow? And if so, what would be the specific instances of conduct?
Don't believe so, Your Honor.
Can you tell us who the witnesses are for tomorrow?
Hang on.
So we're going to hear about these witnesses. It sounds like they're intending to call Court Fox. I don't know that they get to him that on day 3 or not. We'll see.
I'm just going to get to that, but I just, and I would, again, appreciate a little bit of a heads up or what I need to prepare for tomorrow.
I believe it's just Court Fox, and he's our first witness.
And if we're on Court Fox, and I just heard in passing that Mr. Fox may testify about the journals.
What I will say, because I've already started working on the next video, I'm not done with day 3, but they do not call him for, like, he's not the first witness. So something must happen. Now, at the beginning of the day, there's a housekeeping, but I haven't listened to all of it. I went ahead and put it into the video, but I haven't listened to all of it. So I wonder if what happens is overnight, the defense finds some case law and they are successful and they don't even call Court Fox. Or maybe something happened to Court Fox and he has to come another day. I don't know. But they're saying they're going to call him first thing in the morning, and he's not the first witness. It's law enforcement, I believe, is who it is.
I understand if he can lay a foundation, the journals could be admissible through Court Fox. We're not saying that's not the case. I don't know if he's going to be up there giving his interpretation of somebody else's writing
Again, perhaps I'm paranoid, but I'd heard mention that he was going to talk about the journals. So,
and he is going to explain what they mean. Counsel has tried to, read very limited portions of journals and try and paint a picture. And I believe, based on that, the state is entitled to.
Okay, this is really important. We're going to back that up a second because I've got something. We're gonna look at this. Okay, so but Spencer has a question. So he says, quick question. So why could they ask a witness, what did you ask so-and-so person? And then get to say what they ask and then what the person said. So what you're talking about is hearsay. So it would have to be that there's an exception. So again, hearsay is an out-of-court statement that is offered to prove the truth of the matter asserted. So it could be written or verbal. So that includes text messages, right? An out-of-court statement that is offered to prove the truth of the matter asserted. So first thing is, if it's not offered to prove the truth of the matter, Spencer, it's not hearsay. So it has to be the truth of the matter asserted. So it's like a factual thing, right? For which there's no actual evidence. So that's the truth of the matter asserted. So if it's not offered to prove the truth of the matter asserted, then like an example I can give you from Deputy Hertz, because they argue about it in a sidebar, is with Amber on the stand on direct, and they're talking about some incident that happened at Christmas, and the wine got spilled on her, and the whole thing about I'm sorry, or Jack says something happens. She says, I'm sorry, Jack, and then Jack says, are you okay, or something like that, right? And then Elaine argues and says it's not, because they were talking about hearsay, and Elaine says it's not offered to prove the truth of the matter that she was okay or not. It's just offered to show that it leads to the next thing happening or whatever. Basically, that was an example of like, the truth of the matter is not, did Jack think such and such thing, right? That was not the point. So that's just an example. So if it's not offered to prove the truth of the matter asserted, it's not hearsay, okay? Then there's a bazillion exceptions to hearsay, right? So like, just to name a few, like, mental state of mind, as Elaine would say, like, present sense impression, oh my God, why am I'm like, my brain is like drawing a blank. There's, let me see here. Excited utterance, let's see. Excited utterance, declarant unavailable. Then existing mental, emotional, or physical condition. Records of regularly conducted activity. The business records exception. Absence of a regularly conducted activity, public records, right? So public records are an exception. Certificates of marriage, family records, statements in ancient documents. Like, I'm thinking, like, what the hell is that? Like the shit from the Egypt times. What do you call those things? You know what I mean? The scrolls. Anyway, the rest of these are just getting less and less things that you hear, but yeah, so the main ones that you hear the most would be the present sense impression, excited utterance, then existing mental, emotional, or physical condition, statement made for for medical diagnosis, recorded recollection. So if you recorded it at the time, records of regularly conducted activity. So that's like business records exception, right? Anyway, so does that answer your question, Spencer? Typically what they will be able to do is they would be able to say, if they're able to get it in, it would be about what they asked the person. But in terms of what the person responded with, that would typically have to be coming from, they would have to call that person as a witness, typically. Spencer says, okay, so in this case, a young woman that knew the guy who got stabbed was asked, what did you ask him? And she got to say, okay, I see. I asked him, right. So you're almost right. You're almost correct. What she did was, She wasn't allowed to say anything about a question she asked him. She was only allowed to say what she said to him. That was what happened. That was what happened. So she was not allowed to say about anything he said or any type of questions. She was only allowed to say what she said to him. And what she said to him was, I'm afraid, or no, sorry, I'm wrong. Hold on. She said, do you think she's going to do this to you also? But she couldn't say his response. That's what it was. Okay, yeah, that's what it was. She was allowed to say what she said. What she said was a question, but she wasn't allowed to say his response, which is interesting because, again, in this case, there could almost be another exception there because the declarant's unavailable. So I'm kind of surprised they weren't able to get that part in for that. Maybe that's what they're about to be talking about again. Although, no, I think they've moved on to the journal thing. But oh, right. And then that part, that was a second, that was like, I see what you mean. Okay. I think that was a second question though, Spencer. Let's back up and find it. I think that was a second question and that matters. Let's back up and then we'll come back to where we are. Let's go back and listen to it because that does matter. So we're at 40812. Let me back it up and find that spot. We will listen to it. And this is the right witness, isn't it? So hold on, let's just see.
And you found that out from Al.
Okay.
Debriefed about some of the things that she'd been going through in that relationship. And,
no, you're okay.
You know, I shared some experiences as well. It was kind of just like a bonding moment, the importance of kind of leaving those.
And so, was there anything specific she told you about the relationship with Jason Mingle?
Told him that Ezra had reached out and was showing interest as well. Up to that time, I didn't know that anything had happened between us. He had paid the $30 application.
Going forward a bit.
Hearsay, irrelevant.
Well, so you're saying it's what did this witness say?
Yes.
to
What did you say to Alex?
Okay, this is it. Let me back it up. This is the one. This is the one. All right.
I guess I understood why he was upset.
Did you also learn that there was a potential sexual assault investigation pertaining to the defendant and John Hansen?
Okay.
Yes.
No foundation.
No rule. I think this sounds like a foundational question.
Were you aware that the defendant and John Hansen had some sort of relations?
Objection, no foundation. This witness does not have a foundation to testify.
Well,
Her awareness is not based upon personal knowledge. It is based upon gossip or hearsay.
all right. Well, I guess let's start that way. Let's go back. Foundation, any person.
And I can move on. Did you ask?
Okay, so she's moving on from that one, so that one didn't get answered. But the question was, did she know about the whole thing about basically the police report with John Hansen?
Alex something about the defendant?
Okay, I talked over it. Hold on, let me back that up because hear her exact question.
This does not have a foundation to testify.
Well,
her awareness is not based upon personal knowledge. It is based upon gossip or hearsay.
all right. Well, I guess let's start that way. Let's go back. Foundation, any person.
And I can move on. Did you ask Alex something about the defendant and her relationship with John Hansen?
Objection.
So there, it's an asking him.
Hearsay.
Sustained.
That's her statement.
Interesting, because she says that's her statement. It's not a statement, it's a question.
What did you say to Alex?
So she changed it. This is why we were confused, Spencer, because it is a question. But the way she weaseled it. Now I have to say, I'm glad Spencer, thank you. I would never even caught this little detail. I did not catch this. Thank you so much for your questions so that we can go back and watch this because she weaseled it, man. She weaseled it. We have to call it like we see it, man, because everybody can be a weasel. Like, this is the thing. Anyone can weasel. She's weaseling. Because, let's listen again. She says it's about what did she ask, and then she changes it to say, even though it's a question. Hold on, look at this.
This does not have a foundation to testify.
Well,
her awareness is not based upon personal knowledge. It is based upon gossip or hearsay.
all right. Well, I guess let's start that way. Let's go back. Foundation, any person.
And I can move on. Did you ask Alex?
Did you ask Alex
something about the defendant and her relationship with John Hansen?
Objection. Hearsay.
Sustained.
That's her statement.
See, she realized that she fucked that up. The problem is that it's not a statement, right? It is a question.
So what did you say to Alex?
So she's changing it. Fucking hell, that's weaselly.
Regarding a sexual assault investigation.
Objection. Hearsay. Irrelevant.
Right. He's right to keep objecting for that. Yep. She's weaseling it.
Well, so you're saying it's what did this witness say
Yes.
to Alex?
What did you say to Alex?
But see, the witness already knows that what the answer that she's looking for is a question that she asked him, right? She heard that first.
It's her statement to Alex.
Not a statement. Oh my God, that is so weaselly. Dude, the weasel.
Well,
wow.
All right, I'm going to overrule. I'm going to allow you to answer the question.
And remember, I actually said this when we watched this the first time. I was like, I'm surprised you overruled that. I said that. I'm still surprised. I'm even more surprised now.
I was aware that there was an accusation between the defendant.
Move to strike. No foundation.
Okay, well, I'm going to strike
This is the first sidebar.
the beginning of that answer, but if you would just answer the question. What did you say to Alex without any background or explanation? What did you say to him?
I said, do you think she's going to also accuse you of sexual assault?
Okay. She actually handled that really well. She has no idea what the fuck was going on with all that, right? She doesn't know. But she did a really good job because she answered it exactly. And she said, I said, and then she stated a question, which is really interesting. Because see, my reaction, like my gut reaction to that would be, well, I would be like, well, how do I do it? Because I didn't say, I asked, right? Like that's how I interpret it. But she did a really good job. She doesn't know she did. I mean, you know, again, the prosecution got lucky with that, I think.
And
because that's not a normal thing. Like to me, it would feel unnatural to be like, I said, and then state a question, right? Am I weird, or do you guys also agree? Like, would you feel weird saying that? I'm just thinking if Amber could do that, if they allowed that. Elaine would have gone to that over. Right. It's very much, so first of all, there's a lot of differences because Deputy Heard is a civil trial and this is a criminal trial. So while there are a lot of rules that are the same, there's things that are different. Then you have state differences by the state, right? And then even within the state, you have differences by the judge because there's some judges that, I mean, this is just the way it is. It's like lawyers that get used to practicing in front of the same number of judges wherever they live and practice law, they kind of know how those judges are going to tend to rule and what those judges are going to want to hear for argument and shit like that. And so depending on where you're at and what the trial is and then what judge you're in front of, things can actually be completely fucking different. So, you know, a great example, Spencer, in Karen Reed out of Massachusetts, I don't know if you watched that, but that was a really weird one because that judge did not allow any reason for an objection. It was wild, right? So when anybody would object, they just say objection and she just overrules it or sustains it. But she wouldn't allow them to even state the legal grounds. Like they couldn't even say objection hearsay or they couldn't even use the rule. They couldn't even say objection, you know, 801 or whatever, right? Like they couldn't even just say the number. They had to say one word objection and then she just automatically would overrule or sustain. Isn't that wild? And that's just her practice. That's her practice. And judges are allowed to do shit like that, which, you know, who knows? I'm not even gonna get into how I feel about that because it's a whole thing. So, right. So this next part isn't the proof. Okay. The next part, right. The next part, you're right. And the thing is we don't know yet. His phone records, by his, I mean Alex, the phone records and the text messages and shit might come in. I don't know. I don't even know yet. That would be normal, right? For the text messages to come in between the two of them. God, I wonder if that, I hope that happens. God, wow, that's going to be interesting if that happens. But at the same time, it's like, how can it not, right? Because like they always come in. Okay, so like what she says next. Okay, let's keep playing it. Make sure that I fully get to. I want to fully get to this. What you're saying, Spencer. So let's make sure.
how was Alex's demeanor when you made that statement?
He said he didn't know, but he wasn't worried about it because he had months worth of text messages to prove that it was a consensual relationship.
Interesting. So here, listen to the question. I'm not going to, it'd be hard to get to the right spot. The question was, what was his demeanor? The prosecutor asked the right question. I think the defense was not sure if they should object or not, and then they kind of missed the boat because they could have objected to her answer because the question was fine, but their answer was hearsay. Now, having said that, again, I mean, technically it's a declarant unavailable, so maybe they knew that maybe that's why they didn't object. Actually, I take that back. Yeah, declarant unavailable, so maybe that's why. I bet that's why they didn't object. Right. Okay, I'm disagreeing with myself. Okay, let's listen one more time.
Hearsay, irrelevant.
Well, so you're saying it's what did this witness say
Yes,
to
what did
Alex?
what did you say to Alex? It's her statement to Alex.
Well, all right, I'm going to overrule. I'm going to allow you to answer the question.
I was aware that there was an accusation between the defendant.
Move to strike, no foundation.
Okay, well, I'm going to strike the beginning of that answer, but if you would just answer the question. What did you say to Alex without any background or explanation? What did you say to him?
I said, do you think she's going to also accuse you of sexual assault?
And how was Alex's demeanor when you made that statement?
He said he didn't know, but he wasn't worried about it because he had months worth of text messages to prove that it was a consensual relationship.
And were you personally...
A couple things. I think one thing is this. I think and remember, there's motions in limine, and there's things we don't hear at the side. I'm wondering if one of the things that was decided by the judge was that they're allowed to ask a question. Like the way the prosecutor asked that question was, what was his demeanor, right? And that if the response is with something that would be hearsay when it comes from the declarant who's deceased, in this case, Alex, that's fine. Maybe what they ruled is that they just can't elicit that. And what I mean by that is this, that the prosecutor can't say, what did Alex say to you, right? And the reason I'm saying this is because that's not what she asked, right? Like the way she asked that question doesn't actually make logical sense. Like for her to have said, oh, what did Alex say back or whatever, like, or how did Alex respond? That would make more sense. But for her to say, what was his demeanor is like, doesn't really follow logically. But her response was what he said. And so I think that's why it's allowed in this case. Now, again, it's because the declarant is unavailable, but I still think that she couldn't have asked it that way. I think it would have been objected to. I think that's what they decided, which is like a compromise, right? It's like if the witness says something and it's hearsay, but there's an exception because the declarant's unavailable, then it's okay. But the prosecutor can't directly be like, what did he say? If that makes sense. But you're right. It is for the truth of the matter. So it is hearsay, but there's an exception. That's what it is. Yep. Spencer. So they knew from the jump that the Weasley lady is getting in some hearsay, but then they just kind of cave in. So initially that's what I thought, but then I disagreed with myself. I disagree with myself because I remember that there's an exception because the declarant's unavailable. So the Weasley part, I think, was with the part with this witness. The Weasley part, because the declarant unavailable, that is what it is. The Weasley part was in the initial part with this witness, right? Because what this witness says is hearsay. What this witness says is hearsay. That's the harder one to get around. And so the part that was Weasley was the part where she's like, what did you ask him? Now that now it comes full circle. Yep, that's exactly what it is. Because again, remember, that's what it is. Eureka moment. I was right. Because by saying, yeah, that's what it is. That's what it is. We figured it out, guys. Well done. So if she says, like her initial question, right, was like, what did you ask him? That would be eliciting. That's it. That would be eliciting hearsay. Even though so that was the compromise. Even though there's an exception, the compromise was she can't elicit that on purpose, right? Think of it almost like leading in a way, okay? So then that's why she corrected herself and was like, oh, what did you say, right? Even though it's a question. So, dude, that's what it is. That's what it is. So the prosecutor's like, what did you say? And she responds with the question she asked. And then the prosecutor's like, and what was his demeanor? And then she responds with what he said. So she's allowed to provide the hearsay, but the prosecutor's not allowed to elicit it, I think is what they kind. Does that make sense, guys? No, seriously, your questions and your thinking it through with me is so helpful. 100%. Yeah. Because you pointed out a lot of really good things, Spencer. So hopefully that makes sense. Like that's what it is. That's why the questions matter. And again, in this case, the reason she's allowed to respond and the response is allowed to come in is because of the declarant being unavailable. But the compromise was the prosecution can't just straight out come out and ask what Alex said. So, okay, so let's go back to where we were. Yay, learning. We are learning so much today. Let me back it up just a smidge. Okay.
It's about conduct. That's different than hearsay. What people say they're going to do, I don't think has as much weight as what somebody observes somebody actually doing. Actions are what we're talking about.
Okay, now, the next question is, do you have any other witnesses where this is going to be an issue tomorrow? And if so, what would be the specific instances of conduct?
Don't believe so, Your Honor.
Can you tell us who the witnesses are for tomorrow?
Hang on, I was going to get to that, but I just, and I would, again, appreciate a little bit of a heads up of what I need to prepare for tomorrow.
I believe it's just Court Fox, and he's our first witness.
And if we're on Court Fox, and I just heard in passing that Mr. Fox may testify about the journals. I understand if he can lay a foundation, the journals could be admissible through Court Fox. We're not saying that's not the case. I don't know if he's going to be up there giving his interpretation of somebody else's writing. Again, I'm paranoid, but I'd heard mention that he was going to talk about the journals. So,
and he is going to explain what they mean. Counsel has tried to, read very limited portions of journals and try and paint a picture. And I believe, based on that the state is entitled to give the jury what it actually means by considering the whole of. He quoted to Ms. Cobb's 3 articles. I'm going to ask Mr. Fox if he's read those whole articles. He is also a philosophy major. He had numerous discussions with Alex about philosophy. They would sit at the joint and discuss philosophy for hours on end.
With a joint.
And I will ask him I'm going to ask him overnight to read those 3 articles that in their entirety that counsel quoted a very short snippet of. And actually there are 4, I'm sorry, not 3. And
before they get into that. So Spencer, you are allowed to ask as many questions. And you know what's funny? I don't know what happened tonight. We didn't have that many people in the chat, and there's been very few questions and no tangents, which is weird. And so I'm actually really happy to be able to interact with people and go off on it wasn't even a tangent. It's completely relevant. And it was a great question. I mean, these attorneys were arguing over it for a reason, right? Because it's not cut and dry. That's how the law is. So did you say somewhere earlier, Spencer, that the only other trial, I guess, that you've watched, Gavel-To-Gavel, was Deputy Heard? So this is your second trial, or did I imagine that? That's my first question to you. My second question to you is, did you watch the previous episode? And if so, did you watch the tangent? Maisha, are you still here? That was the best tangent ever with the little flying dude, and we did our world tour. Oh my God, that was my favorite thing. There she is. I'm too busy learning to ask questions. So that was literally my favorite. That was so much fucking fun. Oh my God. that reminds me, I was going to, I swear to God, Bermuda's was in the wrong place. I'm still not sure why Bermuda was where it was, but I need to remember to look up the history of that. And like, why is it so close to North? Anyway, we we had like the Man with the Hat, we had Bermuda, we had the Great Lakes, and then Alaska. Oh my God, that was so good. That was the best. It was so fucking fun. Yeah, so Spencer, you didn't hold anything up, man. This is the purpose of live streams right here. Okay, so we can answer questions and we can do scroll through world tours spontaneously. So yes, so feel free to ask any other questions. And I mean, the other thing is like, okay, I see. Gotcha. Okay, gotcha. Wow, you're new to trials. So yeah, I mean, I will say I will say that I've watched a fuck ton of trials, and I know I keep talking about how I need to compile a list. I've actually started to try to compile a list, and I'll read you guys what I have so far, but I only just started on it. Let's just see. I'm not. Like, this was just because I wanted to start it so I could save it, so I could remember I need to update it. But yeah, this is, okay, Derek Chauvin, Duffy Hurd, Scott Peterson, Daryl Brooks, Paltrow, Hannah Gutierrez-Reed, Alec Baldwin, Letitia Stock, Kowalski V.J. Hatch, Jennifer Crumbly, James Crumbly, Lori Daybell, Chad Daybell. I put Murdaugh, obviously, Karen Reed, and that's where I stopped and started doing something else, but there's way more. I don't even know how I would go through and remember it all. I'd have to probably go through like literally on like Court TV's archives and look at all their trials just to make sure I don't forget any. But anyway, but beyond that, I also have a whole stack of legal books here, and I've done a lot of studying. So like earlier, you may not have heard it, but earlier I was reading literally from the Federal Rules of Criminal Procedure and the Federal Rules of Evidence. So I have the book right here. And so you learn a lot from watching trials, but, you know, for me, I don't feel comfortable just like, you know, stating opinions as fact and whatnot, which is why I refer to the actual shit, right? I pull up the case law or the statute, or I go to my book here, you know, shit like that. So, you know, I'm not going to give you guys incorrect information. So yeah, I try to answer as many questions as you guys ask. Dude, you can ask about anything and I'll answer it if I know the answer, you know? Right. Dude, I said the same thing. I mean, I was like, they did not fucking read. He said there's just whatever happened to the old days when you bring your partner home after dinner and movie, light some candles, bring up Plato's Republic while in the throes of passion. Great one. Yeah, yeah. I don't know, man. It's just, well, especially the part that he was saying they would read during sex was like something that came from St. Augustine, which I assume was a saint. I don't know anything. I got it on my list to look up. So for next episode, I'm going to prepare a presentation on the whole St. Augustine thing. And I'm also going to do the thing where I zoom in on those journal entries and try to see if I can clarify them so we can actually read them in full context. So that's the other thing I'm going to do for the next one. Question, who offered that information? Oh, about the reading this shit while having sex? That came from Ezra's defense team, which I'm sure we'll hear it from Ezra's own mouth when she takes a stand. By the way, just to reiterate, okay, what made me decide, okay, I've really been wanting to cover this trial for so long, but I didn't, because the whole trial is not available on YouTube. I didn't think it was possible, or I would have done it earlier, right? I just kept thinking, God damn it, I wish this trial were, because on YouTube, it's just a handful of witnesses, right? And this was like a 3 or 4 week trial. So the state had over 50 witnesses, okay? And then the defense also presented a case in chief with an affirmative defense, and that doesn't always happen. So, you know, I always wanted to cover it, but I'm like, oh, God damn it, it's just not all there. You know, what am I going to do? But what I thought, initially I was thinking, is that I would do just a one-night episode of great cross-examinations, because one of my favorite cross-examinations of all time is attorney on the right, Mr. Dufour, cross-examining Ezra. It is sick. I mean sick in a good way. It is moving. It's moving. It's moving. I don't even know how it is fucking it is a miracle. It is so good. And then I was like, but God damn it, I just want to do the whole trial. But again, I was like, where is it? It took a lot of digging, and that's when I finally saw that Court TV has these Court TV archives. And I don't know why they don't have it on YouTube, but it's on their website. You have to go to their website. You have to go through their archives. And I'm wondering there might be other trials also that are like that, right? Like if there's other trials that we're all like, man, we want to see it, but like it's not on YouTube. Like now I know it might still be there. It might be in the Court TV archives, but it's not on YouTube for some reason. So, but when I saw that the whole trial was there, I was like, all right, let's do it. Let's do the whole thing. Cause like, you know, I know reading while in the throes of passion, talk about multitasking. I know. It just seems like there's just so many problems there, like logistically, you know. I guess if you have a lot of candles lit, like to Spencer's point, like you need like a plethora of candles lit just to make sure you can really see. Because what you don't want to do, right, is you don't want to misquote Plato's Republic, right? Or misread it, you know. Right. Have you guys heard of the prehistoric ground squirrel? I think there's also prehistoric ground sloth. So, okay, let me back this up just a second, because what they're about to get into something is really interesting. It's why I made the hipster business video. So
discussions with Alex about philosophy. That's
okay.
It.
So the deal is that this Court Fox guy, again, I still don't know if we end up hearing from him or not. He said what the prosecution is arguing is that the defense in their opening statements read out of context bits and pieces of Alex's writing, his philosophical writings, right? He was a philosophy major, and offered to the jury interpretations of what they mean. And therefore, the prosecution is arguing, they are entitled to bring in someone who was also a philosophy major and was good friends with Alex and had philosophical discussions with him that were relevant in time because they were in March of 2018 and can actually offer what Alex maybe meant by some of these philosophical musings, or as the defense calls them, ramblings. Okay, so let's see what happens.
They would sit at the joint and discuss philosophy for hours on end. And I will ask him I'm going to ask him overnight to read those 3 articles that in their entirety that counsel quoted a very short snippet of. And actually there are 4, I'm sorry, not 3.
But my recollection here today is that he asked Miss Cobes whether
that's Alex's mom. Hold on, back it up. So that's Alex's mom. Right there behind Mr. Dufour in the green sweater. That's Alex's mom.
Quotes were read by counsel during opening statement. And to give the impression that Alex acted in conformity with them, that Alex had that character trait. That's exactly how counsel portrayed them in opening statement, which I think is a misstatement of what their purpose was supposed to be. Yes. But counsel portrayed them in that fashion. Yes. And I think based on that, we're entitled to explain to the jury through Mr. Fox and potentially in rebuttal after the defendant testifies through Dr. Meyer, what those writings actually mean.
Okay. I'm pausing right here to say something. I don't think they even get into this facet of that, but here's what I'm going to say. For anyone who doesn't know, this could be a strategy because people sometimes aren't sure. I've heard the question asked, if you can object during opening statements or closing arguments. Now, you do see it in Debt Be Heard, but it is an anomaly. So it is allowed, but it's pretty rare, and there has to be usually really good reason to do it. It's generally among attorneys, especially in criminal trials, where there's like just a kind of like an agreement or an unwritten rule or an unspoken rule or whatever you want to say, where they're just not going to object, right, during closing arguments or opening statements. And however, perhaps this prosecutor knows this judge really well and knows that this will be okay, because the problem that could happen is that now when he's making which he's right, he's absolutely right about what the defense did. However, now that he's making this argument, you know, on day 2 of the trial, God, it feels like so much has happened. It feels like longer. It's wild to me. Wow. The judge could say, well, you didn't object at the time, right? Now, perhaps he knows that this judge doesn't encourage objections during opening statements, and that judge is not going to hold his feet to the fire saying you didn't object, too bad, so sad, right? Or, you know, maybe they have that unspoken agreement that they can't object, but nonetheless, he's making this point that this happened in opening statements, right? And again, the only issue that I could foresee is, well, you didn't do anything to stop it, but let's just see what happens here.
And Judge,
to give the jury the correct impression of what they are.
Judge, our position would be this. If they want to enter the journals, they can enter the journals. I read directly from the journals. We're not offering an interpretation.
Okay, hold on. What he says here is really important.
In opening statement, which I think is a misstatement of what their purpose was supposed to be, but counsel portrayed them in that fashion. And I think based on that, we're entitled to explain to the jury through Mr. Fox and potentially in rebuttal after the defendant testifies through Dr. Meyer, what those writings actually mean.
And Judge,
to give the jury the correct impression of what they are.
Judge, our position would be this. If they want to enter the journals, they can enter the journals. I read directly from the journals. We're not offering an interpretation of the journals other than Ms. McCandless's beliefs, which is relevant. A different party's interpretation of these journals is opinion evidence, which has not been disclosed, and it's irrelevant what they think those journals mean. Some other person's interpretation of it is not relevant in any way, shape, or form. And again, it's opinion evidence. If they want to put in the journals, we've conceded you can put in the journals and then they can argue about it in closing and we can argue about what they mean. But we don't get to call witnesses to say, what do you think this means? This isn't a literature class. We're not going to be discussing the meanings of these things other than Ms. McCandless's beliefs, because that's the only thing that's relevant. Third parties is not.
Well, the reasonableness of her beliefs obviously becomes an issue as well. So that's where I believe that, you know, somebody that can put some context into this, maybe it wouldn't. I'm not going to decide right at the moment here, but I believe that's why it would be, though, appropriate for there to be an opportunity to have someone who may be a philosophy student or a colleague or what have you, but that goes to the reasonableness of the beliefs. Perhaps Ms. McCandless, she saw it one way, somebody else maybe didn't. You know, she didn't have the opportunity to hear what Court Fox or this other person, you know, would say they meant and have a debate about it. But in any event, I was sort of anticipating that was become later in the trial.
I love it. He's foreseeing all the troubles.
So, but that Court Fox that's what you plan to get into some of that tomorrow.
Yes, Your Honor. And I mean, counsel in his opening statement, you know, read these things and said almost exactly that Alex that Alex was this person, that this is the type of person that Alex was. Counsel said he's a nihilist and described what a nihilist is, which I don't believe is actually an accurate description of what a nihilist is, but said that Alex is a nihilist, that he doesn't care about anything else. He'll do whatever the hell he wants. I probably added the profanity, but do whatever he wants whenever he does,
I love it.
Which isn't an accurate description of what a nihilist is. And I think we're entitled, because counsel put it in that fashion in his opening statement, which I believe, frankly, is incorrect, because the only purpose that they were allowed for is to show that the defendant knew about them and what's in the defendant's mind. But the defense argued in their opening statement, and his argument, we didn't object, we let it go.
There's the answer to my question. So he's going to say that they were the good guys and let it go.
But argument that that's what Alex was, and that's the type of person that Alex was. And I think we're entitled to respond to that. And that's exactly what we intend to do through Mr. Fox.
That's not what I said. I said, Ezra knew blah, blah, blah. Ezra.
So as I was listening to this, I was like, listen to them. Because they don't have transcripts, right? They're going off of their memory. So Mr. DeFore remembers that the defense described what a nihilist was and defined it, right? And then here, let's listen one, because I've got a plan here. Hold on. Let's just hear one last little bit of it.
About anything else. He'll do whatever the hell he wants. I probably added the profanity, but do whatever he wants whenever he does, which isn't an accurate description of what a nihilist is. And I think we're entitled, because counsel put it in that fashion in his opening statement, which I believe, frankly, is incorrect, because the only purpose that they were allowed for is to show that the defendant knew about them and what's in the defendant's mind. But the defense argued in their opening statement, and it was argument, we didn't object, we let it go, but argument that that's what Alex was, and that's the type of person that Alex was.
Yes.
And I think we're entitled to respond to that.
Right. So I'm like thinking to myself, that's what I remember. Okay. Then we hear from the defense.
And that's exactly what we intend to do through Mr. Fox.
That's not what I said. I said, Ezra knew blah, blah, blah. Ezra knew, and it was her knowledge, her mindset, her belief. I didn't say he was. It was all in the context of what Ezra knew. It's her mind.
I'll just say it was an opening argument and not necessarily just an opening statement, but nobody objected. But I
That's what I was saying. Oh, God, dude. I didn't even hear that part when I was editing this video. That's what I was saying. I was like, is the judge going to be like, wait, no one objected? There it is. There it is. Nobody objected. Okay. So there you go. Yep. I called that one, didn't I?
agree with the state that, there was, it was pretty much an argument about who Alex Woodworth
But nobody
was.
objected.
You can go back I was very particular. I printed out every word, Judge, and I understand it might have been perceived as an argument, but my statements were statements about what Ezra knew.
Okay. He said he printed it out. He was so imagine me listening. I'm like, I remember the way the prosecution remembers it, but he's like really emphatic, right? So guess what I did? I was like, oh, let's just go back and take a look, shall we? So now I know we watched this. We're going to watch Hipster Business again. Now, Hipster Business is going to start out with a little snippet talking about what the defense said in their opening statements about the whole arrest thing or the sexual assault with John Hanson. So we can hear, because again, that was another point of contention earlier from this same housekeeping. And then we're going to hear literally what he says about the journals, okay? Y'all ready? So we're going to find out who's telling the truth.
It's a house.
So the police are called. The police come over and they start talking to Jason like, what's going on? What are you so upset about? And Jason says, my girlfriend was sexually assaulted. The police asked to talk to Ezra.
I mean, I can say right now, just listening to that them talking about the sidebar, that's not what it sounds like. It sounds like it was some Josh guy that called the police. Anyway.
Ask Ezra if she wants to talk there in presence of Jason or down at the station. She doesn't want to talk about it in front of Jason. She leaves with the police officer, and eventually they agree a couple of days later to speak. She speaks with Detective Brown about this allegation that Jason made about a sexual assault. And over the summer and the early fall, her and Alex developed a relationship, a friendship, based upon these non-traditional ideas. He's accepting of Ezra's fluidity along the gender spectrum. He also has some odd ideas. He tells her right away about his journals, his fascination with violence, his captivation with...
So remember, the question that we're listening for is this. Is he simply saying what Ezra thought about the journals? Or is he actually reading these concepts and defining / arguing, right, about what they mean as to Alex's character as if it's a fact, right, versus what Ezra thinks.
Cannibalism. And she finds this kind of a yang to her yang.
It starts out
she
like
learns
this.
about
Okay.
some of his philosophies. Her boyfriend, her ex-boyfriend Alex, she knows him. She knows that he is a nihilist, and you'll hear about that. He believes life has no meaning.
There. He's wrong. He's wrong. Here, he is just offering things as this is not Ezra thinks this, or he told Ezra this. This is he believes. Dude, he's fucking wrong, man. There it is.
There are no consequences for one's moral actions.
Yeah. Dude, but they should have fucking
She's been
objected.
back in his apartment before.
They should have objected.
She's heard his ramblings on about Kierkegaard and fear and trembling. She's heard his ramblings before where he's read to her
from his journals. Read to her.
So this part. So the part that's the most relevant is the part where he says the thing about the being a nihilist, and then he goes on to state he believes blah 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 blah, and it states a couple different things. So that was me going back and being like, okay, let's just see who's right and who's wrong, right?
Well, now,
Before he responds to that. So Spencer, I saw this. Yes, the priest, right. Awesome. Yes, a dino squirrel Jurassic Park sounds freaking amazing. By the way, I also love dinosaurs, and my favorite dinosaur is a velociraptor.
that was, Ms. Vishney had asked, who do you expect? And Court Fox, continuing with Ms. Wisniewski, Max Martinson, David Stoiding, and Mr. Zachow.
Yes.
And what about?
I've got all those.
What about Ms. Wolder? These are the same people that were expected to testify today. So, in addition to those left over from, that we didn't get to today,
Next would be after Mr. Zachow, Matt Schreiner, Officer Susan Zwiefelhofer, Officer O'Neill,
She ends up going first.
Chester Davidson. And we have to do Olivia Earle tomorrow.
I'm sorry. I missed one of these names. Matt Schreiner, Officer O'Neill, Chester Davidson, Olivia what?
Olivia Earle,
Earl, and who else?
Susan Zwiefelhofer.
Susan Weaseled. Who is she?
I know who she is.
Okay. And what about, wasn't there the crime lab photo person who wasn't available or something? Are they coming tomorrow?
No, Miss Wobbler is not coming tomorrow.
Okay. So did I get every name? Schreiner, O'Neill, Davidson, Earl, Zwiefelhofer.
Yeah.
all right, any other issues council can alert the court to that might take some time tomorrow? Okay, very good. Then can I ask that council be here? I'd like to start at 8:20 for council. And then so we can start with the jury right at 8:30. Okay, all right then. Bob will continue. We're in recess for the evening.
There it is, guys. There you have it. Look at that cute squirrel. That's so cute. So, so nice. Oh, so nice. So, I am going to be working on the Debt Be Heard. I'm going to try to do it in a way. Okay, I have a plan. It's funny that Incredibly Average is literally the only channel that has, like, even just the Depot. I forgot that he was, like, I thought Court TV had that, but the Depot, like, that channel is the only one that has it. So anyway, I'm going to be working on editing those with the Australia call and the Depot. And I think actually I will have the next Ezra episode done tomorrow because I've been working on that. And I think I'm almost done. So we may even be able to do an Ezra tomorrow. If anyone didn't see it, I had a Murdaugh video come out earlier today. It's just real short, but it's just a couple updates there on what's going on with that case. Oh, right. And I did also pose the question too for anyone who's interested in and wants me to cover the Buster Murdaugh lawsuit. Let me know. Because I've forgotten to mention that, and I forgot to mention it in that video. So also coming up this upcoming week there's a Karen Reed hearing. Let me pull up. I saved this banner for a reason. Here, I saved this banner. Motions hearing, August 9th. Wait, is that this week? Yeah, 2 p.m. That's the motions hearing. So that's when they're going to hear the defense's motion to dismiss. I'm going to cover that, even though, because we've been taking a break from Karen Reed. It's been nice. I think that's really fucking important, though, because I covered the fuck out of that defense motion. So we're going to cover that hearing definitely. And then, trying to remember what else. I feel like there's something else happening this week. But anyway, is there an Idaho Brian Cover? I'll double check and make sure. But anyway, yeah. So, Squirrels of the World, you guys are awesome. Anyone who didn't watch the last couple episodes, there's the playlist. I'm sure you guys are well aware. And as always, thank you for your questions. Thank you for your comments. Thank you for being a squirrel. Thank you for being awesome. And I will see you guys on the next video. And hopefully, if I can finish it, which I'm thinking I will, then tomorrow for the next episode. See y'all then.